231-500-139, State of Utah versus Kouri Richins. Just for clarity, can I have counsel for the state make their appearance, please?
Good morning, Your Honor. Brad Bloodworth, Lindsay Shervanack, Joseph Hill, and Fred Burmester for the state.
And for the defense, please.
Wendy Lewis, Catherine Nestor, and Alexander Rumbles for Ms. Kouri Richins.
Okay. I appreciate everybody here in the gallery has exercised great patience this morning. We needed to discuss some legal issues related to the admissibility of evidence. Couldn't have had that discussion in the presence of the public in a way that would preserve the integrity of the process going forward. So I appreciate your patience. Mr. Bloodworth, before we get rolling this morning, I understand there's some housekeeping details we need to address.
Yes, Your Honor. The state would like to provide the court with something of an overview regarding how the state will present its preliminary case. The state has presented most of its evidence and arguments in paper in advance of today, notably including the transcript of the detention hearing, which the court has already admitted into evidence, along with 60 and 6 now other exhibits. We intend to be mindful in our presentation to not belabor well-established evidence. To that end, we ask that the court moves along when appropriate. The opposite, of course, holds true. If the court seeks additional information, if the court would let us know, we will present it.
Understood.
Speaking of our papers, back in May, the state had submitted a bench memo. I have two errata that I would like to put on the record. The first is on page 20 and 24, Your Honor. There's a date that refers to Friday, March the 5th, 2022. As a calendar will tell us all, that was Friday, March the 4th.
Okay, got it.
At page 10, in reference to a divorce consultation, the state wrote that occurred in January of 2022. The state asked that the court strike the date. The court will call some litigation related to this matter that occurred after the state filed that bench memo. That litigation revealed that date was not accurate.
Any others?
Those are the errata, Your Honor. The state will call in its presentation Detective Jeff O'Driscoll and experts Chris Kotrodemus and Brooke Carrington. The state has provided the defense with advance notice of those witnesses. When the state calls Detective O'Driscoll, the state will not conduct a direct exam. Instead, the state will refer the court to his testimony at the detention hearing. The state is essentially offering Detective O'Driscoll for cross-examination by current defense counsel within that scope as, in the best interest of a fundamentally fair proceeding, since they've not yet had an opportunity to cross-examine him. The state provided the defense with advance notice of this approach and reserves the opportunity to redirect Detective O'Driscoll. Finally, Your Honor, I'd like to, by stipulation, admit a few more documents. The first is what we have labeled as 7A. Exhibit 7 in the court's binder.
The cell bribe extraction report.
It does, Your Honor, and it's in there, and we refer to it in our papers because it has a screenshot of a navigation system. It is in 7A, but absent a telescope, the court's not going to be able to read it. So we have blown that up and labeled that 7A, if I may pass it up to the court.
Ms. Nestor, Ms. Lewis, any objection?
No, Your Honor.
Okay.
Your Honor, the other document we've labeled 67, and that is some notice for claim stage from true stage. They've been provided in discovery. They've been referenced. They just have not yet been admitted.
What's the number?
67, Your Honor.
What is 66? You referenced 66, but Understood, it's already in the plan, got it.
It is, Your Honor.
And 66 is exhibit, correct, Counsel? Stipulated, my apologies. Is 67 stipulated?
It is, Your Honor.
Okay, 67 and 7A are,
Your Honor, may I?
of course.
Thank you. Your Honor, the final two exhibits are docket references 123 and 124. I'm not sure how they got left out of some of the earlier discussion on this, but they did. So the statement was 123 and 124.
Any objection?
No objection.
Docket entries 123 and 124 are admitted for the purpose of today's preliminary hearing.
Your Honor, unless the court has anything to say, we'll call Detective O'Driscoll.
Ms. Lewis, Ms. Nestor, Mr. Ramos, anything housekeeping-wise?
No, Your Honor, nothing possible.
Okay. Detective, let's get you sworn.
Do you solemnly swear the testimony you're about to give in the matter before the court to be the truth, the whole truth, and nothing but the truth, subject to the pains and penalties of perjury?
Yes, I do.
Your Honor, the state tenders Detective O'Driscoll for cross-examination within the scope of the direct conducted at the detention.
Understood. Ms. Lewis?
Good morning, Detective.
Good morning.
We haven't met. I'm Wendy Lewis. I'm one of Ms. Richins' attorneys.
Thank you.
So, Detective O'Driscoll, when was it that you were first asked to take over this case?
In March of 2023.
And who was on this matter before you as the lead detective?
Detective Jamie Woody.
All right. And why was this matter turned over from Detective Woody to yourself?
Detective Woody moved divisions from the investigations division to the patrol division. She had an opportunity to have some auxiliary assignments that are only available in that division, specifically a K-9 handler position.
Okay. Did you ever become aware of any evidence or any issues with Detective Woody mishandling evidence in this case or other cases?
No.
All right. When you first took over this case in March of 23, what was it that you reviewed initially?
I was not able to review the entirety of the information that was available in the case, but specifically, most of the information that I received was from updates from investigators that had been working the case prior to me. I was able to review some of the supplemental reports that had been entered into our CAD file, but I don't recall the entirety of every document or piece of information that I reviewed.
Did you review all the police reports that had been written up to that point?
From our office?
Yes.
I don't believe so.
Did you review all of Detective Woody's reports?
I believe so, yes.
Okay. Now, who did you interview initially when you first took over this case?
The first interview I conducted, I believe, was with Ms. Richins.
All right. So that interview, well, I'm going to get back to that in a minute. Before we talk about the interview with Ms. Richins, did you, I'm going to go back to the early morning of March 4th, 2022.
Okay.
Did you review evidence about the investigation that was done that night?
Yes.
All right. And what investigation was done at the home that night? Or that early morning hours of March 4th, 2022?
Responding deputies conducted an initial interview with Ms. Richins. Detectives were then called out, and they conducted, I believe, a separate interview with Ms. Richins as well as other people that were then at the home by the time they arrived. And I believe they conducted a search of the home for any kind of evidence that may have helped them understand what had happened.
And what was seized from the home that night as potential evidence? Are you aware?
I don't know a complete list, no.
Are you aware if anyone was searching for any illegal drugs in the home that night? were any illegal drugs found in the home that night, that
I don't
early
believe
morning?
so.
So no fentanyl was found in the home.
Not that I'm aware of.
Were there any unidentified pills, light green pills, blue pills, dark green pills, anything like that found in the home the early morning of March 4th?
I don't believe so.
Were there prescription medications taken at that time?
I believe so, yes. Part of death investigation is to document and collect prescription medications for the scene.
Were there any?
Tell you specifically which ones, though.
Okay, sorry, I didn't mean to speak over you. Were there any non-prescription medications or illegal substances taken from the home that night of any kind that morning?
I don't believe so.
Eventually, or early on when you took over the case, were you able to review the medical examiner's report?
Yes.
And what was your understanding of what caused Mr. Richins' death based on that report?
The medical examiner's report identified that the cause of death was drug intoxication with a specific drug being fentanyl.
All right. But nothing was found or seized the early morning of March 4th that included fentanyl. Is that correct?
No fentanyl was seized that I'm aware of, no.
All right. Was there any glassware seized in that initial search?
I don't know.
You don't know if there was glassware seized, such as copper mugs or shot glasses? You're not aware?
I know with review of supplemental reports I could find that information, but right now I don't know if during the first search on the morning after Eric Richins' death, if those were collected or not.
Were they collected at some other time?
Yes, I believe some copper cups were collected from the home subject to a search warrant.
All right. When was that search warrant that was executed on the Richins home? You said after.
There were multiple that were executed. The first one after Eric Richins' death, I believe, was in April of that same year, mid to late April. I don't remember an exact date.
Was this after the medical examiner's report had been reviewed?
Yes.
Were you present for that?
No.
But you reviewed reports regarding that search?
Yes.
Was there any Oxycontin found in that search?
I know during one of the searches that there were some prescription opiates that were not in a prescription container that were found in the home. I don't know if they were specifically Oxycontin.
Were they fentanyl?
No.
Were they tested at some point in the course of this investigation?
I don't know. I could review supplemental reports and get that information, but I don't.
Okay, but you don't know. All right. Were there any illegal drugs or drugs that weren't prescribed that were seized in that April of 22 search?
I don't believe so.
Did there come a time that some THC gummies were seized?
Yes.
And do you know when that was?
I would have to check dates on the receipts of those items and evidence. It could have been during that first search in April, or it could have been on a subsequent search. I'm not sure.
Oh, so there may have been illegal substances or THC, which is an illegal substance, found in that search.
I believe THC was found in the home during one of the search warrants executed on the home.
All right. And were they in the form of gummies or some other form, the THC?
They were edibles.
Edibles. So were the edibles, were you made aware, or are you aware of who the edibles belonged to?
We received statements that they belonged to Eric, to the decedent.
Were those edibles tested?
Yes.
And did you review a report regarding those edibles?
Yes.
And did that report, that initial report, say that there were traces of fentanyl in those edibles?
No.
You did not review a report that said there was fentanyl in the edibles?
No.
All right. So as you were investigating this case, well, strike that. I'll come back to that. So you talked about that your first interview in this case was with Kouri Richins. What was the date of that interview?
I believe it was April 14th of 2023.
So this was about 13 months after Mr. Richins' death.
Correct.
So you said before that conversation with Ms. Richins, and where did that conversation take place? I'm sorry.
At her home at 282 West Willow Court in Francis.
All right. And you had reviewed a number of reports prior to that interview.
Several, yes.
So you had an idea of the investigation that Detective Woody had already done on this matter.
I had a partial understanding of the investigation that she conducted.
Who was with you when you did that interview? Were you alone, or was there another officer with you?
No, Sergeant Hoffmeyer was with me as well.
Sergeant Hoffman. Had you discussed this matter with him prior to this interview?
I just requested that he accompany me because we had both newly been put into the investigations division and would both be fairly involved with the case.
All right. Had you read correspondence prior to this interview with Ms. Richins, from Ms. Richins' prior counsel to the Summit County Sheriff's Office?
No.
So you hadn't read any correspondence where Ms. Richins' counsel asked that she not be interviewed with counsel present? You hadn't read those yet?
No, I had not.
Now, taking over as lead investigator, didn't you know that she was represented by counsel?
No, I did not.
During the interview with Ms. Richins, did you become aware she was represented by counsel?
Partway through the interview, it became apparent, yes.
But you didn't ask her at any time during the interview if she wanted counsel present, correct?
I did. I told her partway through the interview, her mother, Lisa Darden, came to the home, and she made a statement about whether or not Kouri should talk to us without. She said the word Sky, the name Sky. I assumed that that was an attorney that she had contacted, and at that time I told her, if you would rather have an attorney present here while we talk, that's fine. And she declined.
Let me show you just a portion of that interview. Colleen, if you could give me that. Page 215. Can we show this on the screen to the witness? Thank you. If I could direct you, Detective, to the very bottom of that page as your statement at the bottom of that page. If you could just review that, not read it out loud, but if you could review that. Now, that statement was made as you were leaving the house, correct?
It appears so, yes.
And do you recall that statement that you made to Ms. Richins as you were leaving the house?
Yes.
And what was it you told her then?
I'm sorry, I don't understand the question.
What was it you told her as you were leaving the house, reflected in that statement?
In this statement?
Yes.
That she could have an attorney present while we talk. I'm guessing that's what you're getting at.
Well, but you'd finished talking for that day, correct?
I believe so.
This was, in fact, the very end of the transcript as you were walking out of the house, correct?
It looks like it.
And you told her if she wanted an attorney at future interviews, that would be fine.
Yes.
All right. Does that... We'll strike that. Isn't it true, Detective, that that is the only time that you told Ms. Richins that she could have an attorney present when being interviewed, if she wished to?
I recall making that statement midway through the conversation. If it's not in the recording, then I didn't.
All right.
But I do remember making a statement that we were happy to have an attorney present while I spoke to her.
At least as you were leaving.
Yes.
All right. So let's talk about some of the investigation and interviews you did prior to Ms. Richins' arrest. As part of your investigation, is it true, isn't it true, that you looked into Kouri's relationship with a Mr., I believe it's Grossman?
Yes, some other investigators, I wasn't directly involved with contacting Mr. Grossman, but yes.
And that is someone that you have referred to, or I don't know if you personally, but has been referred to in transcripts as Ms. Richins' paramour, correct?
Correct.
And you reviewed texts between Ms. Richins and this individual, isn't that correct?
Correct.
Did you also investigate the texts between Eric Richins and the women that he'd been having affairs with during that period of time?
I didn't personally, I don't know that any of our investigators did.
Have you ever reviewed any texts or calls between Eric Richins and women that he was having affairs with prior to his death?
Objection, Your Honor, that assumes facts, not evidence, and it's also beyond the scope of the testimony at the detention hearing.
So the first part of that objection is overruled. The second part, though, I'm not sure how this has an impact on the probable cause determination the court will need to make.
Well, Your Honor, I believe that the fact that nobody was investigated other than Ms. Richins is relevant. And this would be a potential alternative suspect that there was
Certainly
no
at
investigation.
Trial, Ms. Lewis, I understand, but preliminary hearings are not supposed to be a discovery tool. The irrelevance objection is sustained.
All right. So, Detective, are you familiar with someone by the name of Carmen, I believe it's Lauber, is that how it's pronounced?
Yes.
And how are you familiar with her?
She became a person of interest in this case at one point when detectives started investigating associations and contacts of both Kouri and Eric Richins. Investigators from our office were familiar with her background in having a criminal drug history, and she became the target of a separate investigation as she related to Ms. Richins.
Could you maybe just explain that for me a little more? How was she a target related to the Richins case?
Text messages were located in the defendant's phone from a phone number that was found to belong to Carmen Lauber.
All right.
At that time, detectives started looking into Carmen Lauber and her activity. They found that she was on a drug court program in another county and started investigating her as related to Ms. Richins, having worked with her and having cleaned houses for both her business, her realty business, as well as her personal home.
So just to clarify, Ms. Lauber did cleaning for Ms. Richins' business and in the Richins' household. Did I have that straight?
Correct.
All right. And did you execute a search warrant, or was a search warrant executed on Ms. Lauber's home?
Yes.
Were you present for that?
Yes.
And were there illegal items seized during that time?
Yes.
Was she arrested at that time?
Yes.
All right. Do you recall when that was?
I believe it was towards the end of April 2023.
All right,
I
so-
don't know an exact date.
So after Ms. Lauber's arrest, did you interview her?
Yes.
How many times have you interviewed her since April of 2023? You or others associated with this investigation, if I clarified.
I believe 4 official planned interviews.
What about unplanned, unofficial interviews?
I've spoken with her, but not in an interview setting, since that's what I'm getting at. Interviewing her in connection with this case, there were 4 that I'm aware of.
Do you know how many hours you've spent interviewing her or others associated with this case?
I believe at the detention hearing, I testified it was around 10. I believe that's accurate.
All right. So when did you initially interview Ms. Lauber?
It would have been I believe, April 26th, shortly after her arrest, maybe the day or two after her arrest.
All right. And during that initial interview, can you tell me what took place during that interview?
We spoke to Ms. Lauber about the items that were found in her home subject to the search warrant. We told her that the charges that she was facing, that she was on drug court probation for in the outside county, could continue to be charged against her due to a violation of her drug court. We told her that she was facing felony distribution charges in that case.
Can I interrupt for 1 second? Distribution of what?
Controlled substance.
What did you seize from her home?
So the charges that she was facing in relation to her drug court were separate from the ones that resulted from the search warrant. But we found illicit THC products as well as a firearm in her home.
And why was the firearm of significance?
It was a violation of her drug court probation to be in possession of a firearm.
Well, she was a convicted felon, isn't that right?
Yes, that's also pertinent.
All right. So she was also potentially looking at charges of felon in possession of a firearm, correct?
Correct.
And you told her that in the first interview?
Correct.
Did you tell her that those would be state or federal charges?
I believe we told her that they could be both.
They could be both, or either.
Either, right.
Did you tell her potentially how much time she could be looking at in prison if she was charged and convicted of these additional offenses?
I don't recall saying a specific number of days, but I know we made mention that there was significant jail time attached to those charges.
Significant prison time.
Prison time.
All right, so what did she tell you in that first interview about her associations with Kouri Richins?
She confirmed that she had worked for Kouri in the past. She told us that she knew Kouri through Kouri's aunt Doreen, whom Carmen worked for, cleaning houses. She initially stated that she didn't know anything about what had happened with Eric's death or anything about fentanyl. And we explained to her that the position that we were in to try to investigate anything that might have happened, whether that was inculpatory or exculpatory for anyone, and that any information that she might have about it would be helpful to us.
All right, well, if we could just break that down just a little bit. What did she tell you about ever dealing fentanyl at that time?
She said that she hadn't really ever, in her words, messed with fentanyl. Then she later admitted she had tried it once and didn't have a good experience with it.
Did she tell you a daughter had overdosed on fentanyl?
I don't recall. I could review the video and give you an answer on that, but I don't recall.
And isn't it true she told you she never dealt in fentanyl, that she dealt in pain pills and marijuana and other things of that sort?
In the first interview, yes.
And what did you tell her you could do for her if she gave you information about Eric Richins' death or anything that could help you in the investigation of Eric Richins' death?
We explained to her that if she had information regarding Eric Richins' death, that we could work with the prosecutor who was responsible for her charges, for both the search warrant and the drug court charges. We didn't make her any specific promises, but we told her that we were willing to work with the prosecutor's office on those charges.
Is Ms. Lauber in custody at this time? Is she in jail?
No.
All right, was she ever charged with anything that was to do with dealing drugs, a violation of her drug court, or with anything that was seized during that search?
I don't know. I don't believe so. I had no dealings with the inner workings of that county's prosecutor's office after we interviewed Ms. Lauber. after we interviewed Ms. Lauber, we informed the prosecutor's office that she was being cooperative with our investigation, and then they and her attorneys worked out whatever kind of deal they worked out with her.
Well, isn't it true, Detective, that you went back and spoke with Ms. Lauber and guaranteed her that she would not be charged in any way as connected to Eric Richins' death if she continued to cooperate?
I didn't make that statement in those words, but we impressed upon her that, yes, in exchange for helpful information in this case, that she could potentially have reduced or eliminated charges.
Well, I'm going to jump ahead a little bit because I know you had a number of interviews with her, and I've certainly reviewed at least 6, because those interviews were recorded, correct?
Correct.
And any interview that you have had with her would be turned over to defense counsel, correct?
Correct.
All right.
So we turn it over to the state, and I believe it's their
All right.
opportunity to turn it over to the defense.
So if I represented that they've turned over at this time 6 interviews with yourself and Ms. Lauber, or with, who was the other detective, I'm sorry, that was with you during those interviews?
Detective Maynard.
Detective Maynard. That they've turned over 6 at this time. Would that sound correct to you?
Yes.
All right. So I want to go to the 6th interview, which was May 13th of 2023. Does that sound right?
Yes.
So isn't it true at that interview you told her that she was going to be testifying in front of a federal grand jury?
I don't recall that.
Yarka,
Am I in the video that you're referencing?
yes, you are.
Okay. I don't recall that.
So you don't recall that you told her that you and Detective Maynard had had discussions with the U.S. Attorney's Office, and that they had guaranteed you that she would not be charged in connection with Eric's death so long as she testified in front of the grand jury?
I don't remember it, but it doesn't sound unreasonable.
You're the lead detective, right?
Yes.
All right. Did Ms. Lauber testify in front of the federal grand jury regarding this case?
I don't believe so.
You don't believe so. Do you know? Yes or no?
I don't know for a fact.
You don't know. Did you testify in front of a federal grand jury regarding this matter?
No.
Do you know of anyone in your investigation that testified before a federal grand jury?
No.
But you do recall telling her that she would be testifying before a federal grand jury the next week.
I honestly don't remember it. I'm not surprised by the information because when we were working with prosecutors' offices at the time, there were both federal prosecutors and state prosecutors that were involved in it. And that sounds like a likely discussion that could have been made that she would need to testify before a grand jury.
The next week.
Like I said, I don't remember those. If I review the video, I probably could speak to it more.
Did you review an interview that Detective Maynard did with Carmen Lauber on the day before that, May 12th, regarding a Zoom meeting he had had with different agencies, in this case, federal and state?
I believe so.
And do you recall in that he explained to her what she would be doing in terms of testifying in front of a grand jury?
Again, I don't recall the discussion about the grand jury. If I review the video, I could speak to it more, but I just don't recall it from my memory.
All right, do you
I
recall?
don't believe that video is one that I have recently reviewed. I reviewed the initial 3 or 4 that we had with Carmen prior to this hearing.
All right, we'll go back to those in just a minute. Let me ask if you recall this. Do you recall telling her on May 13th that she would be testifying in front of the grand jury and that the goal would be to convict Kouri Richins of murder? Do you recall that?
No, I do not.
All right. Ms. Lauber got a letter of immunity from the United States Attorney's Office for the District of Utah, did she not?
I believe so, yes.
But you don't know if she testified in front of a grand jury.
I do not.
All right. So tell me the first interview, I'm gonna go back now to that initial interview in April of 2020, or April 27th of 2023.
Okay.
How did that interview end?
Can you tell me the date again? April 27th, the first time we.
Yes, the
spoke
very
to her.
first time you interviewed her.
We told her that she probably had some things to think on and consider, and that if she decided she wanted to talk to us about this case, that she could contact us, or that we would be in contact with her again shortly.
Yes. So did you tell her you'd be back in a few days after she had some time to think about what had happened?
Yes.
All right. And did you go back in a few days?
Yes.
Do you recall the date that you went back?
I believe it was the following Tuesday.
So if I told you that was May 2nd, 2023, would you have any reason
Sounds
to?
accurate, yes.
I'm sorry, I don't mean to talk over each other. Go ahead.
That sounds accurate, yes.
All right. So the second interview. What did you tell Ms. Lauber in that interview?
We told her a lot of things. Do you want to talk about something specific?
All right. Did you ask her if she'd had time to reconsider her relationship or her activities with Ms. Richins?
I believe so. When we first sat down and she entered the interview room, she immediately started telling us that she had been thinking about calling us and wanted to talk to us.
All right. And you reminded her that she was looking at serious charges, and you guys would have her back. You would help her if she cooperated.
Yes.
Had you seized a phone, a phone from Ms. Lauber at that time?
Yes.
Was there more than one, or did you just seize one phone?
There was more than one. There were two, I believe, that we relied on for evidence and content. There were multiple old phones, I believe, that were seized from her home, but the two that we downloaded and were subject to our investigation, there were two.
Were either of those phones, were either of those phones ones that she was using in March of 2022?
I believe so, yes.
I think one of them was. All right. So what did she tell you in that second interview about communications between herself and Ms. Richins that she thought might be helpful to you? Sorry, I'm going to grab a drink.
In most, if not all, of the interviews that we had with Carmen, her memory went back and forth on what happened, what didn't happen, and which times those things happened.
All right.
So chronologically, it's hard to say where we went in the interview. But she began very slowly, and it appeared to us that she was minimizing her involvement, but said that she had participated in some way in getting Kouri illicit substances. And like I said, it began small and her minimizing her involvement and developed into more specific statements.
And these statements took place over the course of 3 or 4 additional interviews.
Correct.
Your Honor, the state objects on relevant grounds. As the court's aware, Ms. Lauber submitted testimony by 1102 witness statement. And the standard for the preliminary hearing is notwithstanding credible testimony to the contrary. The court's also well aware that Article 1, Section 12 of our Constitution and progeny case law says that discovery is not a proper purpose for this hearing.
Well,
Help me out where we headed here.
Well, Your Honor, Mr. Bloodworth had stated as we were at the beginning of the hearing that in large part he was putting Detective O'Driscoll on in the interest of fairness and justice because Ms. Richins' current counsel had never had the opportunity to cross-examine him on his prior testimony, and he testified in his prior testimony about these things. So my understanding was that this was our opportunity, since we haven't had one before, this is what was agreed upon and represented to the court, to cross-examine him about that prior testimony, even though this is the preliminary hearing. And these facts very much go to probable cause.
It's the last part that I'm not following you on. How do these go to probable cause? I don't think I haven't heard anything that sounds like testimony that Carmen Lauber did not have the opportunity to perceive or know the things that she claims to have perceived or known. I don't get to weigh credibility outside of those extraordinary circumstances at a preliminary hearing. I'm trying to give you as much latitude as the state will agree to. I'm staying out of the way, but at some point the limits on the probable cause determination kick in.
All right, well, based on the earlier discussion with the court, I'd like to go a little farther in terms of reviewing his testimony from the prior hearing.
Understood. If you need clarification of it, but if we, I imagine, don't hold me to this, but I imagine that if we keep reviewing the investigative steps and potential sources of bias on Ms. Lauber, you're going to continue drawing objections regarding relevance.
I understand. All right.
We'll give Ms. Lewis some additional limited latitude here, Mr. Bloodworth. Let's see where we go.
So when you testified before, did you testify as to how many times Ms. Lauber had allegedly provided drugs to Ms. Richins?
I believe so, yes.
And how many times did you say that that happened?
At that time of testimony, we understood there to be 3 transactions that Ms. Lauber participated in with Ms. Richins.
And what were the dates of those 3 transactions?
February 11th, February 26th, and March 9th of
Mar-
2022.
March 9th, after Mr. Richins had passed away.
Correct.
All right. And did you testify at the prior hearing, or do you recall what Ms. Lauber said she provided to Ms. Richins, what sort of drugs she provided to Ms. Richins on those 3 occasions?
Again, it went back and forth with details and was clarified the more information she was presented with from phones and other physical evidence. The determination we came to after the conclusion of all 4 interviews was that she had procured some type of prescription or non-prescription opiate on the first transaction, and that the following 2 were fentanyl pills, counterfeit fentanyl pills.
And so you said that in the first interview, she told you that she didn't deal in fentanyl. Can you just explain what you did in your investigation to try and confirm? How did you come back around to that it was fentanyl?
So in the initial interview with Ms. Lauber, and the statements she made about not having dealt in fentanyl before, in my opinion, my experience with interviewing people, especially in custody, I think she was minimizing her involvement. I think she was trying to cover herself from any type of further legal problems. And then after we came back the second time, I think she had changed her mind about how much information she wanted to reveal to us. And that's when she started talking to us about the fentanyl pills, and that she recalled specifically that they were fentanyl.
And did you interview other people regarding those transactions?
Investigators from the Summit County Sheriff's Office did, yes. I wasn't involved in every single interview, but yes.
Did she tell you how many pills total that she provided to Ms. Richins, or that she recalled providing?
One moment, please. Mr. Lynn.
Your Honor, the state renews its relevance and objection. What's going on here is the defense counsel is asking questions about the detention hearing, which the defense counsel has a transcript of. Did she tell you this? Well, we know this because he testified to it.
Let's just assume that this question, which goes directly to the probable cause determination, is foundation for whatever's coming next.
Thank you.
So I'm going to allow this.
I appreciate it, Your Honor. All these recordings are, all these interviews are recorded in discovery and can be identified.
I understand. Your objection to the extent it's to relevance is overruled. Ms. Lewis, please proceed.
did she tell you a number of pills, the number of pills she provided to Ms. Richins?
Are you meaning in total or per transaction?
Either way, whatever is easiest for you to explain.
She made an estimate of approximately 15 to 30 pills per transaction.
All right. So a total of
Maximum
75,
90,
30 to 90,
30 to 90.
45 to 90 pills. All right. Did you have any of those pills ever been found?
No.
None in the Richins' home,
No.
correct? None in Ms. Richins' car, correct?
No.
So you've never had the opportunity to test any pills that were allegedly provided from Ms. Lauber to Ms. Richins, is that correct?
Correct.
Not one, correct?
Correct.
So the only knowledge you have as to what those pills were came from Ms. Lauber, correct?
And corroborating witnesses.
Corroborating witnesses that,
That supplied Ms. Lauber with the pills or put her in contact with the person that supplied her the pills.
all right,
Or drove her to the transactions where the pills were purchased.
okay. Again, though, have you tested any of those pills or found any of those pills so they could be tested?
No, we have not.
So you actually do not have any idea what the pills were that were given to Ms. Richins, correct?
Just based on the testimony, witness statements by Ms. Lauber and others.
But you don't know.
I don't know.
So you don't know if the pills were OxyContin, correct?
No, I do not.
You don't know if the pills were fentanyl, correct?
Based on what Ms. Lauber told us, she was sure that they were fentanyl. And her description of them match what I know currently to be Drug Trends street illicit fentanyl pills, with the description being a light green to blue round pill.
So let me ask you again. Do you know if any of those pills contain fentanyl?
No, I do not.
Do you know if these pills contained illegal drugs, opioids of any kind?
I do not.
When is the last time you sought evidence in this case?
Sought evidence, is that what you said?
Yes.
The case is active and ongoing until trial. I presume any new information that comes to us will continue to be considered as evidence.
Are you still interviewing witnesses?
Not at this moment, no.
I know you're not at this moment. You're here testifying. Have you recently interviewed witnesses or others investigating this case or involved in this case been interviewing witnesses?
Yes. Some of our team have reached out to witnesses that we've talked to in the past and have kept in contact with them.
Have you been provided statements or interviews by a private investigator in this matter?
They've been entered into systems that I have access to, yes. Not personally been provided with them, but yes.
Who does that private investigator work for?
The Richins family, the Eugene Richins family.
Is that who pays this private investigator to provide information to you?
I assume so.
All right. When was the last time you executed a search warrant in this case?
I believe it was 1 or 2 weeks ago on the Richins home.
Still looking for the pills?
That was to seize a voice recorder that was located in the home.
All right. Just give me one moment. You just back up for one moment about the pills. So you said you interviewed other people. I think it was one other person who provided allegedly the fentanyl to Ms. Lauber. Is that correct?
There were two individuals that we interviewed that were reported to have provided Ms. Lauer with the pills, with one with the non-fentanyl opiates and then with the fentanyl pills.
Okay, so one provided the one that did not have fentanyl, and one provided the ones that she claimed did have fentanyl.
Correct.
Okay, so that individual, or actually either of those individuals, were they manufacturers of those pills?
I don't know. I don't believe so.
Well, one of them told you it was her prescription, correct?
I believe Ms. Lauer told us that. Would you like me to use names?
That's fine.
I believe Ms. Lauer told us that Ms. Kohler, who she claimed she got the non-fentanyl pills from, that they were somebody's personal prescription.
Okay. So we don't actually know where those pills came from either.
No.
All right. And the individual who provided fentanyl, he was not the manufacturer of fentanyl. He told you he didn't manufacture fentanyl, correct?
I believe so. Other detectives in our office, yeah, interviewed him.
All right. Do you know what red devils are?
No, I do not.
Did you record all of your conversations with Ms. Blobber, or if someone else was interviewing with them, were they all recorded?
Interviews, yes.
All right.
We've yes.
Besides Kouri Richins, did you interview or investigate into any other possible suspects in this case?
Interview, no. I personally try to keep an open mind as to all possibilities of what could have caused Eric Richins' death. But I didn't conduct interviews with any other suspects that were persons of interest labeled as suspects.
You didn't collect phones or look at anything else from any other suspects, correct?
We collected several phones from involved individuals in this case, and potentially people that could have had access to the Richins home at different times, that could give alternate explanations of how the fentanyl got in the system. But I didn't conduct any interviews of individuals regarding their involvement.
All right. One quick moment. Nothing for your honor.
Mr. Bloodworth, a brief scheduling question. Roughly how much time do you have on redirect?
Less than 10 minutes, Your Honor.
Okay, please proceed. Wayne, can we get some more water for the witnesses?
Thank you, sir.
Your Honor, I've marked the State's Exhibit 68, Utah Bureau of Forensic Services forensic analysis report related to the collection of THC gummies. May I approach?
Of course. Ms. Liz.
I just can't hear Mr. Bloodworth.
Okay.
So
I'm
didn't-
sorry.
Get a
I-
little closer to that mic.
I'm hoarse from our
So am I.
evidentiary
Obviously.
argument this morning.
Oh, yeah, well,
Sorry.
I'll try to talk into the microphone, Your Honor. Detective O'Driscoll, do you recognize what's been marked as State's Exhibit for Identification 68?
Yes.
You testified earlier regarding toxicology on some THC gummies. Do you recall that?
Yes.
Does that toxicology report reference the THC gummies that you were testifying to?
It appears to, yes.
And then are you familiar with the difference in toxicology reports between fentanyl being indicated and fentanyl being found?
Yes, I'm remembering discussions with our evidence technicians, our forensic technicians, and that there's a difference there that I didn't know before.
Okay. I mean, and what was the bottom line of that discussion with the evidence technician?
The bottom line was that something could be tested and indicate for precursors or some chemical structure that I don't fully understand that could indicate possibilities of fentanyl, but the state crime lab won't say for certain that fentanyl is present.
And in that instance, the reports read as that one does, am I right? Fentanyl indicated, not identified.
Correct. It says fentanyl was indicated in the gummies in the plastic bag.
May I read this? Your Honor, the statement states 68 into evidence.
Ms. Lewis, any objection?
no objections under the same considerations of all the exhibits in this
It'll
hearing.
be admitted for the purpose of the preliminary hearing only.
Yes, Your Honor. And this, Your Honor, the state directs the court to item 14, which begins on the bottom of page 2 and continues to the top of page 3.
Thank you.
Detective O'Driscoll, you testified on cross-examination regarding interviews with Carmen Lauber. You remember that?
Yes.
Are all those interviews either audio recorded, video recorded, audio recorded or audio and video recorded?
Yes.
And to the extent your testimony recollecting back over a year would differ from the recordings, do you think the recording's the accurate testimony?
I do. I sympathize with Ms. Lauder at this point, having been a year past the last time we talked about this.
Sure. Did you have an opportunity to watch a video recording of an assistant U.S. attorney and some federal investigators interviewing Ms. Lauber?
I didn't view it, but I was told about it.
Okay. Were you told that they were interviewing her kind of pursuant to a grand jury subpoena and before the grand jury testimony?
Yes, I'm remembering now that their appearance there, their interview of her was in regard to a grand jury subpoena that at the time we were not aware that they were planning.
Regarding Ms. Lauber's testimony, Ms. Lauber's interview with you and Detective Maynard, I want to perhaps clarify some of the transactions. Is it right to say that Ms. Lauber testified to one transaction with Susan Kohler involving Roxy's,
Yes.
and then a transaction involving fentanyl on February the 11th, a second fentanyl on February the 26th, and a third on March 9th.
Yes.
Regarding the fentanyl portions of the conversation, separate than the Roxy portions of the conversation, did detectives from Summit County talk with the intermediary between Carmen Lauber and the ultimate fentanyl dealer to Ms. Lauber?
Yes.
And did that intermediary say that Ms. Lauber requested fentanyl?
Yes.
Did Summit County detectives talk with the man who distributed the fentanyl to Ms. Lauber?
Yes.
And did he say that she requested fentanyl?
Yes.
And that he ultimately provided fentanyl?
Yes.
Thank you, Your Honor. Nothing further.
Just 3 or 4 questions.
Within the scope of read, Brett, please.
Yes, understood. You said that all interviews with Ms. Lauber were recorded, correct?
For sure, all the ones that I was involved in, yes.
All right. So does that mean that there have been meetings and discussions with her, with Ms. Lauber and either yourself or other people at the Summit County Sheriff's Office or the prosecution not recorded?
Not that were substantive in content in regards to the case. We have on occasion spoken with Ms. Lauber because she was placed on supervised probation by an out-of-county court and was to be under ankle monitor that was supervised by our department. So we have talked to her about compliance with those orders. We have also transported her, given her a ride to meetings with her attorney, and so there has been small talk, but not interview about the case that has not been recorded.
Okay. You drive her to her meetings?
She needs a ride sometimes.
All right. So you just, in discussing this with, in answering Mr. Bloodworth's questions, you said that Ms. Lauber provided fentanyl to Ms. Richins 3 times.
I know that Ms. Lauber had difficulty remembering all the details of her interactions with Ms. Richins. I know at the time that we conducted the interviews, what she had told us in those interviews is what I testified to at the detention hearing.
And that was that there was 1 time that was OxyContin and 2 times that she said she delivered fentanyl. Isn't that right?
Correct. Since those interviews, new forensic information from cell phones was received, was reviewed, and determined that there were 3 transactions involving fentanyl, including one after Eric Richins' death. I believe the most accurate statement from Ms. Lauber is the 1102 statement that she submitted for today's hearing.
All right. You said that you spoke with the individual who allegedly provided fentanyl to Ms. Lauber, and you just testified that he told you she asked specifically for fentanyl. That's not accurate, though. Correct?
He told, from what I'm remembering from watching the video of the other investigators that interviewed him, he told us that Ms. Lauber requested, in his words, blues, which I understand to be fentanyl pills.
Didn't he say she requested Roxy 30s? Or Roxy's?
It's possible. I think blues was also mentioned.
Roxy's are typically OxyContin, correct?
Yes.
All right. So as you're sitting here today, Detective, can you say with certainty that the pills that Ms. Lauber allegedly gave to Ms. Richins were the pills that were taken by Eric Richins, or were pills that were taken, if any pills were taken, by Eric Richins?
No.
And as you sit here right now, do you have any idea, like actual knowledge, not an idea, let me rephrase that, do you have any knowledge of how fentanyl got into Mr. Richins' system? Mr. Richins' system. I'm sorry,
No.
I have nothing further.
Anything further for the detective, Mr. Bloodworth?
No, Your Honor.
You can step down, sir. Thank you. Mr. Bloodworth, it's now an appropriate time to take a lunch break.
Yes, Your Honor.
Ms. Lewis, any objection?
No, Your Honor.
All right. Come back at 1:30. Does that sound workable? 9. Mr. Bloodworth, anything before we continue with the state's case?
No, Your Honor.
Ms. Lewis, Ms. Nestor?
No, nothing else right now.
Okay. The state's next witness, please.
Your Honor, the state calls Christopher Kouri Richins.
We have Brady swearing in, sir.
Do you solemnly swear the testimony you're about to give in the matter before the court to be the truth, the whole truth, and nothing but the truth, subject to the fees and penalties of perjury?
Yes, sir. Please proceed.
Thank you. Sir, could you please tell us your name?
Chris Kouri.
Is that a common spelling of the last name?
Yes.
Thank you. Mr. Kouri, what can you briefly tell us your background?
Yes, I'm a 23-year law enforcement veteran. The last 11 years of which was spent with the Salt Lake City Police Department Homicide Squad and the Salt Lake County District Attorney's Office Homicide Team, where I was an investigator there.
And did you retire from law enforcement?
I did at the end of 2022. I retired.
What have you been doing since then?
I started an investigations firm.
And what's the nature of the investigations that you do?
So we do investigations, training, and consulting work. So regular investigations for criminal and civil offenses, training for attorneys and investigators related to various subject matters. And then I also do some consulting work in criminal and civil cases as well.
Do you have any education, training, or experience with forensic digital evidence?
I do.
Can you briefly describe that for the court?
Yeah, so formal training. I have a 40-hour certification from the ZX Trax. It's a 40-hour training course, call detail record analysis and location mapping. I also have a 40-hour formal training, also with ZX Trax, as a subject matter expert. I'm a Cellbrite certified operator and a Cellbrite physical analyzer certified as well.
Judge, may I ask if Mr. Kouri could put the mic closer to him?
Thank you. And since you've talked about that, what is Cellbrite?
So Cellbrite is it's extraction, it's device extraction, hardware and software.
Okay.
It extracts data from electronic devices.
I see. Have you been retained by the state in this case?
I have.
In what role?
As an investigative consultant and to analyze digital forensics data.
And have you analyzed and reviewed digital extractions of cell phones in this case?
Yes, I have.
I want to talk to you about a few phone numbers and just to identify phone numbers of different cell numbers or cell phones you have analyzed in this case. Do you recognize the phone number 435-671-1987?
I do.
Whose phone number is or was that?
That was the primary cell phone for the defendant.
Okay. You're getting kind of quiet again. Can you pull that
Sorry.
microphone a little
It's
bit closer?
and the phone. There you go.
Normally that's not an issue.
There we go. Thank you. Could you just repeat that answer, please?
Yeah, that's the primary phone number for the defendant.
When you say primary, does that mean that there were other phone numbers that the defendant used?
Yes.
And do you recall what those numbers were?
Yes, there's two other numbers that we're aware of. One ends in 1152, and the other ends in 9592.
And when you say that the 1987 was the primary phone, what leads you to believe that was her primary phone?
In this context, it's the phone that the defendant utilized for her normal, everyday business, communications with most friends, her business, that type of thing.
And the other numbers, let's talk about the 1152. What kind of device was that associated with?
That was associated with her 1987 device, but it was a number being utilized on that device. It was a Google Voice number.
Okay. So, can you just describe what a Google Voice number is and how it can be used on a cell phone?
Sure. It's basically a number that you create through Google Voice services, and you can use it just like a normal cell phone. You can make calls, receive text, that type of thing, and it's utilized through Google Voice app.
I see. Now, the 9592 number, was there a device that was associated with?
Yes.
What was that?
It's referred to in evidence as a blue phone, but it's an iPhone that was obtained by the defendant after her original phone was seized by police in April of 2022.
I see. So was that phone activated roughly that same time?
Yes.
Now, speaking specifically to the device that 1987 number was associated with, did you observe a forensic extraction of that phone?
Yes,
And did you analyze that extraction?
I did.
Did you notice any information or data deleted from that phone between January and mid-March of 2022?
Yes.
And can you describe what type of, or types of data had been deleted off that phone?
A lot of data, primarily and most relevant to the investigations in this case, the call logs, texts, web history, and web search.
So when you say that the texts have been deleted, does that mean the entire text threads between different parties?
Yes.
And was it everybody or in that time frame, or were there specific people?
Pretty much everybody.
Okay. Now you mentioned that web history had been deleted,
Yes.
and was there a specific date that prior to which that web history had been deleted?
Yeah, so there on that phone, the web history for that device, that primary device, was basically ended. It picked back up on March 10th of 2022, but prior to that, all of it was gone.
I see. The deletions that you observed on that extraction, can you say how those deletions were made?
No. I would presume it was completed like most deletions are completed on a phone, which is manual deletion. But there's no indication in the software of, any other means of that, whether it was active or remote or anything like that.
Okay. The data's just not there.
It's just not there.
That's right. Okay. I want to talk to you about a person came up during this investigation by the name of Josh Grossman. Did you associate a phone number with a device belonging to him?
Yes.
Do you recall what that number was?
The last four is 1260.
And a witness by the name of Carmen Laubert, did you identify numbers belonging to devices that were associated with her?
Yes.
And was there a primary number that was associated with her device?
Yes, and I believe the last four of that was 6127.
Same question for a Robert Crozier. Do you recall a number for him?
Yeah, Indian 0540.
And finally, you're almost done with this test. Mr. Richins' phone number. Do you recall the phone number associated with his device?
Last four of 9317 for Mr. Richins.
Thank you.
That has.
We'll grade it and we'll get back to you guys. I want to talk to you about the defendant's communications with Carmen Lauber. Between the time period, well, let me ask this first. Were you able to determine by other means, besides the defendant's phone, whether there were communications between those two?
Yes.
And specifically for the time period of roughly January 1st, 2022 and March 15th, 2022?
Yes.
And where were you able to see evidence of those communications?
Through the call detail records.
Whose call detail records?
I primarily focused on the defendants, but also Ms. Lauber's as well.
And what does a call detail record tell you?
A call detail record is exactly what it sounds like. It's a detail of calls recorded through a carrier. It will tell us, tell an investigator or anybody looking at the record when a call or text was made or received, the duration of that call, and potentially location information related to that account as well, or that device as well.
And who stores that information?
The carrier.
So that's separate from the data that's extracted from the phone, correct?
Correct.
So if data were deleted off of a phone, would that still be available through the carrier?
The communication, the timestamps and the direction of the communications would, yes.
Okay. What about location data?
Yes, potentially.
Okay. You say potentially. What would cause it not to be available?
Time, quite frankly, is usually the inhibitor there. But most carriers retain call detail records for a year to 2 years with location history. It could also be that a carrier does not report location data for, say, for instance, text messaging. Some carriers do, some carriers don't.
I see. Specifically, the carrier for the defendant's phone, was location data available for the call detail records that you analyzed?
At the time the records were sought, no.
And do you know why that was?
Time.
Okay.
Yeah, where Verizon retains location information within call detail records for 1 year.
Thank you. I would like to turn your attention, if I can grab a binder of the exhibits that have been pre-admitted here, to Exhibit 33. Have you seen that Exhibit 33 before?
I have.
And what is that?
This is a Facebook Messenger record between Ms. Lauber and an individual named Nicole Cummings.
Do you know who Nicole Cummings is relative to this investigation?
I do.
Who is that?
My understanding is a friend of Carmen Lauber, in which the friend is the one in which Carmen received a second phone number for Mr. Crozier.
I see. Now, turning over to 34, State's Exhibit 34, do you recognize that document?
I do. 34? Yes.
Yes. And what is that?
This is a
production record.
And the bottom input in that record, is there any number there that is relevant to this investigation?
Yes.
What is that?
This is a message, or this is a contact in a device for a number identified as Mr. Crozier's number, the ending in 0540.
And is the name of that contact Robbie-Nick?
Yes.
And is that the same Nicole that we spoke of a moment ago?
Yes.
Now, I don't necessarily need you to go through those, but I'm referring now to State's Exhibit 35. In Ms. Lauber's call detailed records for her device, do you see communications between her and Crozier on February 10th of 2022?
Yes.
And you recall approximately when those began?
It was in the evening. I don't recall the exact time.
Okay.
On the 10th.
Do you see calls between them on February 11th as well?
Yes.
Also on February 11th, through Ms. Lauber's call details records and the defendant's, did you observe any text messages between them on that day?
Yes.
Do you recall how many?
About 30, I believe.
And were there any text messages the next day, February 12th of 2022, between Ms. Lauber and the defendant?
Yes.
And do you recall when those occurred?
I want to say midday, but I'm not 100% sure.
Okay. But those would be contained in State's Exhibit 35, that call detail record?
Yes.
Okay. And speaking of these, the call detail records, are these in Mountain Daylight Time or Mountain Standard Time?
These are UTC time.
Okay. And UTC is what time?
It's Greenwich Mean Time. It's basically zero. It's a method for everybody to basically stay on the same time zone, as odd as that sounds.
Sure.
Basically, you just add or subtract your time zone from UTC to get local time.
Okay. So if these are in February of 2022, what subtraction would have to be made to find the local time?
7 hours. So during daylight savings, when we fall back in November-ish, we go to -7, and then we spring forward in March usually, where we're -6.
Okay. Thank you. Moving ahead to the February 14th, 2022 call detail records. Did you observe any, sorry, I feel like I'm moving away from that. Did you observe any text exchange between the defendant and Ms. Lauber on that day?
On February 14th?
Yes.
Yes, sir.
You recall approximately how many?
I don't. Not off the top of my head. It's several.
Okay. More than a dozen?
Yes. I want to say 30 again.
Okay.
Seems right.
I want to turn your attention now to State's Exhibit 43. Well, and before we go on to there, I just want to clarify, when you see this call detail record, you're not seeing the content in any of those messages, correct?
Correct. Only that the message was completed, sent and received.
Okay. But when you do a forensic extraction of a device, if those the content of those texts are still on the phone, can you see the content at that time?
Yes.
Okay, thank you. On February 26th of 2022, do you see communications between Ms. Lauber and the defendant on that day?
Yes.
Do you recall when they started communicating?
It was in the evening. I want to, if I recall, around 5 p.m., 4 or 5 p.m. on the 26th.
And you recall when they stopped?
About 10:30 that night.
From those call detail records, specifically from Ms. Lauber's, were you able to see where she traveled that day?
Yes,
And was she at or near a Maverick in Draper that day?
she was.
And how are you able to tell that from the call detail record?
So within that call detail record, AT&T is Ms. Lauber's provider. AT&T does provide location data for SMS messaging. So we're able to determine what tower is being utilized when Ms. Lauber's device made or received text messages as well as calls.
Okay.
So we put it into a mapping software and they're able to determine which tower was servicing the device during any given point in time.
So it's the location of the tower that phone is connecting with, correct?
Yes.
Okay. And down in the Salt Lake Valley near Draper, are you able to see multiple towers that? I mean, fair to say there's more than one tower in the Salt Lake Valley.
Yes, typically speaking, the more dense the population and the urban area, the more dense the cell phone arrays are.
Does that make it more accurate to pinpoint where that phone is?
Typically, yes.
And is the contrary to that true? The less populated an area is, the less cell towers there are.
Typically, yes.
Speaking specifically about Midway, are there less cell towers in Midway, Utah, than there are in or near Draper, Utah?
Yes, significantly.
Now, when Ms. Lauber's phone appears on those towers near Draper Maverick, was she there on any other dates besides that 26th?
Yes.
What dates were those?
February 11th, 2022, and March 9th, 2022.
Did you observe her phone being tracked in that area on any other time in the records you reviewed? Were you able to track her movements from Summit County to Draper and back?
Yes.
And is that, again, just through the tracking the towers that she's pinging off of?
Yes, the tower utilization, yes.
Okay. And we talked a little bit about Midway. Does the precise location become more difficult when she's in a more rural area?
In this case, yes.
Okay. And why is that?
You have less towers serving a larger area, so with a larger estimated range or area in which the device can be in, the harder it is to pinpoint more precise location.
I want to turn your attention now to Exhibit 31. If you could flip back there. Do you recognize what's depicted in Exhibit 31?
I do.
And what is that?
Is a depiction of messaging on a device from January 18th and January 20th of 2022.
And the top of that, the first page there, says Kouri. Do you recall whose device these images are taken from?
I believe they're from Ms. Lauber's.
Can you take one more look at those?
I will, yes.
Could those be from a phone belonging to a Hayden Jeffs?
I need to look at the contents.
Oh, sure. I'm sorry.
Just
Just
to
didn't
make
mean
sure
to
I
rush
look
it.
at the right thing. Yes, I misspoke. These are devices from Mr. Jeff's phone. Messages from Mr. Jeff's phone.
And they start on January 18th and they go to January 22nd
That's correct.
of 2022. I'm going to ask you to flip to State's Exhibit 36. Do you recognize the record depicted there?
I do.
Is that for the number ending 1987, the device belonging to the defendant?
It is, yes.
Was there a call made at 8:53 a.m. on February 14th?
Yes.
And do you know who that call was made to?
I do.
Who's that?
A Mirror Lake Diner.
And moving to State's Exhibit 38, are these call detail records for a number ending 9317?
Yes.
And did that belong to Eric Richins?
Yes.
Was there a phone call between Mr. Richins and the defendant at about 11:09 a.m. that morning?
Yes.
And is there a record of a photo being sent or some sort of multimedia message at 11:27 that morning?
Yes, and that was obtained via Mr. Richins' device.
Okay, so that's not here in the call detail records. That's in
It's
his
physical device.
physical
Yes.
device. Okay. Were you able to see what that image was?
No.
Was that deleted from his phone?
It appeared to be yes.
And were you able to see that on the extraction of the defendant's phone?
No.
Why is that?
All of that was presumably deleted from the defendant's phone as well.
Did the activity on Mr. Richins' phone on the 14th of February 2022, did that cease between 11:39 a.m. and 1:32 p.m.?
Yes.
Was he active on that phone before and after that dead period?
Yes, he was.
And can you describe the volume of his activity?
It would be what I would describe as normal phone traffic for that device. Calls and texts between friends, business-related things of that nature, yes.
Okay. Now, I'm not certain it's made it into the binder. Let me. I've handed you what's been marked as and admitted as State's Exhibit 7A. Do you recognize that?
I do.
What is that image of?
This is a screenshot obtained from a device of the defendant's phone, her navigation app within her device.
And is that from February 14th of 2022?
It is.
So this has not been deleted, correct?
From the defendant's phone, it was not in the defendant's phone. It was in Mr. Grossman's phone.
Okay, thank you for clarifying. Did that originate from the defendant's phone?
Yes,
Was that sent to Mr. Grossman?
it was.
And was that sent at approximately 9:48 a.m. on February 14th?
Yes.
And can you just give a little more description about what that navigation shows?
Sure, it's a typical screenshot of a normal navigation application. There is a location on Rockcliffe Road. The device is it's depicted that the device is traveling northbound, and it gives an arrival time, an estimated time of arrival, and a mileage for that trip that it's depicting.
And on Mr. Grossman's phone, were you able to read any text messages surrounding this time frame?
Yes.
And did the defendant indicate why she was sending this to him?
Yes.
Why is that?
She said she was on her way to see him. He asked if it was about an hour, if she was about an hour away, and she said yes and sent him this screenshot to verify her ETA.
Thank you. Speaking to the defendant's communications with Mr. Grossman, do you recall approximately when those began?
For the 1152 number, which is the first one I'm aware of, it began having trail, basically a digital trail on that phone beginning in November of 2021.
And what was the volume of text calls, anything of that nature, up until March of 2022?
The volume varied depending on the day, but it was pretty much daily communication between the two during that time frame.
And are these phone calls and text messages?
Mostly text, but yes, some phone calls.
And have a number of those texts been recovered from Mr. Grossman's phone?
Yes.
And if I could just have you just thumb through exhibits 29 and 30. Are those excerpts from the extraction of Mr. Grossman's phone?
Yes.
And are they approximately December and January of 2021, 2022?
Yes.
And if I could have you thumb through 39 through 42. Are those also excerpts from the extraction of Mr. Grossman's phone?
Yes.
And are those roughly the time frame of February and March of 2022?
Yes.
And finally, 3 exhibits, 44, 45, and 46. You could look at those. Similar question, also excerpts from Mr. Grossman's phone?
Yes.
And are those specifically March 2nd and March 3rd of 2022?
Yes.
And finally, exhibits 50 and 51, if you could look at those. Also excerpts from that extraction?
Yes.
And a little bit later in time, March 20th and April 9th?
Correct. Yes.
So it's fair to say around the time that Mr. Richins passed away, there were ongoing messages between the defendant and Mr. Grossman?
Yes.
I'd like to ask you now about the extraction from the defendant's phone relative to the morning of March 4th, 2022. We discussed this at the detention hearing, correct?
Yes, we did.
And at that time, you were relatively new to this case.
I was, yes.
Have you had a chance to analyze further the data on the defendant's phone regarding that date?
Yes.
I'd asked you at that time about movement on the phone at approximately 3:08 a.m. Do you recall that?
I do, yes.
Are you able to say at this time whether that was the phone itself moving or a connected device moving?
It appears to be a connected device.
And when you say a connected device, what does that mean?
In this case, I believe it to be a smartwatch. It's a device connected to for instance, the defendant's cell phone that is tracking movement data.
I see. When was the defendant's phone first unlocked that morning?
Right before 3:07 a.m.
And this movement activity, when did that take place?
3:08.
Do you recall how far the connected device moved?
I believe it was about 250 feet.
And was there a series of unlocks on that phone in the next 15 minutes?
Yes.
Was there additional movement around 3:21?
Yes.
Do you recall approximately how much?
I believe it was around 140 feet, 143 feet.
Do you see a 911 call on that device?
Yes.
What time did that happen?
Just after 3:21 a.m.
Do you recall if that approximately 140 feet movement was made before or after the 911 call?
Exactly.
So in about that 15-minute time frame, the connected device moved about 370 feet.
Correct.
Or if I just had one more. Thank you, Mr. Kouri. Those are all the questions I have for you this time.
Oh, sure. Thank you.
Afternoon.
Afternoon, how are you?
Doing great. How are you?
Good.
Good. All right. Let's talk about, go to State's Exhibit 45, please. Let me know when you're there.
Okay, I'm there.
Mr. Hill had you review Exhibits 44, 45, and 46. Do you recall that?
I do.
And he asked you whether that indicated there was communication between Ms. Richins as well as Mr. Grossman. Do you remember that?
I do.
Okay, so let's go to 44. And on 44, how is one of the senders or the parties identified as?
On 44?
Yes.
We have Mr. Grossman.
Perfect.
Yes.
And then let's go to 45. And how is one of the parties identified as?
My princess.
And then above that, where it says under party, first number 1, it says from, and then it has owner.
Yes, 9317 is Mr. Richins' number.
So that is not Mr. Grossman.
Correct.
Okay. So just to clarify, going back to Mr. Hill's questions, your testimony that what was included in Exhibit 45 was Mr. Grossman, that was incorrect.
Yes, I was mistaken.
Okay. You indicated that you were asked about the usage on the phone, about whether it was, you indicated it was normal tracking for that device. Do you recall that? And Mr. Richins' phone, just now.
About normal usage.
Mhm.
Sorry, yes.
Phone calls,
Yes.
text messages.
Yes.
Okay. interestingly, you said normal tracking for that device. I suspect you mean for that person.
They can be one and the same, yes.
A device doesn't do anything by itself.
Right, it has to be manipulated.
Correct.
Activated, yes.
So when you say normal tracking for that device,
Yes.
you mean normal usage by the person who that device belonged to.
Typically, yes.
Okay. You have no way of knowing really what the normal usage is unless you review everything, correct?
To the number, no.
Correct.
Yeah.
Perfect. You indicated that when responding to deletions on Miss Richins' phone, you indicated that it was from everybody.
Yes.
Okay.
Pretty much, yes.
Was there a time frame for that?
Yes.
And what was that?
January through March. About March 10th or so.
And that was for which phone?
It was for the 1987 number.
Perfect. Testified about attending a Celebrite certified operator course.
Yes.
When was that?
2017.
Have you been recertified since then?
I have not.
A Celebrite physical analyzer course as well?
Yes.
And when was that?
Same time, 2017.
Then a 40-hour cell phone analysis and mapping course.
Yes.
That one was not through Celebrite, that was through Zetex and Trax. Is that what it was?
ZedX is the company.
Correct.
Trax is the program. Yes.
Thank you. And so separate from Celebrite, but when was that?
The initial was, I believe, in 2013, and the subject matter expert class was in 2017.
And have you been recertified in that?
No.
The Trax technology gathered from the testimony, that's related to mapping?
Yes.
Okay. And is that what you used here?
Yes.
Okay. Now, you were retained by the Summit County Attorney's Office, is that correct?
Correct.
Were you hired by anybody else?
No.
And it was specifically to evaluate the digital evidence in this case,
Yes.
to analyze it,
Yes.
specifically phone extractions
Yes.
of Eric Richins,
Correct.
of Kouri Richins,
Yes.
of Carmen Lauber,
Yes.
others.
Yes.
Now, to be clear, you didn't perform the extractions.
Correct.
Who performed Kouri's on any of her phones?
I believe the RCFL did those.
Who at RCFL?
I don't know that.
Who did the extraction on Eric's phone?
I don't know.
Who did the extraction on Carmen's phone?
I don't know.
What about the other phones?
I don't know. The examiner's name is in each report, but I don't know them offhand.
So you didn't perform the extractions. You weren't present when they were done.
Correct.
In fact, I think, if my timeline's correct, you were hired after the extractions were done.
Yes, for most of them, yeah.
So you don't have the benefit of having observed the extraction examiner do the extraction
Correct.
or validate the results of the extraction.
Through the examiner, no.
And you don't have the privilege of observing the extraction examiner perform manual decoding methods
Correct.
or manual decoding methods in the hexadecimal code.
Correct.
You didn't confirm whether the extraction examiner validated their extraction tools.
No.
Let's talk about the Celebrite extraction process.
Okay.
We're going to go from the device to the data,
Okay.
okay? that, I'd like to be so visual. So, this is a target device.
Correct.
Let's assume this is a target device. Let's hope it's not a target device for my sake. This is a target device. We're going to say that this right here is UFED. Okay? So that is the Universal Forensic Extraction Device, correct?
Yes.
That's what it stands for?
Yes, you better, yeah.
Your Honor, I'm going to make an objection at this point as to relevance. I don't know that this is necessary at this point in time to a probable cause standard.
Not sure where we're headed, so I'm going to give Mr. Ramos a little latitude here until I know where we're headed.
Thank you.
This is UFED. Okay? You're going to plug this into this, and then what it's going to do is it's going to spit out something.
Yes.
Correct?
Yes.
I mean, it's not the technical term, but. So once we have that, it's in a raw format.
Correct.
Okay. Now, you have been given, when you were brought on, the output, what it spit out,
Correct.
right?
Yes.
Okay. So your testimony, both at the detention hearing and here, is based on this, on the spit out version.
Correct.
Okay. You have not received the raw data.
There is raw data available. But,
Correct.
Yeah.
Correct.
Yes.
There is raw data available. You have not received it.
Correct.
You have not analyzed it.
Correct.
You have not cross-referenced it with what you were given.
Correct.
Perfect. Now, let me pause. When you state that information was deleted, it doesn't tell you in what you've been given how that happened,
Correct.
why that happened,
Correct.
where it happened.
Also correct.
The raw data could potentially hold that.
Potentially.
Now, you use Celebrite, these extraction tools, you rely on them to provide you this information so that you could then assist, in this case, the Summit County Attorney's Office, with their case, correct?
Correct.
With meeting probable cause standards.
Correct.
Okay. In terms of location of individuals,
Yes.
such as Miss Lawler.
Yes.
Okay. Now, to be clear, I only have what you've been given as well. So I'm relying on the information that has been spit out, but not on the raw data, just so we're clear. I want to talk to you about your validation process. Validation of data.
Okay.
As, or having been rather, certified, you know the importance of being able to validate the data that you review.
Yes.
One of those methods is possibly to use it with the, or compare it to the raw data. That's one way.
Yes.
Another way is perhaps to use the cell data location from call detail records
Yes.
in terms of location.
Yes.
Now, when you use the software, that was a form of validating, sorry, I apologize, what did you call it? The tracks technology, that tracks software.
Yes.
That's a way of validating whether the information that you received is accurate. you talked about the cell towers.
Yes.
Now, this program, we're going back to spitting, does it spit out something for you?
It does.
Okay. Now, have you provided that to the Summit County Attorney's Office?
Yes. You're talking about the
Like the mapping?
Yes.
Okay. And are those towers that you referenced earlier, are they sectorized or omnidirectional?
They're sector.
Okay. When you use that program, were you aware at that point that software had been found to be unreliable in courts?
I'm not aware of that.
You've not been aware of that. But you haven't been certified since 2017.
I've been certified since 2017, but I have not. There's no need for research on that course. It's a learning and it's a continuing education.
What software version did you use for the tracks software?
Off the top of my head, I don't know.
When you did it, was it the most up to date?
Yes, as far as I know.
Had you updated it since 2017?
Yes, it's web-based, so it's updated constantly. So you can rely on the fact that if you're updating, say today, that it would be the most up-to-date software package.
And what about Celebrite itself, your Celebrite certification process? There are no requirements to recertify,
Correct.
but they do recommend that you recertify
And they do.
every 2 years.
They do.
But you've not done that.
Correct.
Along those same lines, there is no state of Utah, say, standard for mobile forensic extractions.
Not that I'm aware of. No.
There's no national one.
No.
There's no international one. It's pretty much whatever Celebrite says.
Well, they're one company.
Correct.
So,
To my point.
yeah.
Did you review or were you given rather any mobile data sets from the individuals who performed the extractions on all these phones? Like sample data sets, controlled data sets?
No. No.
Are you familiar with external enrichment?
I'm not.
Okay. You had indicated rather, you were asked about the activity sensor of a Apple Watch.
Yes.
How did you determine between the detention hearing and now that it was in fact an Apple Watch?
Review of the download stated Celebrite extracting that it was a connected device.
Now, are you qualified in mobility metrics?
No.
Do you know what mobility metrics are?
No.
You testified about the distance that was covered on the morning of March 4th by a connected device.
Yes.
And you were very specific on the number. Okay?
Yes, more or less.
But you don't know how that number was calculated.
I don't know the internal calculation process of the devices, no.
You just read it.
Yes.
You read what was spit out.
Correct.
You don't have the data, the raw data, correct?
Correct.
So everything you've testified to is basically because you've read it.
Well, yes, and the extractions from the devices, but yes.
Correct. Just what was given to you.
Yes.
Were there items that were deleted from Mr. Richins' phone?
From Mr. Richins' phone?
Mm-hmm. From Eric's?
Not that I'm aware of.
But it could be.
Could be.
Have you ever worked with Mr. Todd Gabler?
With? No.
Alongside?
Alongside and, quite frankly, against.
On this case?
No. Well, with, yes, on this case.
With on this case. And has he provided information to you?
Yes.
Has any of that information been used in your testimony today?
No.
I believe that's it, Judge. If I may just have a quick second.
Take them all. Counsel. Ms. Nestor, just push the button.
Thank you. Sorry. Yeah.
Just a couple more, Your Honor.
Go ahead.
Has the Richins family ever hired you?
No.
Have they ever paid you?
No. Is the podium?
I did sound quieter.
Did sound quiet.
Yeah.
Let us just check for a second, folks.
It sounded like my conscience was speaking.
In fact, mine was muted. Brittany, you broke it. Yeah, my mic is dead.
I can hear it.
Why would we need something that's going overhead? I think, well, the things going overhead are muted, so.
A lot of things go over my head.
There we go.
Oh, there we are.
Just saying.
Last question. Did you want me to repeat that?
Have they ever paid you?
Yeah.
The last question.
Perfect. What was provided to you by Todd Gabler?
Off the top of my head, mostly tolls.
Tolls?
Yeah. Yeah. Call tolls, toll records from the Verizon toll records.
No further questions. Thank you.
Mr. Hill, any redirect?
Just briefly.
Okay.
Mr. Ramos asked you about any deletions that you observed from Eric Richins' phone, and you had previously testified that a picture that he sent on the 14th was deleted. Is that right?
Yes, that's correct, yeah.
How could you tell that that was deleted?
Well, it's not present any longer. It shows a file path that it used to exist, but the image itself is not there.
Okay. And so to follow that, when he asked you if there's anything else that's deleted, did you see anything similar to that picture or any remnants on that phone or relics that showed deletion the same way that photo did?
Not that I can recall.
Okay. Thank you. That's the only question I have.
Mr. Ramos, anything on that?
No, Your Honor. Thank you.
Can we let this gentleman step down? Mr. Hill?
Yes.
You can step down, sir. Thank you.
Your Honor, can I suggest, please, a brief recess? Mr. Burmister's going to set up a computer
Okay,
in about an hour.
no problem. Why don't we take a 5-minute recess? Who's testifying after the recess?
Your Honor, Ms. Carrington, Brooke Carrington.
Okay, she's present.
She is.
All right, we'll take a 5-minute recess. Thank you. Court's in recess. Thank you. Next witness.
The state's next witness, Your Honor, is Brooke Carrington.
Ms. Carrington, let's get you sworn in.
Do you solemnly swear the testimony you're about to give in the matter before the court to be the truth, the whole truth, and nothing but the truth, subject to the pains and penalties of perjury?
Deputy, can you give Ms. Carrington a glass of water? Thank you. Mr. Burmister, take it away.
And to increase the likelihood of a disaster, is that the witness notebook? Because we're putting water next to a notebook. And
That is the witness's number.
okay, that's what I would do. Now, Ms. Carrington's a lot better than me.
Thank you very much.
Can you please state your full name and then spell your last name for the record?
Brooke Carrington, Karrington.
Ma'am, are you employed?
Yes,
How?
I am a forensic accountant.
Do you work for a firm or have a firm?
I have a firm, KF Squared,
And how long have you practiced in this field?
over 30 years.
Now, did you testify as an expert in this case at the detention hearing in June of last year?
Yes, I did.
What sort of documents did you review, if any, in preparation for today's testimony?
I reviewed financial documents that include bank account statements, real property documents that are recorded like trust deeds, warranty deeds, etc. I've also reviewed loan documents, which includes promissory notes, the applications, the documents that memorialize the terms of the loans. I've reviewed insurance documents, which are the applications and the policy documents. There's also a large body of email communication associated with different loan applications and insurance applications.
Okay, so to be clear, that would be things like maybe someone submits an application and then there's some follow-up communication between a lender and a borrower?
That's correct.
Okay. What bank accounts did you look at? I'm sorry. What banks or credit unions, other things, did you look at?
Primarily, there are a number of them, but primarily America First Credit Union, PenFed Credit Union, Navy Federal Credit Union, UCCU, which I believe is Utah Community Credit Union.
Okay, so let's look at the bank accounts from AFCU, from America First. Were there a number of those accounts associated with the defendant and her family?
Yes.
Okay. Let's talk about, were there some associated with their children?
Yes.
Okay. Leaving those to the side, see, that's why I don't have water next to me. Let's look at the adults. What accounts, and let's refer to them to the last 4 digits of those accounts. What ones did you look at?
Primarily, the Kouri Richins Realty account, which is 5677.
You sure it's 5677?
6577. Sorry about that. They're joint. Eric and Mr. Richins and Ms. Richins had a joint account 2204. Ms. Richins had a personal account which is 5244, and then the C&E Masonry account, which is 7664.
This 6577, the K. Richins Realty, did Eric Richins have access to that account that you could see?
Not that I'm aware of. He was not a signer. I don't see any transactions that indicate that he would have accessed that.
Can you generally conceptualize how 2204, that joint account, was used?
That appeared to be the account where typical household expenses were paid. The mortgage on the house, the credit card payments, the kids' expenses, insurance payments, various things associated with the family.
Purchases at the grocery store?
Things like that, yes.
Yeah, okay. Are you, through this work you've done for the county, and let me ask this question. Were you originally hired by the estate or someone else before being hired by the county?
Yes, it was.
Who hired you?
I was brought into the case to work on behalf of the estate of Eric Richins.
Okay.
And so I worked on that case, but then when I was hired by Summit County, I ceased my engagement with her.
I see. Okay. So in part of your work, did you ever become familiar with a premarital agreement?
Yes.
Okay, I'd like to refer your attention to docket number 106.
Okay.
Did you, in your work, did you examine this document?
Yes, I did.
And what is it?
This is the premarital agreement between Mr. Richins and Ms. Richins.
And I'd like to further direct your attention to section 2 of that document.
Okay.
In section 2, is there something relevant to today's inquiry?
Yes, this section states that the business C&E Masonry would retain its character as separate property belonging to the husband.
Even if funds were commingled,
That's correct.
personal and professional? But was there an exception to that?
Yes, if the husband should die prior to the wife, then his interest would transfer to her.
So what was K. Richins Realty?
That is Ms. Richins' business, primarily in the real estate business.
Did she have other businesses that you're aware of?
Yes, she did.
Do you know when that business was formed?
Yes,
When?
in April of 2019.
I'd like you to take a look at State's Exhibit 19, please. What is that?
This is the Certificate of Organization of K. Richins Realty, LLC.
Does it indicate when the company was formed?
It does on yes, it does.
What is the date?
April 26, 2019.
And does it also give an address for this business?
Yes, it does.
What is that address?
282 Willow Court in Kadmus, Utah.
Okay, is that in Summit County to the best of your knowledge?
It is in Summit County, yes.
Just generally speaking, how does this type of business work that Ms. Richins was involved in?
She appears to me that she was a licensed real estate agent, so she did represent buyers and sellers, but primarily she was involved in fixing and flipping homes.
So she would buy it, fix it, then sell it? Is that what we're getting at?
That's correct, yes.
Okay. This began then in 2019?
That's right.
Were there other purchases or transactions that predate 2019?
Yes,
And where did those take place?
those were in South Carolina.
So the market in 2019, do you have any idea of what the market was like, real estate market was like in 2019?
Yes, it was robust.
Meaning properties could come up for sale and be gone within a matter of days?
I think that's a fair statement, yes.
Okay, what were the interest rates like? Conventional loan interest rates then versus, say, today?
Fairly low. They were still very, very low at that time.
Rough neighborhood average?
Well, depending on your loan, but 2 to 4 or 5%.
Safe to say that's a little different today.
Safe to say, yes.
So in that business, it would seem to me that you would need to be able to act quickly to obtain properties before they're suddenly off the market. Is
I
that
think that's a fair statement, yes.
okay? So how do the practitioners of that type of business work? It would seem you'd need some capital somehow.
That's correct.
And what are the possible sources for capital?
A business in that field could have its own capital. It could borrow from financial institutions. They could borrow from friends or whatever, hard money lenders,
Okay.
or have investors.
Okay. So what do you mean by hard money lenders?
Hard money lenders are, soft money lenders would be like traditional financial institutions where it's a conventional loan, there's a conventional loan application process, due diligence by that financial institution, or and they're typically regulated by state and federal agencies. And then hard money loans are called that colloquially because they have more strict terms, they're harder terms, usually a higher interest rate, very definite zero tolerance default clause usually.
Okay, so I guess the advantage of a conventional loan would be lower interest rate. The disadvantage would be response time because of the due diligence required.
That would be, yes.
Okay. The others are more responsive in time, but have these more draconian clauses.
Yes.
Prior to the April 26, 2019 date, was there something else that you found that was important for our inquiry today?
Yes.
And what was that?
The home equity line of credit that was taken out on the home.
On the family home, the marital home.
The home on Willow Court, where the family lived. Yes.
Do you know whose name that well, first of all, was there a mortgage on that home that pre-existed?
Yes.
Do you know whose name was on that mortgage?
The home was owned by Kouri Richins,
Okay.
and the home equity loan that was taken out was also in the name of Kouri Richins.
Could you give us a very brief description of what a home equity loan is?
It's a line of credit typically that is established. There's a loan application process. There's a line of credit that's established that someone could tap into their equity that they already own.
I see. So you could make home improvements or whatever you wanted to do with it, I suppose.
a person could tap into it for any number of reasons.
I see. Okay. In this case, there was home equity line of credit for how much?
$250,000.
And when was that?
That was in March 2019.
And so does this in effect, is it secured by the home itself?
It is, yes.
Okay, so this is essentially a second mortgage.
Your Honor, I know this isn't expert, but we're doing a lot of meetings, so I would just object and ask if we could maybe let the expert be the expert here and object.
I think it's just laying foundation and so overruled, but if we can keep it moving.
Will
Mr.
do.
Bruce.
Do you know if this was, there was any in order to obtain this, I guess, is where we need to go with this. In order to obtain this loan, home equity line of credit, on a home owned by Eric Richins, how does that happen?
There's a loan application process, and in this instance, it was signed by Ms. Richins, referencing a power of attorney.
Okay, I'd like to direct your attention to States Exhibit 123, States Exhibit 124. We'll take 123 first.
You're talking about the dockets?
Yes,
Okay.
I'm sorry. Docket number 123 and 124.
Okay, yes, I got those.
Do you recognize those two documents?
Yes.
Is there a difference on the date it's signed by the purported author of it, I guess?
Yes.
What's the difference in the date on it?
Docket 123 is signed and dated 5/8/13, and docket 124 is signed, dated 5/8/18.
During your investigation and examination, are you aware of whether those docket number 123 and 124 came under suspicion?
They were.
Okay. I'd like to direct your attention to States Exhibit, or docket number 127.
I do
127.
not have a 127. I do not have a 127. Wait, never mind. It's just in different order.
Yes, it
Sorry.
is out of order. That is
That's okay.
totally my fault.
Okay,
Do you know what that is?
I do.
What is it?
This is the expert report by Matt Throckmorton.
And those, he examined 3 question documents, is that right?
That's right.
Okay. And 123 and 124, are they any of those question documents?
Those are 2 of the 3.
Okay. I'd like you to take a look at now. I don't think it's lost control. Oh, it's right here. We do have it right here. Okay. I think we have marked them as States Exhibit 70 for the court. I approach the witness
Of
because
course.
I'm not sure she has States Exhibit 70.
Go ahead.
Can you please just describe or the title of that document for the record, number 70?
This is the Willow Court Loan Advances and Payments.
Okay. When is the first withdrawn that home equity line of credit?
It's March 26, 2019, for
And how-
$60,000.
When is the next withdrawal?
August 5th, 2019.
Could you describe the next couple of withdrawals on that?
Following that $2,100 in August, there are a series of withdrawals for the next few months.
Okay. In August, is there more than one or just the one?
There are several.
Okay. Does that strike you as important for today's
Yes.
purposes? Would you explain to the court what you draw from that?
Beginning in August of 2019, this is around this time is the first property that Ms. Richins purchased after obtaining her business license. It's a home in Heber City. As far as I know, that was her first home in Utah that she flipped.
We have State's Exhibit 71.
Mr. Bruce, are you offering State 70?
Yes, yes, I will be offering State 70 and 71 as summary charts.
Okay. Is there any objection?
No, sir.
Okay. 70 and 71 are admitted.
Could you read for the record the title of 71?
Encumbrance and Real Property Chronology Trust Deed Summary.
So what, does that help you state for the record what that first transaction was and where and?
Yes.
Okay.
It's the 550 house. The first warranty deed involving Kouri Richins Realty was August 1st of 2019.
Okay. Now I'd like to portray that in another way. Did you prepare a timeline bar chart?
Yes.
Does it depict much of the same information, just in a different way?
Different format, yes.
Would that be helpful in conveying your testimony today?
Yes.
Okay. State would offer State's Exhibit 69, and we're just going to go for the first chart, which is the timeline.
Is there any objection?
No, sir.
State's Exhibit 69 is admitted.
That's the whole PowerPoint? I'm sorry.
It is, but I've only laid foundation for the very first
Got
one.
it.
Is that the bar chart you were just referring to?
Yes.
Okay. And so, can you just explain for the judge how this chart works?
Sure. I think you've seen this before. And the colors don't mean anything. They're just to distinguish one line from another. I just got the years along the top and the months, and then going down the different properties just as some sort of an illustration to depict when properties were held at any particular time.
And then within each bar is the address of the property purchased?
Right, and so if you wanted to know what was held in June of 2021, you could draw a vertical line to see which properties were owned at that time.
I see. Okay. So, any more purchases in 2019 by Kouri Richins Realty?
Not that I know of. There could be others, but this is what I have been able to compile.
How about in 2020?
2020, yes, there were others.
Okay. How many purchases by Kouri Richins Realty of property in 2020?
I think there were just the 5.
I see. Is there one that stands out to you?
In 2020,
Yes.
not particular. Well, the Franson Lane one toward the end of 2020, in October of 2020.
I see.
The Franson Lane property in Oakley.
I see. Let's drill down into the Franson Lane property. You said, when was that
It was
purchased?
acquired in October of 2020.
Is it different from the previous 5, I guess, counting 2019.
Yes.
In what ways was it different?
It was a more robust project, more ambitious project in amount. You know, it was. I think she acquired it for $1.3 million, and the others had been somewhere in the neighborhood of like $300,000 or $400,000 or $500,000.
Did she require money, outside money to
Yes.
make this investment?
Yes.
Okay. What sort of investors?
They were hard money lenders.
Do you know who they were?
Yes.
Who are they?
Sierra West Capital was the primary lender, which is this, as is the case on several of her properties.
I see.
And then there were other investors who contributed the funds basically for the rehab.
I see. Okay. Was there something else different in this application that you garnered from all the financial records?
I'm sorry, I didn't understand your question.
That's the way I roll. Okay. Was there something else that you found in reviewing all of the documents, not just the loan documents, that distinguished this purchase as opposed to the ones that had gone before it? Involving, all right, how about this? Do you know if C&E was involved in this project?
C&E was involved in this project.
Okay. And what did you discover about C&E's involvement?
After the acquisition of the Oakley property, the Franzen Lane property, C&E, there are several checks from C&E that were deposited to the Kouri Richins Realty account, and they specifically have a memo on them that tie them to this property. And so over the next, between October and when this property was sold in March of 21, there are a series of checks. I think there are 6 or 8 checks that are about $133,000, I think.
Was this property ever sold?
Yes, it was.
When?
In March of 2021.
Okay. What happened to the proceeds from that sale?
This was a property where the net proceeds were about $466,000, which came into the Kouri Richins Realty account, that 6577 account. And
Okay.
then from that, $217,000 was paid directly to C&E.
Okay.
And then there were some other payments, transfers out from the account that were associated with this property as well, and left her with about, around $200,000 in net proceeds.
In your examining of all the evidence in this case, were there other things that you looked at to inform your examination that took place in October of 2020?
There were other things in October of 2020, yes.
Did you take a look at State's Exhibit 22, if you would? Are you familiar with that document?
Yes.
Could you explain what it is?
This is an intake form from a divorce attorney describing that Eric Richins was wanting to consult with this attorney on a potential divorce, and it's dated October 8th of 2020.
In the wake of that, are you aware of any other instruments that were created out of that?
Yes, there are the notes that the attorney appeared to have handwritten during the course of that first meeting.
Were there financial arrangements made after that meeting that you're aware of?
Yes, the notes indicate that there was some new information by Mr. Richins that there was the HELOC had been taken out on the home,
Okay.
that as if this was new, and then from this he set up the Eric Richins Living Trust and also a will.
Was there something dramatically different about the trust situation as before?
Ms. Richins was not the beneficiary of his estate. It was to be for his children, and the trustee was going to be his sister, Katie.
So I'd like to go back to, I think it was 70. It should be the HELOC loan balance for Willow Creek, is that right? Yeah. By August of 2020, what was the balance?
August of 2020, $246,931.
Okay. Is there a significant, well, up until that point, how was there money being paid on that debt?
Yes, they were the interest-only payments. The minimum payments were about $900, $1,000, something like that, that were made every month.
Did something different happen in October of 2020?
Yes.
What happened?
There's really the first significant payment, and it's $50,000 on October 12th.
Do you know what the source of that fund was?
Yes, Ms. Richins had sold the Cleveland Avenue house in Salt Lake, and from that she received net proceeds of about $63,000. There was a transfer, and then this $50,000 was sourced from that.
Okay, on October 12th.
Yes.
Okay. Bringing the balance to approximately what?
$196,000.
Do you know whether in October she was in a financial position to just pay that $196,000 off?
She was not.
Let's go into 2021. I guess we've still got the timeline up. Direct your attention to timeline. And could you describe for the record a summary of what purchases, et cetera, took place in 2021?
Yes. So she acquired a property in Heber City before she got the proceeds from Branson Lane. And then after that, she acquired a number of properties throughout the summer especially, and then ending the year acquiring 3 on the same day in November. And I think there may be another property that she was working on that I don't have on here, but all in all, she had about 15 properties in 2021.
So, did she go to the same lenders for all of these 15 properties?
No, there is some consistency in the lenders, but she did diversify a little bit.
Okay. Can you tell the court some of the lenders that you have found that she used?
So she primarily used the Sierra West, and that's pretty consistent through here. And those investors who would have been taking second, third, or fourth position were pretty consistent as well.
And those are like Cockerhands?
Cockerhands, Ellis, Soto, Lieb. There's a number of them.
Okay.
And then She also went to a company called Ironbridge, a company called Boomerang. She did 4 projects with Boomerang.
I see. So let's take, first of all, when did she go to Ironbridge and when to Boomerang?
Those were in the summer of 2021.
Okay. And Ironbridge, how would you describe what Ironbridge is or does?
They are, they appear to be a hard money lender. The terms are somewhat more flexible than typical hard money lenders, but the interest rates the interest rate on that loan, I believe is 13%. Was 13%.
And in 2021, is that high?
That would be high, yeah.
So, how did the application process go between the defendant and Ironbridge?
There is an original application that is submitted. It appears to be online. I don't know that for sure, but it appears to be online. And then there was a series of emails back and forth where the person analyzing the loan or underwriting the loan is asking her to submit some additional documentation.
Okay. Can you take a look at State's Exhibit 58, please?
5-8.
Yes, 5-8. State's Exhibit 5-8. Is that what you were talking about? Some email going back and forth between Ironbridge and the defendant?
Yes.
Okay. Is there something about a bank statement in there?
Yes. It asks for personal bank statements, the most recent.
Okay. Based on your experience and training, why would they want to know that stuff?
Typically, they call that proof of funds. They want to, they need to verify. In banking terms, it's KYC, know your customer. Every financial institution needs to know and verify the individual and entities that they're dealing with.
I'd like you to take a look at State's Exhibit 59, if you would. What is State's Exhibit 59?
This is a secured promissory note for what I call the 299 house in Heber with Ironbridge.
I see. And first of all, this is Kouri Richins Realty purchasing this. Is that what it?
That's right. And I misspoke. This is 10%. I had misstated the interest rate earlier.
And what is the amount that they're loaning?
$346,500.
When?
In this is in July of 22.
20.
I'm sorry, July of 21. Sorry. It's signed July 7th, 2021.
Now, did you examine a bank statement from Ironbridge purportedly given to them by the defendant?
You mean from Ironbridge, meaning?
It was obtained from Ironbridge, but submitted to it that it used to.
It was part of the Ironbridge loan information that we received. Yes.
Okay. Would you take a look at State's Exhibit 11, please? What is State's Exhibit 11?
This is America First Credit Union bank account statement for May 31st, 2021 for Kouri Richins Realty, account number 6577.
And do you know where this was sourced from?
This was sourced from Ironbridge, as indicated by the number on the top.
Okay. And how do you know it's Kouri Richins Realty?
The header on the bank account statement purports to be Kouri Richins Realty.
I see. And then In the body of that statement, does it give the amount in the bank account?
Yes.
What is that?
The summary of the accounts for the 3 accounts that are included in this bank account statement is $210,898.61.
Okay.
That's the ending balance.
So I'd like to direct your attention now to State's Exhibit 12. What is State's Exhibit 12?
This is the America First bank account statement for Kouri Richins Realty for that same month, May of 2021, for account 6577. This is the actual statement that we received from America First Credit Union.
In what way is it the same, and in what way is it different from the State's Exhibit 11?
The header is the same, but the body, the transactions that are contained are different.
What is the total balance?
The total balance is $15,609.
All right, let's take a look at State's Exhibit 13. What is that?
This is the actual bank account statement for C&E Stone Masonry, ending in 7664. This was the document that was received directly from America First Credit Union.
And how do you know it's C&E's?
The header indicates that it's C&E's, and the transactions appear to be consistent with what C&E would be doing, and it matches the bank account statement that Iron Bridge produced, but it has the different header on it.
So let me make sure I understand this. 11 has a header from her account, Kouri Richins Realty, but yet the body of C&E's May 31st bank statement.
That's correct.
I'd like you to take a look at State's Exhibit 60. That's 60. I believe that's an email exchange. Is that right?
That's right.
What's the subject?
Quick question.
Okay, and is the quick question physically below the response? Is that
Yes.
okay? So what is the quick question?
This is from Mr. Amy, I don't know how to say that, from Iron Bridge, emailing Ms. Richins asking for an explanation about her credit score, the credit cards, and referencing that bank account statement.
Okay. Is he perplexed? I mean, or
Check
is,
speculation.
Sustained.
specifically, what does he say to her?
He says when he first ran her credit, it was lower than expected. There were some delinquencies on the credit cards, but he can see from the bank account statement that she provided that she's got plenty of money in the bank to cover expenses.
How does she respond to that?
Would you like me to read it?
Yes, please. If you just read what she says to that question.
She says, "Hi Richard, hope you had a great 4th of July weekend. Yes, sure. Everything is paid off now. It just probably hasn't updated. I recently learned about all of this as well, LOL, and then my husband decided to explain to me that this was his doing a while ago. We are in the process of separation for one of many reasons, but this is one of them. To keep it short and sweet, LOL. It's been crazy to say the least. I look forward to working with you guys on our first and hopefully many projects."
Okay, you said she obtained some loans from Boomerang 4, I believe you said.
Yes.
Okay. I'd like you to take a look at State's Exhibit 14, if you would. what is State's Exhibit 14?
This is from Boomerang, but it's an America First Credit Union bank account statement for Kouri Richins Realty, account 6577 for June of 2021.
And how do you know it's Kouri Richins Realty?
It's just the header.
And what is the balance on the?
The balance, the ending balance is $702,831.
Okay. Let's take a look at State's Exhibit 15 then. And what is that?
This is the actual statement that was obtained directly from America First Credit Union for Kouri Richins Realty, account 6577 in June of 2021.
And the header says Kouri Richins and Realty and the 6577?
That's right.
What is the ending balance?
Ending balance is $15,339.
Okay, let's take a look at State's Exhibit 16. And what is that?
This is the actual bank account statement that was obtained directly from America First Credit Union for C&D Stone Masonry LLC, account 7664 for June of 2021.
And it presumably says C&E and 7664
Yes.
in the header?
In the header, yes.
What's the ending balance?
The ending balance is $702,831.
That's the same as State's Exhibit 14?
The one that was issued to Boomerang, or submitted to Boomerang, yes.
Okay. So once again, cut and paste of header for Kouri Richins Realty and the data, the amount of money on hand from C&E.
That's correct.
Direct your attention to State's Exhibit 61, if you would. Could you describe for the record what this is?
Yes, this is from Boomerang. This is a document that came directly from Boomerang. It's a kind of an internal review, a summary of a potential loan, kind of ahead of, it would be prepared in the midst of the approval process.
I see. And what was the property?
This is for the 75 East Midway House, I think. Yes. The smaller Midway House.
Okay. And in there, does it reference, well, first of all, how much is the loan amount?
The loan amount on this is $454,750.
And does it talk about the defendant's liquidity?
It does on the second page.
And what does it say about it?
Let's see. It says under liquidity and net worth, Kouri has liquidity in the amount of $702,000. She has a net worth of $2,719,000 made up of cash, securities, life insurance, retirement funds, and real estate investments.
And so that number 702,000 is that same figure from C&E that she's submitted in State's Exhibit 14?
Don't remember the exact exhibit number, but yes, that number is drawn from that bank account statement that was actually C&E, not Kouri Richins Realty.
Did you find any other instances where this similar type of cut and paste header with some other account was submitted to lenders?
Yes.
How many times did you find that?
I found 6 so far.
Including these two?
Yes.
Now, I'd like you to take a look again at the timeline.
Yes.
Okay, so these purchases in 2021, you've already mentioned, it's 15, more and more. Did any of them sell?
Yes, great number of them did, yeah.
Okay, tell us about that.
Well, as like the Mill Creek House, for example,
Mm-hmm.
that was acquired in the spring. That's a home in Salt Lake County, and so there was a primary lender on that, and multiple investors who gave Kouri Richins Realty money for the rehab costs. And then when it was sold, most of those were paid from closing, like at the title company. Some were not. Some came out of Kouri Richins Realty's net proceeds.
Okay. So she's turning over property, isn't she gaining money by doing this?
Yes.
Okay. What's happening to her debt load?
That was increasing, especially she started in the middle of summer of 2021. She started acquiring personal property loans that they're not secured by real property and were secured by advanced, her future receivables.
Okay. Is Greengrass holding one of those?
Yes.
Okay. Turn your attention to State's Exhibit 20. So could you, first of all, tell us what State's Exhibit 20 is?
This is a revenue purchase agreement dated, it's in September of 2021.
And could you explain the basic terms of this?
This is an agreement with Kouri Richins Realty and then some other companies pledging $87,000 of advance receivables for $60,000 upon execution of the agreement, and e-signed by Kouri and Doreen Kouri.
Okay, so let me make sure I understand this. So she's saying, I will give you $87,000 of money I haven't earned yet, but I'll pay it to you in the future if you give me $60,000 now.
Yeah, and what's represented here that it's been earned and it's going to be coming in, but it's not in yet.
I see.
So she's saying, I'll pay you back $87,000 for $60,000 now.
I see. Okay. And what did it obligate her to pay?
$5,438 every week.
Did she pay that?
For a series of payments, yes.
Okay. How much did she pay that you're aware of?
I think she paid about $20,000. I'm not exactly sure the amount on there, but she paid about $20,000 and then defaulted in December.
Did something happen as a result of that default?
Yes, they filed suit in New York.
Okay, the state would direct your attention to State's Exhibit 21. Could you describe for the record what State's Exhibit 21 is?
This is the summons and the verified complaint associated with that lawsuit.
And so in a lawsuit like that, there's some alleged facts?
Yes.
Okay, so I'd direct your attention to page 5, fact number 11.
Yes.
And what is the allegation there?
That she did pay $21,752, leaving the balance of unremitted receivables of $65,248. And then there's default fees of $2,500 and attorney's fees of $19,574.
Did you find any other agreements or attempted agreements between the defendant and these type of lenders?
Yes, I found several.
Okay, what are they?
QFS Financial is one she entered into where she pledged $165,000, $167,000 for future receivables for $105,000.
Okay.
That was the largest one by far. Most of them are in the $20,000 to $30,000 range.
Is Blue Bridge something like that?
Blue Bridge is one, Delta Bridge Funding, Zahav, Asset Management, Crown Funding. There are over a couple of dozen, or I'm sorry, over a dozen, yeah, about 20 or 25.
You mentioned early on that the defendant had an account with Navy Federal.
Yes.
Navy Federal, do you know what kind of account she had there?
At Navy Federal, she had a checking, a savings, and a credit line.
Okay. During the period of August to December of 2021, do you have any idea? Well, first of all, what was the maximum amount for that, the credit limit for that revolving line of credit?
That was $15,000.
For that period, August 2021 to December of 2021, do you know what her balance was, relatively speaking?
Well, it was almost maxed out most of the time. During that specific review period, I would say, I think that's about $13,000.
Okay. Can you take a look at State's Exhibit 26, please? Is that a multi-page document?
It is.
What are they?
These are the bank account statements for the account ending in 0060, starting in July of 21. Ending in March of 22,
Okay.
and for Kouri Richins.
Does the statement include the balance on revolving credit?
Yes.
Okay. And throughout that time period I've just mentioned, it's more or less maxed out?
Yes.
Okay. I'd like you to take a look at State's Exhibit 27. Do you know what those are?
Yes.
What are these?
These are checks from the account of Kouri Richins at Navy Federal, and these checks were deposited into the account of K. Richins Realty. I believe all of these were deposited into that account, and none of them cleared.
Okay. Let's just do an exercise on one of these. Let's take a look. What's the check number on the very first one of State's Exhibit 27?
Check 271.
And when is that?
The date on the check is 8/28/2021.
Can you find that transaction in State's Exhibit 26, which is those statements for that appropriate time period?
Yes. Yes. It's on, the Bates number ends in 99 at the top, and it was returned on 8/31/21.
Okay. So that check, and how much was that check for, that particular one?
$2,100.
And all of the checks then in State's Exhibit 27 are similar in that way?
That's right.
So now we're at December of 2021, the end of the year there. What is her financial status at that point?
All in all, with all of the property, she had acquired and sold a number of properties. She retained several as rentals. She still had loans on those properties. So at that time, it was about $4 or $4.5 million that she still owed on those. Well, the trust deeds, she had paid some on them, but there's that. And then with all of the personal property loans, it's hard to tell for sure, but I think somewhere around $500,000 or $600,000 she owed on those personal property loans as well.
Now, you mentioned that one, for example, was, I think it was Greengrass that
That's right.
required her to pay $5,000 weekly.
5,438 weekly, yes.
Okay. Were there some that were daily?
Yes.
And how many payments did she have to make for the month of December, for example?
She made about over 90 payments on debt. You know, toward there's a difference. There's the debt load and there's the debt service. So she owed the amounts that I stated, and then the debt service are the payments that she paid on that debt. And they're a little, well, there's over 100 that she paid payments.
So for the month of December, how much debt service is just what she paid? Not necessarily. It could be the same as debt load, but
In this instance, no, it's different.
okay.
Yeah.
What was the debt service for the month of December? Do you know?
It was over $300,000.
Okay. I'd like to take a look at. This is back to State's Exhibit 69. I'm going to move on to the next chart. Can you describe for the record what this next summary chart is?
This is the debt payments that she made
So-
during these months.
Once again, this is debt service, not debt load. Or-
That's right.
Okay.
This is not the amount of debt she possessed. This is the amount of payments that she made on that debt.
Okay. And for the months of
June of 2021 through February of 2022. And I do need to make a note that in preparing for this hearing, I've noticed that in December of 2021, I made a duplication. So we need to reduce that number by about $44,000 in December.
okay.
It's still about $320,000.
Now, in January and February, it appears to go down. Is that right?
That's right.
Let's once again look at the same information and expressed differently. You described this for the record. This is the third chart on the PowerPoint.
So this is drawn from that previous data. And so it's just showing it in a pictorial format.
It seems after December, it seems to be going through the floor.
That's right. These are the payments that she made on the debt. She did pay off one of her lenders, one of the personal property loans. She did pay that off in January, and that was about $19,000. But mostly because of what had happened in November and December, so many transactions had been returned and not cleared by the bank. They did not. Some of them continued to try to draw in January and February, but they were unsuccessful. And so those payments were not made.
So this doesn't depict her debt load, the amount of debt she has, but rather she's just not paying.
That's correct. At least from the accounts I have. At least from the accounts that I have reviewed.
Okay. Sometime around this time period, did she take on another project?
Yes, she did.
Is it different than previous projects?
Are you talking about the Legacy Way project, the large house?
Oh, okay, yes. Tell me
Yes.
about that.
She, the first REPC, which stands for Real Estate Purchase Contract, was in December of 2021, and it's a very large property on Legacy Way and Midway. and that's the property that she did end up closing in March 22.
Okay. It begins though in December and concludes when in March?
Well, the settlement statement I've seen is dated March 4th. Some documents were signed March 4th, some were signed on the 7th and recorded on the 8th of March.
How is this different from any of the other previous projects?
It was an unfinished house and just quite large, a very, very ambitious project. The purchase price, I believe, was $2.9 million.
What was its state of repair?
It was under construction, so it didn't have much inside, down to the studs, exposed wiring, things like that.
Did she ever, that you're aware of, give an estimate to lenders about what she anticipated those costs would be to rehab it?
Yes.
What was that?
Her estimate was between $3 and $4 million to rehab that property once it was acquired.
And how did she obtain this property?
Through hard money lenders.
All borrowed then?
Pardon me?
All borrowed?
Yes, all borrowed.
Okay, I want to talk about life insurance. Have you had the opportunity to look at life insurance policies that were owned by the Richins family?
Yes.
Do you know about how many there were?
I think there were 6.
I see. Okay. This is the fourth chart of 4 from States Exhibit 69 PowerPoint. Can you describe what that is?
Yes, these are the life insurance policies on Eric Richins' life, and I've taken the effective date. Some of them were in 2015, 17, 18, and there's the one in 2022.
Okay, and those dates, those years are the date of purchase?
That's right.
Okay. Are they different for, I guess, different purposes?
It appears to be, yes.
In what ways?
Oh, the first one on the top is a mortgage insurance policy. So basically, it would pay off pay down the mortgage. I think it's some odd amount, like 72.05% or something.
I see.
But
Okay. Was there one for business?
I believe so, and I am unclear as I sit here if that's that $1 million one or not. So I'm sorry, there is one on the business where Eric and his business partner, if one passed away, then it would benefit the other and allow the other one to buy out the business from the estate of the other.
Okay, so it doesn't go to the spouse, but rather to the other business partner.
The business partner.
To buy out the spouse.
Yeah.
I see. Are you familiar with a company, life insurance company called True Stage?
Yes.
Is it some sort of business association with PenFed?
Yes.
Okay. To your knowledge, what is that relationship?
Well, True Stage is an insurance company, and they typically market their product to credit union members, all sorts of credit union members, different credit unions.
Do you know whether the defendant was a member of PenFed?
She was, yes.
How about, do you know whether Eric Richins was?
I know that he was not.
Okay. Direct your attention to States Exhibit 62. And what is that, just for the record?
These are the bank account statements for Kouri Richins at PenFed Credit Union, the account 9118, for the period starting in October of 2021. It's just through April of 2022.
And State's Exhibit 63. What is that?
This is a declaration of custodian of records, no records, and this is from PenFed Credit Union, stating that Eric Richins did not have any accounts at their institution.
Okay. Are you aware of an application from the defendant to True Stage for life insurance in January of 2022?
Yes.
All right. Direct your attention to State's Exhibit 17. What is State's Exhibit 17?
This is the application for True Stage individual term life insurance, TAT. And this is dated the end of January 28th or 29th of 2022.
And who's applying for what in this application?
This is for life insurance for Kouri Richins and for Eric Richins.
Now, is there something unusual about the information provided, contact information for each of those two applicants?
Yes.
Tell us about that.
The contact information is the P.O. box that Ms. Richins used for her business. Her email address is on there. There's no email address for Mr. Richins, and the phone number that's listed for Mr. Richins is not correct.
How is it different? Do you know off the top of your head?
Yes. It says 892. His number starts 792.
And then ends with the 9317?
That's correct.
Okay. To be clear, the mailing address is the business address for K. Richins Realty for both of them?
Yes, this was pre-populated. It
Okay.
appears to be pre-populated this way with Kouri Richins and her P.O. box in Kadmus.
And when is it effective?
This policy was effective February 2nd, 2022.
Okay. Direct your attention to State's Exhibit 65. Now, before I go there, I'm sorry, I skipped over something. Early on, we talked about docket 127.
Yes,
That was, if I remember correctly, that was Throckmorton's report.
that's right.
And in there, he has how many question samples?
3 questioned samples. Yes.
Okay, so 1 and 2 are the power of attorney we've already addressed.
That's right.
So question number 3 is,
It's the signature on this life insurance policy.
I see. And so is your understanding what?
He calls them simulated forgeries, and that they're probably not Mr. Richins' signatures.
Okay, so now let's go to State's Exhibit 65, if you would. What is State's Exhibit 65?
This is a letter from True Stage Insurance to Eric Richins at that P.O. Box 759, dated February 4th, 2022.
And what is it informing Eric Richins of?
This is a welcome letter. Thank you for choosing True Stage Life Insurance, and talking about the premium. The premium would be deducted from the checking account 6577, which is the Kouri Richins Realty account,
Okay.
on February 14th for $46.50.
And that's an automatic withdrawal?
That is.
Okay. Have you examined AFCU account for Richins Realty, that 6577 for December, January, February of December 21, January, February, March even of 2022?
Yes.
Okay. So in 6577, is there that automatic withdrawal that you were talking about?
There is in February, yes.
Is there any other insurance premiums that are paid from 6577?
No.
Okay. Now let's take a look at States Exhibit 64, and I'll let you just take a look at what 64 is and 37.
What was the second number, Mr.
37. Could you describe for the record, what is 64?
64 is part of December. So this is an America First Credit Union bank account statement from America First Credit Union.
Mm-hmm. Which account?
Eric Richins account 2204. So this is the joint account
Okay.
where the typical household expenses were paid. And it is for December 2021, pages, and it goes through, goes through March 1st of 2022.
Okay, so looking at those, are there any of the insurance premiums that you've mentioned before paid out of 2204?
The payments that had previously been made, historically been made, I should say, are paid here, but not that one.
But not the new one, just
Not the
all
new
the
one.
previous ones?
That's correct.
So, just a second, I have to steal my courage. Oh, okay. So we are looking at, in your chart there, I guess that you find evidence of payment of those top four in your chart?
I'm
From
not
the
sure which one.
2204?
The payment of the premium?
Yes,
Yes,
but not the bottom one.
that's correct.
Do you know if the defendant made any claims on those insurance policies,
Yes, she did.
particularly the true stage?
Yes, she did.
Okay. How does the claim process work?
Mr. Burris, you're getting back in front of that mic.
Oh, sorry.
Thank you, sir.
How does the claim process work?
A claim is made, the insurance company would initiate a claim, give it a number, and then proceed to do their due diligence.
Okay. A couple of things. Based on your experience and training with working with insurance companies, is there a convention for naming these claims?
Yes, everyone's got a little bit different process, but in this situation, there are two different claims, and we can see from the information contained in the diary that the insurance company kept, and also the name, the number of the claim. We can see what date it was opened.
I see. Okay, so in addition, is there any, are insurance policies treated differently if they're made, a claim is made on them near in time to when they're opened versus if you've had a policy intact for 10 years or something.
Yes, I worked on, I don't know, a few dozen death investigations, and what happens, every insurance company will have a different policy, but typically if a life insurance policy is taken out and there's a death of the insured within a certain period of time, usually it's a year or two, there's a standard death investigation that takes place. And I worked on many of those throughout my career.
Okay. I'd like you to take a look at what has been marked as State's Exhibit 18. Now, what is State's Exhibit 18?
This is notes for claim 2204-28003. So this would be the claim opened on opened on April 28th. It's probably the third one that they assigned that day or something.
Okay. And so do you know which policy this is referring to?
This one is the larger of the two. This is the $250,000 policy that from 2017.
Okay. And is this what you referred to earlier as a diary?
Yes.
Okay. I think we have an State's Exhibit 67. We just, at the beginning of the day, I think, offered State's Exhibit 67 as.
Yes.
And I don't know if you did.
It's right here.
I have.
And can you identify for the record what State's Exhibit 67?
Yes. This is a similar document. This is for the other claim, number 2204-22032. So this is the claim that was open on April 22nd, 2022, and this is the first one, and this is for the $100,000 policy.
And it was opened on April 22nd of 2022.
That's right.
Okay. Let's look a little closer then. First of all, with State's Exhibit 18, can you describe what this is recording and how it works with the business?
This is a chronological diary, just note-taking about the date and time of a call or a contact, and just some notes. So over time they can go back and refer to what happened and when.
I see. Now this is State's Exhibit 18 is referring to the 2017 policy.
That's right.
And it was made then by April 28th, so a week after the other one.
Yes.
Okay. In there, does the defendant ask some questions, or I guess is the insurance company asking the defendant some questions about the case?
Yes.
Do they want to know about fentanyl?
Yes. They needed the final death certificate showing the cause of death, and then they need to know if the fentanyl was prescribed.
And does the defendant respond to that?
She does. Toward the bottom, she said the fentanyl was not prescribed, so she can't give any information about it. She also added that she don't have any idea how did her husband got that.
Okay.
Just for the record, that's what it says. That's not my grammar.
Let's turn to State's Exhibit 67. Now, to be clear, this is the first in time request.
Yes, it is.
And the policy that she opened and I believe was effective, you said,
February
February?
2nd. Mhm.
Okay.
Yes.
At some point, I think in July of 2022, is there a conversation between the defendant and the insurance company about what's taking so long?
Yes. This would be, well, there were several conversations in July. They're talking about needing the medical records from the medical facility. And then finally in August, that they say, she called to know the status of the claim. And then they said that they had received the medical records from the clinic.
Okay, I wanted to.
All of her properties,
Yes, sir.
and then there were other investors who contributed the funds basically for the rehab.
I see, okay. Was there something else different in this application that you garnered from all the financial records?
I'm sorry, I didn't understand your question.
That's the way I roll. Okay. Was there something else that you found in reviewing all of the documents, not just the loan documents, that distinguished this purchase as opposed to the ones that had gone before it? Involving, all right, how about this? Do you know if C&E was involved in this project?
C&E was involved in this project.
Okay. And what did you discover about C&E's involvement?
After the acquisition of the Oakley property, the Franzen Lane property, C&E, there were several checks from C&E that were deposited to the Kouri Richins Realty account. And they specifically have a memo on them that tie them to this property. And so over the next, between October and when this property was sold in March of 21, there are a series of checks. I think there are 6 or 8 checks that are about $133,000, I think.
Was this property ever sold?
Yes, it was.
When?
In March of 2021.
Okay. What happened to the proceeds from that sale?
This was a property where the net proceeds were about $466,000, which came into the Kouri Richins Realty account, that 6577 account. And
Okay.
then from that, $217,000 was paid directly to C&E.
Okay.
And then there were some other payments, transfers out from the account that were associated with this property as well, and left her with about, around $200,000 in net proceeds.
In your examining of all the evidence in this case, were there other things that you looked at to inform your examination that took place in October of 2020?
There were other things in October of 2020, yes.
Did you take a look at State's Exhibit 22, if you would? Are you familiar with that document?
Yes.
Could you explain what it is?
This is an intake form from a divorce attorney describing that Eric Richins was wanting to consult with his attorney on a potential divorce, and it's dated October 8th of 2020.
In the wake of that, are you aware of any other instruments that were created out of that?
Yes, there are the notes that the attorney appeared to have handwritten during the course of that first meeting.
Were there financial arrangements made after that meeting that you're aware of?
Yes, the notes indicate that there was some new information by Mr. Richins that there was the HELOC had been taken out on the home, that as if this was new, and then from this he set up the Eric Richins Living Trust and also a will.
Was there something dramatically different about the trust situation as before?
Ms. Richins was not the beneficiary of his estate. It was to be for his children, and the trustee was going to be his sister, Katie.
So I'd like to go back to, I think it was 70. It should be the HELOC loan balance for Willow Creek, is that right? Yeah. By August of 2020, what was the balance?
August of 2020, $246,931.
Okay. Is there a significant, well, up until that point, how was there money being paid on that debt?
Yes, they were the interest-only payments. The minimum payments were about $900, $1,000, something like that, that were made every month.
Did something different happen in October of 2020?
Yes.
What happened?
There's really the first significant payment, and it's $50,000 on October 12th.
Do you know what the source of that fund was?
Yes, Ms. Richins had sold the Cleveland Avenue house in Salt Lake, and from that she received net proceeds of about $63,000. There was a transfer, and then this $50,000 was sourced from that.
Okay, on October 12th.
Yes.
Okay. Bringing the balance to approximately what?
$196,000.
Do you know whether in October she was in a financial position to just pay that $196,000 off?
She was not.
Let's go into 2021. I guess we've still got the timeline up. Direct your attention to timeline. And could you describe for the record a summary of what purchases, et cetera, took place in 2021?
Yes. So she acquired a property in Heber City before she got the proceeds from Branson Lane. And then after that, she acquired a number of properties throughout the summer especially, and then ending the year acquiring 3 on the same day in November. And I think there may be another property that she was working on that I don't have on here, but all in all, she had about 15 properties in 2021.
So, did she go to the same lenders for all of these 15 properties?
No, there is some consistency in the lenders, but she did diversify a little bit.
Okay. Can you tell the court some of the lenders that you have found that she used?
So she primarily used the Sierra West, and that's pretty consistent through here. And those investors who would have been taking second, third, or fourth position were pretty consistent as well.
And those are like Cocker hands?
Cockerhands, Ellis, Soto, Lieb. There's a number of them.
Okay.
And then she also went to a company called Ironbridge, a company called Boomerang. She did 4 projects with Boomerang.
I see. So let's take, first of all, when did she go to Ironbridge and when to Boomerang?
Those were in the summer of 2021.
Okay. And Ironbridge, how would you describe what Ironbridge is or does?
They appear to be a hard money lender. The terms are somewhat more flexible than typical hard money lenders, but the interest rates the interest rate on that loan, I believe, is 13%. Was 13%.
And in 2021, is that high?
That would be high, yeah.
So, how did the application process go between the defendant and Ironbridge?
There is an original application that is submitted. It appears to be online. I don't know that for sure, but it appears to be online. And then there was a series of emails back and forth where the person analyzing the loan or underwriting the loan is asking her to submit some additional documentation.
Okay. Can you take a look at State's Exhibit 58, please?
5-8.
Yes, 5-8. State's Exhibit 5-8. Is that what you were talking about? Some email going back and forth between Ironbridge and the defendant?
Yes.
Okay. Is there something about a bank statement in there?
Yes. It asks for personal bank statements, the most recent.
Okay. Based on your experience and training, why would they want to know that stuff?
Typically, they'd call that proof of funds. They want to, they need to verify. In banking terms, it's KYC, know your customer. Every financial institution needs to know and verify the individual and entities that they're dealing with.
I'd like you to take a look at State's Exhibit 59, if you would. What is State's Exhibit 59?
This is a secured promissory note for what I call the 299 house in Heber with Ironbridge.
I see. And first of all, this is Kouri Richins Realty purchasing this. Is that what it?
That's right. And I misspoke. This is 10%. I had misstated the interest rate earlier.
And what is the amount that they're loaning?
$346,500.
When?
In this is in July of 22.
20.
I'm sorry, July of 21. Sorry. It's signed July 7th, 2021.
Now, did you examine a bank statement from Ironbridge purportedly given to them by the defendant?
You mean from Ironbridge, meaning?
It was obtained from Ironbridge, but submitted to it that it used to.
It was part of the Ironbridge loan information that we received. Yes.
Okay. Would you take a look at State's Exhibit 11, please? What is State's Exhibit 11?
This is America First Credit Union bank account statement for May 31st, 2021 for Kouri Richins Realty, account number 6577.
And do you know where this was sourced from?
This was sourced from Ironbridge, as indicated by the number on the top.
Okay. And how do you know it's Kouri Richins Realty?
The header on the bank account statement purports to be Kouri Richins Realty.
I see. And then in the body of that statement, does it give the amount in the bank account?
Yes.
What is that?
The summary of the accounts for the 3 accounts that are included in this bank account statement is $210,898.61.
Okay.
That's the ending balance.
So I'd like to direct your attention now to State's Exhibit 12. What is State's Exhibit 12?
This is the America First bank account statement for Kouri Richins Realty for that same month, May of 2021, for account 6577. This is the actual statement that we received from America First Credit Union.
In what way is it the same, and in what way is it different from the State's Exhibit 11?
The header is the same, but the body, the transactions that are contained are different.
What is the total balance?
The total balance is $15,609.
All right, let's take a look at State's Exhibit 13. What is that?
This is the actual bank account statement for C&E Stone Masonry, ending in 7664. This was the document that was received directly from America First Credit Union.
And how do you know it's C&E's?
The header indicates that it's C&E's, and the transactions appear to be consistent with what C&E would be doing, and it matches the bank account statement that Iron Bridge produced, but it has the different header on it.
So let me make sure I understand this. 11 has a header from her account, Kouri Richins Realty, but yet the body of C&E's May 31st bank statement.
That's correct.
I'd like you to take a look at State's Exhibit 60. That's 60. I believe that's an email exchange. Is that right?
That's right.
What's the subject?
Quick question.
Okay, and is the quick question physically below the response? Is that
Yes.
okay? So what is the quick question?
This is from Mr. Amy, I don't know how to say that, from Iron Bridge, emailing Ms. Richins asking for an explanation about her credit score, the credit cards, and referencing that bank account statement.
Okay. Is he perplexed? I mean, or
Check
is,
speculation.
Sustained.
specifically, what does he say to her?
He says when he first ran her credit, it was lower than expected. There were some delinquencies on the credit cards, but he can see from the bank account statement that she provided that she's got plenty of money in the bank to cover expenses.
How does she respond to that?
Would you like me to read it?
Yes, please. If you just read what she says to that question.
She says, "Hi Richard, hope you had a great 4th of July weekend. Yes, sure. Everything is paid off now. It just probably hasn't updated. I recently learned about all of this as well, LOL, and then my husband decided to explain to me that this was his doing a while ago. We are in the process of separation for one of many reasons, but this is one of them. To keep it short and sweet, LOL. It's been crazy to say the least. I look forward to working with you guys on our first and hopefully many projects."
Okay, you said she obtained some loans from Boomerang 4, I believe you said.
Yes.
Okay. I'd like you to take a look at State's Exhibit 14, if you would. What is State's Exhibit 14?
This is from Boomerang, but it's an America First Credit Union bank account statement for Kouri Richins Realty, account 6577 for June of 2021.
And how do you know it's Kouri Richins Realty?
Which is the header.
And what is the balance on the?
The balance, the ending balance is $702,831.
Okay. Let's take a look at State's Exhibit 15 then. And what is that?
This is the actual statement that was obtained directly from America First Credit Union for Kouri Richins Realty, account 6577 in June of 2021.
And the header says Kouri Richins and Realty and the 6577?
That's right.
What is the ending balance?
Ending balance is $15,339.
Okay, let's take a look at State's Exhibit 16. And what is that?
This is the actual bank account statement that was obtained directly from America First Credit Union for C&D Stone Masonry LLC, account 7664 for June of 2021.
And it presumably says C&E and 7664
Yes.
in the header?
In the header, yes.
What's the ending balance?
The ending balance is $702,831.
That's the same as State's Exhibit 14?
The one that was issued to Boomerang, or submitted to Boomerang, yes.
Okay. So once again, cut and paste of header for Kouri Richins Realty and the data, the amount of money on hand from C&E.
That's correct.
Direct your attention to State's Exhibit 61, if you would. Could you describe for the record what this is?
Yes, this is from Boomerang. This is a document that came directly from Boomerang. It's a kind of an internal review, a summary of a potential loan, kind of ahead of that would be prepared in the midst of the approval process.
I see. And what was the property?
This is for the 75 East Midway House, I think. Yes. The smaller Midway House.
Okay. And in there, does it reference, well, first of all, how much is the loan amount?
The loan amount on this is $454,750.
And does it talk about the defendant's liquidity?
It does, on the second page.
And what does it say about it?
Let's see. It says, under liquidity and net worth, Kouri has liquidity in the amount of $702,000. She has a net worth of $2,719,000 made up of cash, securities, life insurance, retirement funds, and real estate investments.
And so that number 702,000 is that same figure from C&E that she's submitted in State's Exhibit 14?
Don't remember the exact exhibit number, but yes, that number is drawn from that bank account statement that was actually C&E, not Kouri Richins Realty.
Did you find any other instances where this similar type of cut and paste header with some other account was submitted to lenders?
Yes.
How many times did you find that?
I found 6 so far.
Including these two?
Yes.
like you to take a look again at the timeline.
Yes.
Okay, so these purchases in 2021, you've already mentioned, it's 15, more and more. Did any of them sell?
Yes, great number of them did, yeah.
Okay, tell us about that.
Well, as like the Mill Creek House, for example,
Mhm.
that was acquired in the spring. That's a home in Salt Lake County, and so there was a primary lender on that, and multiple investors who gave Kouri Richins Realty money for the rehab costs. And then when it was sold, most of those were paid from closing, like at the title company. Some were not. Some came out of Kouri Richins Realty's net proceeds.
Okay. So she's turning over property, isn't she gaining money by doing this?
Yes.
Okay, what's happening to her debt load?
That was increasing, especially she started in the middle of summer of 2021. She started acquiring personal property loans that they're not secured by real property and were secured by advanced, her future receivables.
Okay, is Greengrass holding one of those?
Yes.
Okay, turn your attention to State's Exhibit 20. So could you, first of all, tell us what State's Exhibit 20 is?
This is a revenue purchase agreement dated, it's in September of 2021.
And could you explain the basic terms of this?
This is an agreement with Kouri Richins Realty and then some other companies pledging $87,000 of advance receivables for $60,000 upon execution of the agreement, and e-signed by Kouri and Doreen Kouri.
Okay, so let me make sure I understand this. So she's saying, I will give you $87,000 of money I haven't earned yet, but I'll pay it to you in the future if you give me $60,000 now.
Yeah, and what's represented here that it's been earned and it's going to be coming in, but it's not in yet.
I see.
So she's saying, I'll pay you back $87,000 for $60,000 now.
I see. Okay. And what did it obligate her to pay?
$5,438 every week.
Did she pay that?
For a series of payments, yes.
Okay. How much did she pay that you're aware of?
I think she paid about $20,000. I'm not exactly sure of the amount on there, but she paid about $20,000 and then defaulted in December.
Did something happen as a result of that default?
Yes, they filed suit in New York.
Okay, the state would direct your attention to State's Exhibit 21. Could you describe for the record what State's Exhibit 21 is?
This is the summons and the verified complaint associated with that lawsuit.
And so in a lawsuit like that, there's some alleged facts?
Yes.
Okay, so I direct your attention to page 5, fact number 11.
Yes.
And what is the allegation there?
That she did pay $21,752, leaving the balance of unremitted receivables of $65,248. And then there's default fees of $2,500 and attorney's fees of $19,574.
Did you find any other agreements or attempted agreements between the defendant and these type of lenders?
Yes, I found several.
Okay, what are they?
QFS Financial is one she entered into where she pledged $167,000 for future receivables for $105,000.
Okay.
That was the largest one by far. Most of them are in the $20,000 to $30,000 range.
Is Blue Bridge something like that?
Blue Bridge is one, Delta Bridge Funding, Zahav, Asset Management, Crown Funding. There are over a couple of dozen, over a dozen, yeah, about 20 or 25.
You mentioned early on that the defendant had an account with Navy Federal.
Yes.
Navy Federal, do you know what kind of account she had there?
At Navy Federal, she had a checking, a savings, and a credit line.
Okay. During the period of August to December of 2021, do you have any idea? Well, first of all, what was the maximum amount for that, the credit limit for that revolving line of credit?
That was $15,000.
For that period, August 2021 to December of 2021, do you know what her balance was, relatively speaking?
Well, it was almost maxed out most of the time. During that specific review period, I would say, I think that's about $13,000.
Okay. Can you take a look at State's Exhibit 26, please? Is that a multi-page document?
It is.
What are they?
These are the bank account statements for the account ending in 0060, starting in July of 21. Ending in March of 22,
Okay.
and for Kouri Richins.
Does the statement include the balance on revolving credit?
Yes.
Okay. And throughout that time period I've just mentioned, it's more or less maxed out?
Yes.
Okay. I'd like you to take a look at State's Exhibit 27. Do you know what those are?
Yes.
What are these?
These are checks from the account of Kouri Richins at Navy Federal, and these checks were deposited into the account of K. Richins Realty. I believe all of these were deposited into that account, and none of them cleared.
Okay. Let's just do an exercise on one of these. Let's take a look. What's the check number on the very first one of State's Exhibit 27?
Check 271.
And when is that?
The date on the check is 8/28/2021.
Can you find that transaction in State's Exhibit 26, which is those statements for that appropriate time period?
Yes. Yes. It's on, the Bates number ends in 99 at the top, and it was returned on 8/31/21.
Okay. So that check, and how much was that check for, that particular one?
$2,100.
And all of the checks then in State's Exhibit 27 are similar in that way?
That's right.
So now we're at December of 2021, the end of the year there. What is her financial status at that point?
All in all, with all of the property, she had acquired and sold a number of properties. She retained several as rentals. she still had loans on those properties. So at that time, it was about 4 or 4.5 million that she still owed on those. Well, the trust deeds, she had paid some on them, but there's that. And then with all of the personal property loans, it's hard to tell for sure, but I think somewhere around $500,000 or $600,000 she owed on those personal property loans as well.
Now, you mentioned that one, for example, was, I think it was Greengrass that
That's right.
required her to pay $5,000 weekly?
5,438 weekly, yes.
Okay. Were there some that were daily?
Yes.
And how many payments did she have to make for the month of December, for example?
She made about over 90 payments on debt. You know, toward there's a difference. There's the debt load and there's the debt service. So she owed the amounts that I stated, and then the debt service are the payments that she paid on that debt. And they're a little, well, there's over 100 that she paid payments.
So for the month of December, how much debt service is just what she paid? Not necessarily. It could be the same as debt load, but
In this instance, no, it's different.
okay.
Yeah.
What was the debt service for the month of December? Do you know?
It was over $300,000.
Okay. I'd like to take a look at, this is back to State's Exhibit 69. I'm going to move on to the next chart. Can you describe for the record what this next summary chart is?
This is the debt payments that she made during these months.
Once again, this is debt service, not debt load.
That's right.
Okay.
This is not the amount of debt she possessed. This is the amount of payments that she made on that debt.
Okay. And for the months of
June of 2021 through February of 2022. And I do need to make a note that in preparing for this hearing, I've noticed that in December of 2021, I made a duplication. So we need to reduce that number by about $44,000 in December.
okay.
It's still about $320,000.
Now, in January and February, it appears to go down. Is that right?
That's right.
Let's once again look at the same information expressed differently. You described this for the record. This is the third chart on the PowerPoint.
So this is drawn from that previous data. And so it's just showing it in a pictorial format.
It seems after December, it seems to be going through the floor.
That's right. These are the payments that she made on the debt. She did pay off one of her lenders, one of the personal property loans. She did pay that off in January, and that was about $19,000. But mostly because of what had happened in November and December, so many transactions had been returned and not cleared by the bank. They did not. Some of them continued to try to draw in January and February, but they were unsuccessful. And so those payments were not made.
So this doesn't depict her debt load, the amount of debt she has, but rather she's just not paying.
That's correct. At least from the accounts I have. At least from the accounts that I have reviewed.
Okay. Sometime around this time period, did she take on another project?
Yes, she did.
Is it different than previous projects?
Are you talking about the Legacy Way project, the large house?
Oh, okay, yes. Tell me
Yes.
about that.
She, the first Rep C which stands for Real Estate Purchase Contract, was in December of 2021, and it's a very large property on Legacy Way in Midway, and that's the property that she did end up closing in March 22.
Okay. It begins though in December and concludes when in March?
Well, the settlement statement I've seen is dated March 4th. Some documents were signed March 4th, some were signed on the 7th and recorded on the 8th of March.
How is this different from any of the other previous projects?
It was an unfinished house and just quite large, a very, very ambitious project. The purchase price, I believe, was $2.9 million.
What was its state of repair?
It was under construction, so it didn't have much inside, down to the studs, exposed wiring, things like that.
So, did she ever, that you're aware of, give an estimate to lenders about what she anticipated those costs would be to rehab it?
Yes.
What was that?
Her estimate was between $3 and $4 million to rehab that property once it was acquired.
And how did she obtain this property?
Through hard money lenders.
All borrowed then?
Pardon me?
All borrowed?
Yes, all borrowed.
Okay, I want to talk about life insurance. Have you had the opportunity to look at life insurance policies that were owned by the Richins family?
Yes.
Do you know about how many there were?
I think there were 6.
I see. Okay. This is the fourth chart of 4 from States Exhibit 69 PowerPoint. Can you describe what that is?
Yes, these are the life insurance policies on Eric Richins' life, and I've taken the effective date. Some of them were in 2015, 17, 18, and there's the one in 2022.
Okay, and those dates, those years are the date of purchase?
That's right.
Okay. Are they different for, I guess, different purposes?
It appears to be, yes.
Okay. In what ways?
Well, the first one on the top is a mortgage insurance policy. So basically, it would pay off pay down the mortgage. I think it's some odd amount, like 72.05% or something.
I see.
But
Okay. Was there one for business?
I believe so, and I am unclear as I sit here if that's that $1 million one or not. So I'm sorry. There is one on the business where Eric and his business partner, if one passed away, then it would benefit the other and allow the other one to buy out the business from the estate of the other.
Okay, so it doesn't go to the spouse, but rather to the other business partner.
The business partner.
To buy out the spouse.
Yeah.
I see. Okay. Are you familiar with a company, life insurance company called True Stage?
Yes.
Is it some sort of business association with PenFed?
Yes.
Okay. To your knowledge, what is that relationship?
Well, True Stage is an insurance company, and they typically market their product to credit union members, all sorts of credit union members, different credit unions.
Do you know whether the defendant was a member of PenFed?
She was, yes.
How about, do you know whether Eric Richins was?
I know that he was not.
Okay. Direct your attention to States Exhibit 62. And what is that, just for the record?
These are the bank account statements for Kouri Richins at PenFed Credit Union, the account 9118, for the period starting in October of 2021. It's just through April of 2022.
And State's Exhibit 63. What is that?
This is a declaration of custodian of records, no records, and this is from PenFed Credit Union, stating that Eric Richins did not have any accounts at their institution.
Okay. Are you aware of an application from the defendant to True Stage for life insurance in January of 2022?
Yes.
All right. Direct your attention to State's Exhibit 17. What is State's Exhibit 17?
This is the application for True Stage individual term life insurance, TAT. And this is dated the end of January 28th or 29th of 2022.
And who's applying for what in this application?
This is for life insurance for Kouri Richins and for Eric Richins.
Now, is there something unusual about the information provided, contact information for each of those two applicants?
Yes.
Tell us about that.
The contact information is the P.O. box that Ms. Richins used for her business. Her email address is on there. There's no email address for Mr. Richins, and the phone number that's listed for Mr. Richins is not correct.
How is it different? Do you know off the top of your head?
Yes. It says 892. His number starts 792.
And then ends with the 9317?
That's correct.
Okay. To be clear, the mailing address is the business address for K. Richins Realty for both of them?
Yes, this was pre-populated. It
Okay.
appears to be pre-populated this way with Kouri Richins and her P.O. box in Kadmus.
And when is it effective?
This policy was effective February 2nd, 2022.
Okay. Direct your attention to State's Exhibit 65. Now, before I go there, I'm sorry, I skipped over something. Early on, we talked about docket 127.
Yes,
That was, if I remember correctly, that was Throckmorton's report.
that's right.
And in there, he has how many question samples?
3 questioned samples. Yes.
Okay, so 1 and 2 are the power of attorney we've already addressed.
That's right.
So question number 3 is,
It's the signature on this life insurance policy.
I see. And so is your understanding what?
He calls them simulated forgeries, and that they're probably not Mr. Richins' signatures.
Okay, so now let's go to State's Exhibit 65, if you would. What is State's Exhibit 65?
This is a letter from True Stage Insurance to Eric Richins at that P.O. Box 759, dated February 4th, 2022.
And what is it informing Eric Richins of?
This is a welcome letter. Thank you for choosing True Stage Life Insurance, and talking about the premium The premium would be deducted from the checking account 6577, which is the Kouri Richins Realty account,
Okay.
on February 14th for $46.50.
And that's an automatic withdrawal?
That is.
Okay. Have you examined AFCU account for Richins Realty, that's 6577 for December, January, February of December 21, January, February, March even of 2022?
Yes.
Okay. So in 6577, is there that automatic withdrawal that you were talking about?
There is in February, yes.
Is there any other insurance premiums that are paid from 6577?
No.
Okay. Now let's take a look at States Exhibit 64, and I'll let you just take a look at what 64 is and 37.
What was the second number, Mr.
37. Could you describe for the record, what is 64?
64 is part of December. So this is an America First Credit Union bank account statement from America First Credit Union.
Mm-hmm. Which account?
Eric Richins account 2204. So this is the joint account
Okay.
where the typical household expenses were paid. And it is for December 2021, pages, and it goes through, March 1st of 2022.
Okay, so looking at those, are there any of the insurance premiums that you've mentioned before paid out of 2204?
The payments that had previously been made, historically been made, I should say, are paid here, but not that one.
But not the new one, just
Not the
all
new
the
one.
previous ones?
That's correct.
So, just a second, I have to steal my courage. Oh, okay. So we are looking at, in your chart there, I guess that you find evidence of payment of those top four in your chart?
I'm
From
not
the
sure which one.
2204?
The payment of the premium?
Yes,
Yes,
but not the bottom one.
that's correct.
Okay. Do you know if the defendant made any claims on those insurance policies,
Yes, she did.
particularly the true state?
Yes, she did.
Okay. How does the claim process work?
Mr. Burris, you're getting back in front of that microphone.
Oh, sorry.
Agency.
How does the claim process work?
A claim is made, the insurance company would initiate a claim, give it a number, and then proceed to do their due diligence.
Okay. A couple of things. Based on your experience and training with working with insurance companies, is there a convention for naming these claims?
Yes, everyone's got a little bit different process, but in this situation, there are two different claims, and we can see from the information contained in the diary that the insurance company kept, and also the name, the number of the claim. We can see what date it was opened.
I see. Okay, so in addition, is there any, are insurance policies treated differently if they're made, a claim is made on them near in time to when they're opened versus, if you've had a policy intact for 10 years or something.
Yes, I worked on, I don't know, a few dozen death investigations, and what happens, every insurance company will have a different policy, but typically if a life insurance policy is taken out and there's a death of the insured within a certain period of time, usually it's a year or two, there's a standard death investigation that takes place. And I worked on many of those throughout my career.
Okay. I'd like you to take a look at what has been marked as State's Exhibit 18. What is State's Exhibit 18?
This is notes for claim 2204-28003. So this would be the claim opened on opened on April 28th. It's probably the third one that they assigned that day or something.
Okay. And so do you know which policy this is referring to?
This one is the larger of the two. This is the $250,000 policy that from 2017.
Okay. And is this what you referred to earlier as a diary?
Yes.
Okay. I think we have an State's Exhibit 67. We just, at the beginning of the day, I think, offered State's Exhibit 67 as.
Yes.
And I don't know if you did.
It's right here.
I have.
And can you identify for the record what State's Exhibit 67?
Yes. This is a similar document, but this is for the other claim, number 2204-22032. So this is the claim that was opened on April 22nd, 2022, and this is the first one is for the $100,000 policy.
And it was opened on April 22nd of 2022.
That's right.
Okay. Let's look a little closer then. First of all, with State's Exhibit 18, can you describe what this is recording and how it works with the business?
This is a chronological diary, just note-taking about the date and time of a call or a contact, and just some notes. So over time they can go back and refer to what happened and when.
I see. Now this is, State's Exhibit 18 is referring to the 2017 policy.
That's right.
And it was made then by April 28th, so a week after the other one.
Yes.
Okay. In there, does the defendant ask some questions, or I guess is the insurance company asking the defendant some questions about the case?
Yes.
Do they want to know about fentanyl?
Yes. They needed the final death certificate showing the cause of death, and then they need to know if the fentanyl was prescribed.
And does the defendant respond to that?
She does. Toward the bottom, she said the fentanyl was not prescribed, so she can't give any information about it. She also added that she don't have any idea how did her husband got that.
Okay.
Just for the record, that's what it says. That's not my grammar.
Let's turn to State's Exhibit 67. Now, to be clear, this is the first in time request.
Yes, it is.
And the policy that she opened and I believe was effective, you said,
February
February?
2nd. Mhm. Yes.
At some point, I think in July of 2022, is there a conversation between the defendant and the insurance company about what's taking so long?
Yes. This would be, well, there were several conversations in July. They're talking about needing the medical records from the medical facility. And then finally in August, that they say, she called to know the status of the claim, and then they said that they had received the medical records from the clinic.
Okay, I wanted to. All right, so they finally get them when? The medical records?
That's, according to this, is 8/15/22.
In the, you see the entry 822, the bottom of page 2?
Yes.
Are they talking about the medical records there, that last entry?
It looks like, yes.
And that they received them on what day?
Well, this is when they received the invoice.
Oh, it's the invoice, so the payment. All right, so do they describe what is important to them as far as this investigation in at least one of those 822 entries?
Yes. Yes. It looks like they received the records on 8/2 and 8/11. I don't know if that matters. Okay, yes, they received the 36 pages of records on 8/11. And then there's substance use other than prescribed. It's marijuana once or twice a year.
Okay.
And no concerns about substance abuse in the household.
You have a moment, Your Honor.
Yes.
That's all the questions I have.
Who's doing the question? It's me. Ms. Nestor, left with me. How much time do you think you have with Ms. Arrington?
30 minutes.
Okay. Do you have a possible answer?
Not law enforcement at this time.
I don't think he's ever been law enforcement, but that's true.
And how did you know Mr. Gabler?
We've been colleagues for 30 years or so.
And by colleagues, do you share office space? Do you work together on cases just randomly, or what do you mean by colleagues?
No, I have worked on the same cases that he has worked on. I would not say we've ever worked on cases together.
Okay. And he approached you and asked if you would be interested in working for Eric Richins' family, who was dealing with trust issues, right?
With the trust, the Eric Richins Living Trust, yes.
Who's the trustee of the Eric Richins Living Trust?
Katie Richins Benson, his sister.
And so would she have been the individual basically responsible for paying you as the trustee?
Yes.
And did you meet with her?
I don't know that I ever met with her. We had phone conversations.
Okay. And did you have a contract of employment with her or with the trust?
An engagement letter, yes.
And what did they agree to pay you to help them?
My hourly rate and, yeah,
How much was that?
$325 an hour.
And I believe you said you worked for them up until the county attorney approached you. Is that right?
That's right.
So how long a period of time did you work solely for the trust?
I don't remember when I first started working for them. In the summer. It was in the summer, I believe, of 22.
So a few months after Mr. Richins had passed.
Something like that. I can get that exact date for you.
Okay.
Something like that. And then toward the fall of that year, they engaged in some litigation, and I was pretty much out of the picture at that point.
So maybe 5 or 6 months you think you worked for them?
Probably 4 or 5, yeah.
And do you remember a total how much they paid you during the time you were employed by them?
I think it was about $9,000.
And during that time, did they provide you with records to analyze?
I did have some records, yes.
Right. And so these are being produced to you by Eric Richins' family.
That's right.
And that would include these life insurance documents?
I did have some. Whether or not they're this, I honestly don't remember if it includes this one. I don't think it did. There were several New York life insurance policies that I reviewed.
Do you know how they obtained those records before they gave them to you? Are you aware? You may or not have a copy.
I don't know.
What other records did the Richins family give you to analyze?
I had some of the C&E Masonry bank account records. I had some tax returns. I know I had some other things. I had some odds and ends. So nothing, and I do not know how they obtained them.
And then how did it come about that you switched from working from Eric's family to the prosecution team in this case?
Well, in my view, they are separate entities, separate cases, separate engagements, and I did not feel like I could work on both. And at that time, when I was engaged by Summit County, I had not had any contact, well, I shouldn't say any. I had really not had much, if any, contact since like the fall. I did have a Zoom call with their counsel where they just kind of wanted to see where I had left off, but the complaint that they filed doesn't include any of my work.
And the complaint that they filed is basically an effort to make sure that Kouri does not get a single penny from Eric Richins' trust, right? Is that your understanding of the litigation?
I actually don't know much about that litigation, and on purpose I have tried to ignore it. I try to stay in my lane and in my box, and this is the box I'm in, and so I really don't know the status. I don't know what's been happening there. My overall understanding is they were trying to enforce the trust, the Eric Richins Living Trust, and associated documents. That's a weird way to say that, but that's my understanding.
And when you were in their box, when you were in the box with the trust, was it your understanding that Kouri Richins was aware that a trust had been created before Eric passed?
I was under the impression of the opposite, that she did not know about the trust. And whether or not she knew or didn't know, I really do not know the answer to that question.
So you've not reviewed any police reports in this case that talked about interviews of Katie the morning of Eric's death?
I know that there were some that took place, but I have purposely not reviewed them.
Okay, so you don't have personal knowledge one way or the other about whether Kouri knew this trust was in place before Eric died.
I cannot testify one way or another about that.
Okay. Did Todd Gabler ever give you any documents to analyze, or it all came from the attorneys at the trust?
I didn't get anything from the attorneys.
Where did you get the documents from the trust?
I believe I got everything from Katie.
From Katie, the sister.
I believe so.
Okay. All right. Are you still retained in any way by the trust?
No. I haven't engaged in conversation with them. I haven't responded to anything for better part of a year.
Okay. Did you review new documents before you testified today that you did not review before the detention hearing?
Yes.
What are the new documents you reviewed before today?
We have more bank account statements. There are loan documents that I did not have before, and that includes the promissory notes. And I know that payment ledgers have been requested, and there's very little of that due to the nature of the loans. I searched and obtained many more deeds in South Carolina and in Utah, and the UCC filings of the personal property loans, the unsecured loans, the insurance documents. I'm sorry, I'm getting a little conversational, but at the detention hearing, it was early in the week, say a Tuesday, for example, and most of the documents, the financial documents that I reviewed, I had for just a couple of days.
Okay.
Literally.
I want to talk about these properties that you've looked at as far as Ms. Richins. It appears from your testimony with the county attorney that you were looking at the debt that those properties put her in. Is that right?
Yes, and I did testify about that exact point at the detention hearing, because at that time, that's all I had access to were those recorded documents. So I could see the amount of the trust deed, and I did acknowledge that that does not necessarily represent what she owes on it, but what she encumbered. That's why I'm calling it an encumbrance.
So these charts that went up dealt with what she owed on the property to the best that you could determine looking at publicly available records, right?
Not necessarily. The timeline chart that has all the colors, I mean, that has a date, well, it has a point at which she no longer owned it. Her name is no longer on that.
Okay.
And so that represents that she no longer had that debt.
Successfully flipped that property, right?
Successfully would be a judgment call, and I've not been asked to give opinions.
Okay. All right, so let's talk about equity.
Okay.
When someone owns a home, you have what the home is worth when you buy it, but then you put money down on it, you pay money towards your mortgage, and at some point you build up something called equity in your house, right?
That's true.
And when you have a lot of equity in your house, you can go, like she did on their house in Willow Creek, right? And go, I say to a banker, hey, I have this property that has about $600,000 worth of equity in it. Can I borrow $50,000? And what is the banker likely to say to that?
A banker's likely to look at a lot of factors, right? Go through some due diligence. Given a lot of different factors, probably going to say yes.
Right. Because equity has value.
That's true.
And it's part of your net worth.
That is true.
So when you're evaluating someone's net worth, you're looking at their debt for sure, but you're also looking at things they have that have value.
That's true.
Their jewelry, right?
That's true.
Their artwork,
Yes.
their stocks and bonds,
Yes.
their equity and property.
Yes.
You were not asked to make that evaluation by this county attorney's office, correct? Because I don't see that you did a net worth evaluation here.
I have done some. There's some holes in it. There's some holes in it. So.
Okay. So you haven't today put on evidence of Ms. Richins' net worth?
No, and there are a lot of things that I don't know, like I'm aware that she has a tax liability, and I know that I can estimate a range, but I don't know how much that is, and that would factor into her net worth.
And I know you're an experienced accountant. You would never make a statement about someone's net worth if you knew you were missing critical documents to make that evaluation. Fair?
I would definitely put a footnote on that.
Okay. As far as the profits that Ms. Richins made when she flipped these houses, unless you have the settlement statement, the closing statement, all the records, it's not always possible to tell what her profit margin was, is it?
Well, profit margins, the answer is maybe yes, maybe no. Do you mind if I explain?
Go ahead.
Okay. For example, Ms. Richins has a schedule that she had submitted to some lenders that talked about the projects that she'd done. And she included in there is the acquisition price, the rehab budget, what it was sold for, and her profit. And I've gone through a few of those, and they're not accounted for correctly. The sales price does not reflect what her margin is. You asked me about margin, and the margin is not correct. Her profit is not correct on that. What I can tell you, the answer to your question, is I do have the settlement statements on a lot of those. And the settlement statements are prepared by the title company at closing. And so that'll go down the sales price and the deductions from that, like the property taxes that need to be paid, the encumbrances, like the first trustee, the second, if there are more, some other agreed upon amount that needs to be on one side of the ledger or another. And then we get to a net proceeds amount. And then I can go to her bank account statement and I can see those funds hit the bank account statement.
Okay.
The way she had borrowed money, not everybody who was involved, I use that term as not everyone who had participated financially in that project would have had a deed filed that would have them hit the settlement statement. So once the funds hit her bank account, then she also had to pay out some funds associated with that property.
So once she flipped a property, paid off everybody that helped her out to buy it or rehabbed it, whatever's left in her pocket after she pays everybody is her profit.
That's right.
And you can't say that, what that amount was on every one of these properties, can you?
Not every single one, but I can on many.
And if you, as I understand it, she was servicing some pretty major debt and servicing it, right? Sending those checks out.
That's correct.
Check after check after check, making payment to her lenders, right?
Yeah, they mostly were auto withdrawals, but yes.
And out of all those properties that you have with the pretty colors on your chart, how many of those got foreclosed on before she flipped them?
Before she flipped them? Well, she doesn't own any anymore.
So none is the answer, right?
None then.
So she successfully purchased the property, got what she needed to rehab it, flipped it, and it never went under on any of those properties, except for after she got arrested, before she was arrested.
And again, I'm gonna not use the word success because everyone's got a different version of what that term means. I think what you're trying to say is, did she end up selling them? Yes, she did.
Okay. All right. Did you ever interview any of Ms. Richins' hard money investors?
Yes.
Right. Did any of them, other than Greengrass, did any of them ever file suit against her for defaulting on their deal, as far as you know?
I do not know that.
Okay. All right. The joint account with Eric and Kouri that they paid their bills out of and their kids' soccer fees and things like that, did you ever compare the deposits from Eric into that account versus deposits from Kouri into that account?
I'm aware of how much was kind of coming and going.
And who put more money in that account?
Eric's paycheck was auto-deposited there, and that was more than Kouri's. There were funds coming and going, and so, but they were for different purposes.
Would you
so-
disagree with me that Kouri substantially deposited more in that account than Eric did in the joint account from her KRR account?
I don't know if I would agree with that or not, because there's a lot. There are a couple of instances where C&E, there is money coming from C&E. I will say that there are a lot of instances where there are, say, like there's a $5,000 payment from Kouri Richins Realty account, the 6577, into the joint account. But there are some instances where there's a lot of money coming from Eric's resources too.
Okay, now I want to back up just a little bit when you very first got on the stand and you were talking about the accounts, who had access or whose name they were in.
Yes.
So spouses have their own decision about who does the money, who doesn't do the money, and you were not privy to that arrangement between Eric or Kouri, were you?
No.
So you don't know if they sat down at dinner every night and looked at every one of their bank account together, do you?
I do not know that.
You do not know if Kouri gave Eric the password to all their bank accounts and said, babe, it's shared money, look at whatever you want to look at. You don't know if that
I
happened.
do not know.
You don't know how often they talked about finances or what Eric knew or didn't know about Kouri's business.
That's correct.
You do know that Eric invested in at least one property himself through his C&E account, the
Ransom Lane.
Thank you.
I would not call it investing. I know that there were the C&E checks that went into the Kouri Richins Realty account.
Okay. Looks like they invested in the property if you were just looking from the outside. Fair?
I have other information that tells me that's not the case. That's why I've not included it in my testimony.
Okay. You also looked at the prenup agreement, and we all know what prenups or agreements are from TV, right? It's an agreement before you get married about how you're going to split stuff up if you get a divorce, right?
That's true.
Okay. And in the prenup that was signed when they got married, was the home contained in that prenup that you've reviewed? The home they lived in?
I don't recall. I'd be happy to look at it if you want me to.
Take a second, please. It's exhibit number, it's docket 106.
I'm skimming this. I don't recall it's in here.
Okay.
Is that correct?
It's not.
Okay.
Thank you for checking. So if you don't have your home in a prenup, regardless of whose name is on the title, would you agree with me that as a spouse, you have an interest in your marital home, correct?
That's,
Well, hold on. They're about to object that it calls for a legal conclusion.
Your Honor, if I can argue this because I
It
observed.
calls for a legal conclusion. Sustained.
Okay. Let me ask you this way. You testified earlier that Ms. Richins got a HELOC on that house. Is that right?
that's correct.
All right. And you don't know if you're not a lawyer, you're not a divorce lawyer, certainly, right?
That's correct.
So you can't tell, and I almost just called them the jury. Automatically. You can't tell the jury. You can't tell whether or not Ms. Richins had a lawful interest in that home that enabled her to put any type of lien on it or anything based on her marital interest, because you're not a divorce lawyer, right?
That's that legal conclusion.
Okay. So, and you also don't know if Eric knew about the HELOC or when he knew about it or what he did about it.
Objection calls for speculation.
I'm
I think
asking.
that's what she's establishing,
Yeah.
but you can answer the question.
I am aware that there are indicators that he knew about it in October of 2020.
That's right, because he told it to the lawyer that he was seeing about maybe getting a divorce, right? So when he told the divorce lawyer, hey, she took out this money on my account, that was October of 2020, right? So we know
and
he...
the indicators are that's when he learned about it.
Right, so a little less than 2 years before he passed away.
A year and a half, yeah.
Okay. And how many payments did you see Eric Richins make on that HELOC after October of 2020? In your review of every payment that was made toward that HELOC, how many did Eric make out of his account?
Out of which account?
Out of his accounts.
The 657, or I mean the C&E account?
Did he make any out of the C&E account?
No,
Did he ever sign a check for that you ever saw?
I don't believe so.
And it was coming out of their joint account or out of the KRR account, the realty account?
Mostly out of the 5244 account, which was Kouri's account.
Okay, so she's paying it. The HELOC that she took on it.
Yes.
Okay. And he knew about it in October of 2020.
Right.
Okay. And they stayed together, obviously. All right. If the home was not contained in the prenup, since you did work for the trust, is it not true that the trust is taking the position that the home gets poured into the trust upon death?
I don't know.
She's just asking what Ms. Carrington knows. Let's
What?
find out.
Thank you. Do you know?
I don't know.
Okay.
To be clear, I think my knowledge on these issues is
Better than
superior
all of
to
ours.
that than anybody else in the room, and so I can keep it straight.
Well, yeah, and I appreciate that, John, because I think the court in summary judgment motion 2 weeks ago ruled on this very issue.
I can give you chapter and verse on these if we need it.
Okay. Thank you,
We
Your
can
Honor.
just keep it.
I'll try to
Which
skim
is my
past.
point, Your Honor. We
I
can
understand.
do-
We'll just keep it.
Okay, just a minute. Just making sure I don't miss anything. I want to talk about those life insurance policies that were on your chart. If you could look at that chart in front of you, those 6 policies.
It's not up, but that's fine.
Oh, I thought you had a binder. I'm sorry.
It's okay.
I can put it back up.
Thank you. It's exhibit number, I think it is.
Number
Exhibit 69, yes, sir.
Back.
Thank you, Your Honor. Now, of those policies on Exhibit 69, the very first policy is a mortgage policy,
That's correct.
which just pays off the mortgage if you die.
It doesn't pay it off, it pays it down significantly.
Right, sorry, you said that, 70 some weird percent.
Some weird percent, yeah.
Okay, so that life insurance policy is made payable to the mortgage company.
And as far as I know, it was paid directly to them.
Okay. In your chart, it says it was paid to the trust. Do you see that? That they were the
do not.
beneficiary?
I say they were the beneficiary, but that was, no, that's not what I said, but it was paid toward the mortgage is my understanding.
So, Kouri, and when was that policy obtained? Back in
15.
Okay. And do you even know Eric applied for that, right? Himself?
I do not know.
You don't know.
I don't.
Okay.
Don't recall.
Second policy. What's the second one?
On my chart is the $250,000
True stage.
from 17.
And that's 2017.
That's correct.
And do you know whether Eric, that is not one of the questionable signatures, right? You've agreed that's Eric's signature on that application.
Let's make it clear, I'm not making any determination out of signatures. That's not me.
Okay. So the report you read from the handwriting analyst
That one.
didn't look at that signature of the True Stage $250,000 policy, correct?
Actually, I don't know. He looked at, in his report, he lists couple of few dozen exemplars. I don't know if that's one or not.
Okay. Do you know whether or not Eric Richins had to take a medical exam to get that life insurance policy?
I don't recall. I think I've got the documents for that, but I don't, off the top of my head, no.
So you can't say right now, as you sit here, whether Eric was involved in getting that policy or not. You just don't know.
I don't recall. There's both of those next two. There's the True Stage and the Auto Owners. That was part of a group of policies where there's one on Ms. Richins, one on Mr. Richins, and somewhere along the line there's some on the kids too.
That auto insurance policy, that's the big one. That's $1 million, right?
Auto Owners. Mm-hmm.
And what is the date that insurance policy was applied for?
That's also in 2017.
So, help me with math, 5 years before he died.
That's right.
And that $1 million policy, there's no way they're going to insure somebody for $1 million if they don't have a medical exam. Do you think that's fair?
I think that's a fair statement, yes.
Okay. And then the next insurance policy was what day?
This is in April of 2018 with New York Life.
So that's 4 years before he passed.
That's right.
And do you know who applied for that?
I have the documents, but I don't recall. I'm sorry.
And do you know whether Mr. And how much was that one for?
$500,000.
And do you, again, that's pricey, bless you, Your Honor, that's a pricey insurance policy. Again, I would imagine that would require a medical exam. Do you know if Eric submitted to one?
I know that he did on a policy. I've seen that, and I can't recall which one it were ones. I just don't recall those details.
So that really just leaves, and the policy that he had with his partner, the buy-sell policy, which partners do all the time, right,
That's
in
correct.
business,
Yes.
that money goes to the partner. That doesn't go to the spouse.
That's
Right.
They're set up specifically that way.
Right.
Yes.
So the only policy on there that was obtained within any short period of time before Eric died was the very last one for $100,000, right?
Right, and that's usually, typically in my experience, that's an amount that probably would not have required an exam.
Totally agree. And that policy is one of those ones that we all get in the mail if you belong to a credit union, where they send you a little flyer, you get it in your junk mail, and it says, hey, you want to up your insurance? No exam, just sign here and we'll add some more for free. Please do that. Is that what that is?
It is a brochure from the credit union, but what you've just described it's not contained in there. It was an offer of life insurance though.
Made by the credit union
Yes.
to all their credit union members. It's just like a perk for being a credit union member.
It's a marketing brochure, yes.
Here's some pretty cheap insurance, grab it if you want it, right?
That would be a fair statement, yes.
Okay. And that's the policy that was taken out, I guess, that was signed to become effective a few weeks before, or a month and a half before he passed.
A month, yeah.
Okay. And again, that's $100,000 out of a total insurance amount that had been obtained years before, exceeding $2 million.
That's
right?
correct.
Okay. Were you ever asked to look at Eric's financial records in his company or his business? Anybody ever give those to you?
I do have his bank accounts, the bank accounts for their company, yes.
And the bank accounts that you talked about where, well, I'll strike that, I'm not going to go into that. Okay, court's indulgence, I think I just about threw you on. Can I ask a quick question? Your Honor, thank you very much. Thank you, Ms. Carrington.
Mr. Farmer, Attorney, redirect within the scope of process.
Yes. Ms. Carrington, You were asked about a successful flip.
Yes.
If we're measuring success as an amount above and beyond all costs that go into the purchasing, rehabbing, taxing, etc., the flip, that is a measure of successful flip. Were these purchases and subsequent sales successful?
If they were sold, if that's your measure of success, then they were sold, so that would be successful. There were several instances where the investors were not going to get their money out of that particular property, so their trust deed, their investment was transferred to a different property where there was room for them to be repaid.
So some of these subsequent sales did not even meet the investment that went into them.
That's right.
Okay. So at the time of the defendant's death, March 4th, what was the summary of debt owing? Do you have the figure for that?
Yes. 3 of the homes had recently, prior to Eric's death, had been sold for about $170,000 in net proceeds. And then Mrs. Richins had retained, I believe, 5 properties at that time. The HELOC was over its limit. It was at $252,000 on its balance. Her credit line at PenFed had been exceeded. Her credit line at America First was about maxed out, and she had ended the year in 2021 in the hole. I think in her 5244 account she was in the hole $15,000, and in the 6577 account she was in the hole $22,000. There just were no resources.
When you say there's no resources, so then she's unable to service all the debt she's acquired.
That's correct. And at that time, again, it's kind of mix and match to try and figure out how much debt load she had. She owed about $4 million on, let me restate that. The trust deeds associated with the property that she retained were about $4 million. So she probably owed a little bit less than that. And then the personal property loans, the accounts payable loans, I believe her balance at that time was about between $500,000 and $600,000.
Somewhere then between $3 million and $4 million is her total debt load she has at the time of March 4th, 2022.
No, it would go the other direction. So she had roughly $4 million in real estate that she owed on, and then another $500,000 to $600,000 in those personal property loans. So $4.5 million, something like that.
Okay. You mentioned the HELOC in talking to defense counsel. Do you know, other than that one $50,000 payment on principal in October of 2020, were there any other payments that you're aware of that were substantially beyond just paying the interest?
No, they were pretty much the minimum payments for the rest of the life of the loan.
When did she stop drawing money on the HELOC?
Do you mind if I look at my notes?
No, that'd be just fine.
In October of 2021 is the last draw of $2,300 payable to Kouri Richins Realty.
And why didn't she just take some more out of there?
Objection to speculation, Your Honor.
I think he's asking a financial question overruled.
The balance of that account, the limit was $250,000, and as of that time, the balance was $253,199.25. So there's no room to draw more.
Did these lenders that you're aware of analyze the defendant's net worth when she was taking out these loans? Accounts receivable, for
It
example.
appears, yes, they did.
Okay, so how much did she have in artwork?
I don't recall any artwork listed.
Okay, how about jewelry?
I don't recall any jewelry listed either.
Okay. When you look at the AFCU bank accounts, from which bank account were the payments made to the top insurance 1 through 4?
Those are paid from the joint checking 2204.
Okay, and that's distinguished from the last one, the one made on February 4th, or entered into on February 4th, with apparently no notice to Eric. That was paid from which account?
From the 6577 account for K versus Realty.
I have nothing for you.
Ms. Nestor.
Nothing, Your Honor. Thank you.
Ms. Carrington, you can step down. Thank you. Okay. Mr. Bloodworth, what's the plan?
Your Honor, the state does not intend to call any more witnesses.
Does the state rest?
The state
Okay. Ms. Lewis, Ms. Nestor.
Anticipate this a little bit.
Sure.
I'd like to note at the outset, other than the hearsay evidence that the court addressed in a private or non-public hearing yesterday,
Right.
all the other evidence that the state references in its bench brief has been placed into evidence. So the court can rely
Right.
on that briefing. I suspect, considering that the court has already found substantial evidence at the detention hearing related to the aggravated homicide charge, and since there's really no evidence to undermine the credibility of the existing evidence, and the state has added evidence, mostly in the form of 1102 statements from Ms. Lauber, Mr. Jeffs, Ms. Lloyd, and Mr. Grossman, and also considering that the financial charges are mostly paper-based charges that the court can read. Considering all of that, my sense is the court is most interested in hearing arguments on the attempted homicide charge, and the distribution kind of goes along with that. It really trails it.
So let me be specific, but I'm happy to go wherever you'd like to take me. But counts 2 and 4 are linked.
Yes.
And I have questions about the state's view of those. I do have some questions about counts 8, 9, and 10, only because I'm not sure I understand specifically the conduct that the state believes is associated with each of those 3 counts, but we can get there.
Yes, Your Honor. Let's start with 2 and 4, the attempted homicide and the connected distribution. In the meantime, Mr. Burmester may start thinking about 8, 9, and 10,
Fair.
but I also may address them as
Okay.
well, depending on the specific questions. Let me begin, Your Honor, on the attempted homicide bond-over argument. This is a domestic violence case.
Right.
And to best understand the attempted homicide charge, the court should view the defendant's conduct through a wide-angle domestic violence lens. And consider the entire arc of the criminal information and all the evidence that supports it.
May I ask you a specific question about that?
Yes, sir.
to what extent can I consider the probable cause showing that of the aggravated murder in March when considering whether the state has shown probable cause of an attempt in February? The reverse would certainly be true.
Sure.
I'm unclear as to what extent I can consider the March events as probable cause for the February events.
Your Honor, you can fully consider it, and the court should fully consider it. What happens before a charged event and what happens after a charged event is probative of the event, particularly in this case. Let me maybe explain in some greater detail.
Sure.
And I guess further to that point, Your Honor, to consider the attempted homicide in isolation or as a discrete event, I think would be an error. The best evidence of the attempted homicide by poisoning on Valentine's Day is the actual homicide by poisoning 17 days later. All of the defendant's motive that existed for the homicide also exists for the attempted homicide. And maybe let me just kind of detail some of that for the court. I don't want to belabor the briefing, but there's some highlights that I think...
I agree with you. The financial motives that existed in March existed in February.
That's correct. But it's not only the financial motive, Your Honor. There is, and I don't want to recap it unless it's helpful for the court. I can recap the financial motives.
I think I have those sufficiently in hand.
Your Honor, the second motive that is just as present in February as it was in March, 17 days later, was her love interest in Mr. Grossman and their planning of the future. And specifically, the purchase of the $3 million Midway mansion where she discussed raising children and farming with him about a month earlier.
I guess what I'm saying is you don't need to prove motive beyond a reasonable doubt. The state has shown probable cause for it.
Okay. So then I guess the takeaway, Your Honor, is that the same motive for the charged homicide it's identical to the attempted homicide.
I agree.
Okay, I will move on.
Yeah. And candidly, I think the state has probable cause that she procured fentanyl prior to February 14th. The state has shown probable cause that she wanted something stronger after February 14th and sought it again. Made a reference to the Michael Jackson stuff, which I think at least at the preliminary hearing stage I could take judicial notice, refers to a well-known event in which someone took a controlled substance and died. I'm tracking all of that.
Okay.
Where I stumble or where I pause is, do we have an evidentiary foundation for a non-speculative inference that she actually gave Eric Richins a controlled substance on February 14th?
So we do, Your Honor. Let's...
Or attempted to do so.
Sure. Let's kind of focus in then on February 14th with the understanding that she 2 days earlier, with the probable cause understanding that she 2 days earlier purchased fentanyl from Miss Lauber.
Got it.
Okay. So her conduct on Valentine's Day helps establish that she, in fact, provided the fentanyl to Eric Richins. And so her conduct that day starts early in the morning when she purchased a sandwich from the Mirror Lake Diner. And
Well, we know she makes a purchase from the Mirror Lake Diner, right?
yes, sir.
We don't know that it's a sandwich based upon admissible evidence.
Sir, we do.
me how.
The invoice from the Mirror Lake Diner entered into evidence as Exhibit 66.
Go ahead.
Shows I think it's labeled on the invoice as breakfast sandwich.
Yeah, bagel sandwich.
Okay, bagel sandwich. And Your Honor, we also know from the defendant's own words that in her text message with her best friend, she admits to purchasing a sandwich that day.
Remind me, which exhibit is that? We're going to need to talk.
I'm gonna need some help on that
I
exhibit.
know what you refer to, but I just need to look at it.
Yeah, I might have it in my notes, Your Honor. If not, we're working on that on the side. I'll get
Keep going.
I'll
We
get
can
that
go
exhibit.
chronologically.
So we know from the invoice and from her text message that she purchased a sandwich that morning from the Mirror Lake Diner. We also have, as the court's seen, bank statements that confirm a purchase, phone call that confirms an order. The receipt corroborates, the invoice corroborates that the phone call is related to the order in Exhibit 66. So she purchases the sandwich from the Mirror Lake Diner. I think it's something like a 9:07 pickup is what the invoice shows. We then know at 9:43, the defendant, it's Exhibit 8, Your Honor, is the text message with her best friend.
Okay.
We then know at 9:43, she text messages her paramour that she's on her way. And at 9:49, she sends him a navigation screenshot that shows her kind of leaving the Kadmus area with an arrival time at some unknown destination approximately an hour from then. We also know, based on her text activity with her paramour, that they were essentially together all day. And we know that because, as the court can see, they text frequently throughout the day. But throughout that day, they weren't texting with each other. And I think the reasonable inference is they were not texting with each other because they were together. While the defendant is an hour or so away from Eric Richins with her paramour, Eric Richins has some medical event strong enough that he texts the defendant and says he's considering going to the hospital. And we have that text exchange in evidence.
Right.
Feeling sick enough to go to a hospital, and then sleeping in the garage, which he also texts, for about 2 hours, which is consistent with no activity on his phone and associated devices. All of that is consistent with a reaction to fentanyl.
I've read it, but I can't remember the number. The number for the 1102 from the person that lays that foundation regarding a reaction, if any.
Yes, so that's the toxicologist Matt Slauson.
Okay, thank you. Keep going.
Your Honor, also in evidence is literature from the Mayo Clinic, which lays a similar foundation. Okay, so we now have, right, on the chronology of Valentine's Day 2022, the defendant and her paramour an hour or more away. Eric Richins sick enough that he's considering going to the hospital and is inactive for 2 hours. All of that consistent with fentanyl poisoning. And then at that point, the defendant's own words are kind of important here because he texts her, right? of his illness, of considering going to the hospital, and what she says is chilling. She says, take a nap. And then she doesn't check on him for 2 hours. She doesn't come home, she doesn't text, she doesn't call, she doesn't check on him. Their next communication is 2 hours later when Eric Richins checks in with the defendant. Notably, throughout the day, Valentine's Day, and thereafter, the defendant's reaction to Valentine's Day events is consistent with a consciousness of guilt. She had texted on February 11th and 12th significantly with her drug dealer during a time frame that corresponds with the drug dealer's purchase of fentanyl at the Maverick and the Draper.
Right.
Those texts are deleted from her phone. She texted with the drug dealer 30 times, about 30 times was Mr. Kotrodimos' testimony, on Valentine's Day, and those texts are deleted. There is no good reason the defendant is spending Valentine's Day with her paramour and texting her drug dealer 30 times. Eric Richins texted the defendant a photo while he was texting her about feeling ill and considering going to the hospital. That photo is deleted from the defendant's phone and also from Eric Richins' phone. That is in the moment consciousness of guilt. The next day,
Forgive me, I don't recall testimony from Mr. Kotrodimos or any documentary evidence about when those images were deleted. Now, I acknowledge they were deleted sometimes after they were created, but...
Fair, Your Honor.
Okay. Okay.
The next day, after Valentine's Day, February the 15th, 2022, the defendant lamented to her paramour, if he could just go away, ... life would be so perfect. And then 2 weeks later, she assured her paramour, life is going to be different, I promise. Hang in there until Friday. On Friday, Eric Richins was dead. We've referenced Exhibit 8, the text messages that the defendant sent to her best friend.
I don't think that's 8. I think Cellbrite is 8. Can you give me that number again?
Well, Your Honor, it would be found in a Cellbrite extraction.
Oh, my apologies. Okay.
So,
It's not like a screenshot. It looks
Okay.
like that.
Let's get there together. I need the exact language of that. It would be... Okay, got it. So this is, we got to be specific about this, a June 18, 2022 communication, correct?
yes, Your Honor, it is June 18th, 2022. I can give the court some context, which the court's already familiar with on the timing. The timing relates to the same allegation kind of is wrapped up in the attempted homicide charge that was made in the civil litigation. And timing would suggest, I think it is reasonable to infer that they were discussing this incident. This text is a discussion of the Valentine's Day 2022 incident as put forth publicly in a civil filing.
ask questions about this when you're done going through the evidence.
Okay, sir.
I also have questions about the February 15 text messages, so just put 2 pins in those.
Okay.
I'm not questioning they exist. I know they exist.
No, sure, sir. That glance was to get a copy of whatever the
Okay.
February 15th text was.
We'll see. If you would just go away, ... and then
Yeah.
I promise we'll be together on Friday or worse than that effect.
Yeah, yes, Your Honor.
Okay.
We can discuss those kind of texts when we're both looking at them.
Okay.
The text to her best friend regarding Valentine's Day. The defendant says, it was Valentine's Day and Eric and I were both working from home that day. We know that to be false. We know that to be false from her text messages with Eric himself. We know that to be false from her text messages with her paramour. We know that to be false from the navigation screenshot. Continuing with the text, she says, he, meaning Eric, never broke out in hives or used an EpiPen. She did not know that. She was not with him. The court can reasonably infer that the opposite is true. She is lying about being with him. She is lying about him not breaking out in hives. She is lying about him not using an EpiPen because she knows those facts are indeed true and indeed inculpatory. Sir, do you want to discuss those texts, or should I continue on with kind of further answering your question as how the homicide charge kind of relates directly to the attempted homicide charge?
Well, let's pause here for a second.
Yes, sir.
We also skipped over or didn't mention in that recitation. Remind me of the date where she asks CL for something stronger.
So, Your Honor, that I don't know that I know a precise date. It's somewhere around February the 25th. And Your Honor, the court raises an important point, right? I said at the outset that the best evidence of the attempted homicide by poisoning is the actual homicide by poisoning 17 days later. And the defendant learned from the attempt and applied it to the homicide. And we see that with what the court just raised. She wanted something stronger. She learned that whatever she used on Valentine's Day wasn't strong enough, which is why she went back and asked for something stronger. But she had a similar MO, right? You know, her MO is to go to the drug dealer, procure fentanyl, and 2 or 3 days later, 4 days later, administer the fentanyl. That is the same. The drug is the same. The drug dealer is the same. The timing is the same. But she learned. She learned she needed something stronger. She also learned how to administer it. She learned that putting it in a sandwich where Eric Richins could take a bite, feel the effects, set the sandwich down, was not the proper way to administer a fatal dose of fentanyl. Instead, she administered it with a lemon shot, where Eric Richins would throw it back all at once. She says that in her journal article, her journal note at Exhibit 49. And she learns that it takes a truckload of fentanyl to kill him. She learns that one bite in a sandwich isn't enough. It has to be stronger, it has to be administered at once, and it has to be a lot. And that's why Eric Richins' toxicology shows 5 times the lethal amount in his blood and 20,000 nanograms per milliliter remaining in his gastric fluid. The attempt and the homicide are connected in MO and lessons learned.
If we view, let's imagine for a moment that everything through February 15, well, February 26 stays the same. Imagine Eric Richins is still alive. The text message on June 18 gets sent. I imagine you tell me we'd still have probable cause of attempted murder.
We would, Your Honor, and I guess that goes back right to the standard of this hearing. You know, all reasonable inferences go to the state.
Right. And I hear you telling me it's a non-speculative inference that you tried to poison him because we have her admitting that she ordered lunch from Mirror Lake Diner. We have him having a significant enough event that he contemplates going to the hospital. We have text messages on February 15 that draw reasonable inference that she wanted him dead. We have her out looking for something stronger when he did not die on February 14. We have a financial motive. We have the medical foundation. The difficulty is, right, and maybe this just highlights the low threshold that is the probable cause determination. And I imagine this is what Ms. Nestor and Ms. Lewis is going to tell me, is this turns just about every possession charge into an attempted murder charge if the spouse has some medical event around the same time. But
and
here you'd say...
And the spouse dies 17 days later under very, very similar circumstances, same MO, connections between the two.
And is it 404 that lets me connect the dots here?
I don't even think the court has to go to 404. I think the court can connect. I mean, certainly it's probative. So, yeah, certainly it's relevant. I guess the court could connect the dots through probative, but there's no doubt, especially returning to the fact that this is a domestic violence case. The court sees the consistency in the domestic violence defendant's conduct throughout. The motive is super strong. I mean, I know we've kind of agreed that the motive is present in both circumstances, but
it's equally present. It's separated by merely 3 weeks.
Correct, and
yeah.
it's equally as strong. Now, Your Honor, the court raised, that this isn't speculative, and it's not. And Schmidt kind of talks to the notion, the point, right, that the court's job here is not to sift through the evidence and find the most reasonable explanation, just to make sure that the state's the most reasonable inferences, just to make sure, rather, that the state's inference is reasonable, and we leave the most reasonable inference question to the jury.
All right, so if you've got probable cause for count 2, you've got it for count 4.
Yes, sir, I think two goes as, or 4 goes as 2 goes.
Right. I think I understand the state's position here. You will, of course, get the last word on counts, on all the counts, but certainly counts 2 and 4. I have some questions regarding some of the financial counts.
Yes, sir.
Bear with me for a moment. All right, count 8 for insurance fraud. What is the conduct that forms the basis of that count? Count 7, the $100,000 true stage policy. I'm following the state's argument. I'm not sure what count 8 refers to.
Yes, Your Honor, and in the statute under count 8, the insurance fraud statute has different non-exclusive, or I guess different exclusive theories of presenting an insurance fraud claim.
Certainly.
And then count 8 is kind of the broadest claim. It's the scheme claim.
Well, for count 7, right, it's either it could be the forged signature, it could be the false representations regarding how Eric got the fentanyl in him. Either one of those, I think, would get you there. Let's just say it's the false statements regarding the fentanyl.
Sure.
You have a forgery count
Sure.
regarding the false signature,
Mm-hmm.
I think, in either, bear with me, 9 or 10,
Mm-hmm.
or maybe 11. Candidly, I think 11 is the forged signature on the $100,000 policy.
Sure.
So
That relates to the claim, right? Count 7 is a false claim
right.
on an insurance policy. Count 8 is a scheme devised to get money falsely from an insurance company.
But
Can or cannot involve a claim.
fair enough, but is it I acknowledge that we don't need to get into merger today, but
Sure.
is it the forged signature on the $100,000
Sure.
true stage?
Sure, it's the signed application on January 28th and 29th. It starts with the application
Okay.
for the policy that issued on February 4th,
Right.
10 days before the attempted homicide,
Okay.
a month before the homicide. It starts with that signed kind of application that the court will recall. There was no way for the insurance company to contact Eric Richins. Rather, they could only contact the defendant, right? The defendant used her business P.O. box. The defendant used her email. The defendant provided an improper phone number.
Okay.
And so submitting that application begins the scheme.
Got it.
Then the scheme continues through the false claim for the money. And the evidence of that is the claim log we submitted into evidence as Exhibit 67. But different than the false claim where the mens rea and the actus rea is just submitting a false claim with the intent to get paid on it. The scheme is much more sweeping. The scheme in count 8 is, I'm going to submit a false application for insurance on Eric Richins' life. I am going to then cause his death and then seek money.
Understood. All right, so with respect to the 3 forgery counts, 11 is allegations regarding Eric Richins' signature on the application for the $100,000 true stage policy.
Correct, Your Honor. And that's the policy of Exhibit 17.
What is 9 and 10?
9 is the fraudulent bank statement that the defendant provided to Ironbridge, and 10 is the similarly fraudulent statement that the defendant presented to Boomerang. That's the cut. Those are the cut and paste job statements.
And so the forgery count of 9 is related to the mortgage fraud count that is in 5, right? and then the forgery count 10 is related to the mortgage fraud count in 6.
Correct.
Got it. Okay. Thank you. Anything else you want to put on the record at this time?
No, Your Honor, I'll be back.
Very good. Ms. Lewis, how are you?
I'm fine, thank you. I'm going to address really just counts 1 and 3 and a little bit of 4. And then Ms. Nestor is going to address count 2
Okay.
and the remaining counts.
Tell me where you see the gap on count 1.
All right, well, here's where I see the gap on count 1. So I understand that there was a finding made at the detention hearing. And I understand that the court can consider the transcripts from that hearing. However, I think we're in a kind of an interesting situation because the burden of proof has to be at the preliminary hearing, and the court does need to make a new finding at this hearing. And I actually think, interestingly, that this is a situation where additional information that came in makes it less likely and makes it more difficult for the state to establish a reasonable belief as to the first element of aggravated murder, that she actually intended and knowingly killed Mr. Richins. Because what we learned yesterday is we have now the affidavit, or the 1102, from Ms. Lauber. But what that really tells the court is only one thing, is that she believes she gave fentanyl to Ms. Richins. She doesn't know what she gave Ms. Richins. Whatever she gave Ms. Richins has been through at least 3 people before it came to Ms. Richins. Ms. Lauber got it from somebody, Mr. Crozier, who got it from somebody else that we don't know who that other person is. None of these people manufactured it. None of these people tested it. So we don't know what was given to Ms. Richins.
I don't disagree that we don't know, but knowing is not the legal standard that I'm required to apply today. So tell me why Ms. Lauber's 1102 is insufficient to support a reasonable belief in the parlance of preliminary examination law that the stuff that she provided was fentanyl.
Well, let's look at the distribution counts and examining that.
Yeah, we can't do anything about that. All right, go ahead.
So, looking at the distribution, and then I'll backtrack a little. So, Detective O'Driscoll said that he had no way of knowing, that he did not know what was in the pills.
He just knows that they are blues or greens, which, given his experience with, didn't say narcotics, but with controlled substances, is consistent with street fentanyl.
Blues, he said.
Okay, here you go.
Anyway, I was trying to remember if this was in the record or not before I said it out loud, so that's what was my pause there. But I have never seen a distribution case where we don't have anything that was distributed.
You mean a preliminary hearing or a trial? Two very different universes.
Well, personally, neither. Okay? Personally, I have not seen it either place. But I don't think just an individual who's a drug addict saying, I thought I gave her fentanyl, I mean...
Doesn't that form the reasonable belief, though? I mean, by all accounts, Carmen Lauber knows the difference between a controlled substance and not.
Well, that's not in her affidavit. How do we know that? How do we know that she knows the difference?
With respect, she's in drug court and she faces controlled substance convictions. So apparently she has some experience with it.
But Detective O'Driscoll testified that she said initially, and she said it in more than once, that she knew nothing about fentanyl. She didn't deal fentanyl. It's not her drug. And he said that.
These are great trial arguments, but I question whether this would be sufficient to, these concerns are sufficient to rule that there's only a speculative basis rather than a reasonable basis.
And I understand.
There was provision of a controlled substance.
I mean, I understand your position and where you're headed with this, but I do think we want to, for the record especially, Detective O'Driscoll testified that he cannot say with any certainty what happened to those pills. We have no knowledge, no testimony, no evidence, even if those pills were fentanyl, what happened to them after February 25th. I mean, the third ones were allegedly received after Mr. Richins' death, which is interesting in terms of what these pills were actually for. And I think, and again, maybe a trial argument, but it's interesting that if that was the purpose of these pills, that they were still being handed out afterwards. But he said he could not testify what happened to those pills. He cannot testify what was in those pills, and he does not know how, if those pills were given to Mr. Richins, and if they were, how they were given, who gave them, did he take them himself? There isn't any evidence as to that. And I understand, the position and the very low standard we're looking at here. I get it. But that would be...
To be clear, the court's position is based on an application of the standard, not because I have an independent
I
belief
understand.
of what did or
And I
didn't
didn't mean to imply that it was your personal belief. I understand the standard. And your application of the standard. Our position is still that there needs to be something more when you look at everything that's been presented as evidence in this case up to this point. And particularly on the distribution count, I think it's...
3 or 4.
Well, to both, but there's additional, of course, problems with the February 14th distribution count.
With count 3, though, I mean, if there's probable cause for if there is evidence sufficient to support a reasonable belief that Kouri Richins put some drugs in a drink and handed it to Eric Richins, there's probable cause for the count 3, right?
Yes.
Okay. All right.
You're right. But I think I've made my argument on that. And I just don't think that anything that happened from any of the other witnesses, of course, goes any further to show anything about count 1. It goes to the motive, which is an element of count 1, especially the Ms. Carrington's testimony. I understand that. But nothing that they said, I think, goes to intentionally or knowingly administering the drugs.
Well, the motive would provide some foundation for intentionally or knowingly. Let me put it differently. If there was no motive, the inference would be harder to draw, correct?
Yeah, you're correct.
Okay.
I think that covers what I have in our record on that. I don't know if you have any other questions, but Ms. Nestor will talk about counts 2, and then that, of course, relates directly to count 4. And she'll address the financial counts.
Okay. I think I understand your position on 1 through.
Okay. Thank you.
Good morning, Your Honor. May it please the court. If the court would indulge me just a couple minutes. I know you're so familiar with preliminary hearings. You do about 1 billion of them a year, probably. But I do just want to talk about what they are and what they mean to this system and to my client. So, Utah is a state that has decided not to employ the grand jury system to determine whether someone should be prosecuted for a felony crime. Utah has decided to place the entire power of whether someone's going to be dragged away from their home in handcuffs to a courtroom facing serious charges to the discretion of these people at this table. It's their power to fill out an information.
I have some role in the process.
Yes. I'm talking about before they get to you. I haven't got to that part yet. Right. You're jumping ahead of me.
Okay.
But what brings them to you is the people sitting right here. And it's their opinions, it's their beliefs. They're not a grand jury, they're prosecutors, they do their best. So what we have created to protect clients from that awesome power that sits at that table is this process of a gatekeeping, that instead of delegating that to a grand jury, people in our society that come together in closed doors and hear the evidence and decide whether there's enough to put someone through this, they bring it to you. You're the gatekeeper. And this preliminary hearing is a critical right that every single individual who they decide to write a charge against has. And when we come before you, we recognize that it's a low standard. We recognize that probable cause means that. It just means enough to charge you. It doesn't mean enough to convict you. It doesn't mean enough to determine you committed a crime. It's enough to charge you. But that charging decision does matter. And it's going to have a huge, huge impact on the way this case plays out, on the evidence that is brought before the jury, on who will be witnesses, determining what charges get past this gate, you the gatekeeper. So we believe very, very, very strongly that the charge of attempted murder has not met the lowest standard even of probable cause. And that as rare as it is for a judge to say there's not even enough to charge here, it is anticipated that that will happen on occasion, which is why you do thousands of these, right? Because every once in a while, they don't get up to that level. And we think in this case they haven't done it, and we'd like to tell you why. So thank you for indulging me in that.
I agree with everything you said about the law.
Okay.
What is the essential element of count 2 that you believe the state has either shown no evidence of or insufficient evidence to draw a reasonable inference regarding?
Causation. 100% causation. So, in order for them to establish an attempted murder,
Right.
they have to show that Ms. Richins took some act that caused someone to be in danger of death, right? She had to have caused something that put them at risk, right? Whether they actually died, obviously it's attempt, right? So I think it's critical that you understand the timeline of that day. And I want to walk it through, and I know it may take us a couple of minutes, but I think it shows so clearly that they cannot make the connection. And it's indisputable evidence that's in the Celebrate that has been downloaded off their phones. There's no debate about what happened on those phones, okay? So, in Exhibit 6, there are substances of text between Eric and Kouri that say exactly their communications that day. I want to go back to the very beginning, which is the receipt, which is Exhibit 66 from the Mirror Lake Diner. It shows that Kouri's credit card swiped at 9:07 a.m. and that she ordered a bagel breakfast sandwich and an omelet. There is a statement under the sandwich that it's over hard, which means it's an egg sandwich. There's an egg in that breakfast sandwich, and I think that's important because I don't know about you, but I'm not eating an egg sandwich 2 to 3 hours after it's brought to me. You eat it quick or you don't eat it. So she brings an egg sandwich home at 9:07. This actually hasn't come in, but I think the court could take judicial notice because of the address on Ms. Carrington's exhibit about the Willow Creek home where they resided. It's about 5 minutes away from this cafe, and I don't think the DA will, or the county attorney will dispute that.
Nothing in Kadmus is very far away.
Nothing in Kadmus is very far away. So it's about a 5-minute drive from the cafe to their home. So best case scenario, if her credit card's being swiped at 9:07, she's getting home around 9:15 in that area, maybe.
Is there any evidence that she actually went home?
Correct.
Well, I'm asking.
There is. On her phone. The printout of her phone shows her returning back to. Well, actually, they've introduced that exhibit that they blew up that showed that she was on her way to the house, and that's from her home.
Okay.
So she was at home. So there's a period of time where she's at home between 9:15 and 9:41 a.m. with eggs to eat. Now, it is a fair assumption that when you bring eggs home, you eat them quickly. So it is perfectly possible, and just as inferential, that she could have had breakfast with her husband that morning together. And let me tell you why I believe that that's proven in the state's own case. Because at no point in any conversations, any texts between Kouri and Eric, does he ever tell her that he's feeling sick until he tells her at 11:40 something that if I'm still feeling this bad, I'm going to go to the hospital. So it sounds very much that they've already discussed that he doesn't feel well, right? So it is perfectly consistent with Kouri Richins' statement to her friend, they breakfast together, which would make it pretty hard to poison someone when they're sitting there and you're handing them their food and watching you hand them their food. So then you have Eric between 10:21 and 12:06, and these are reflected in exhibit number 38, which shows the locations of calls made by Eric.
Could you pause for a second?
Yes.
Is there a statement that they ate breakfast together?
They just talked about her telling her friend lying that they were together when they ate.
So, I just want to make sure I'm not missing anything that you're seeing. Quote, forgive me, folks. I didn't even make him a fucking sandwich, those fucking idiots. It was Valentine's Day, and Eric and I both were working from home that day, and I ordered lunch from Mirror Lake Diner.
Well, that was months later, and she hadn't seen the time. She hadn't been exposed to any of the
Hey, folks, I need you to take a deep breath.
She had
Is there any evidence that she has a backward-looking statement saying, I ordered breakfast?
Well, that's the only statement that we're aware of.
Okay.
But at that point, she hadn't seen the time. So she's remembering if it was breakfast, lunch, whatever. I mean, that was months later.
Right.
But she admits she got it at Mirror Lake. She admits they ate it together. She mixed up the time of breakfast and lunch. I mean, there's no debate that she was not there at lunchtime. That didn't happen. So,
Right.
so that's clearly a mistake. So she leaves the house at 9:41 and is gone for the rest of the day. Eric drives to multiple other locations after she leaves.
Do we know, help me out, do we know that? Or
Yes.
was he doing the estimating from home? This was unclear to me from the testimony.
So in the Celebrate exhibit that is Eric's phone, it shows where he's making calls from.
Okay.
And so he makes calls from, I think he goes to it looks like the Smith's grocery store, the Walmart. He goes and runs some errands. He's
Right.
making business calls ever since Kouri left, the whole time. After he's eaten the egg sandwich, he's driving around, he's making calls. Then he texts Kouri at 11:27 and talks to her about some soccer fees that the boys owe. And then says a few minutes later, so between 11:27, he's talking about soccer, and 11:33, so he hasn't seen Kouri now in 2 hours. He says, I'm going to go lay down. If I don't feel better, I may go to the hospital.
Right.
And I must respectfully point out that when the prosecution talked about her saying, go take a nap, and how that was chilling, he pulled that completely out of context of the rest of what she said in that text.
Do you need me to come home?
Would you like me to come home? Jesus, is that bad? You know, she even at one point later in the day talks about, he says, I wish you were here. And she's like, I would cuddle you. So that is very misleading to pull that statement out. And I need to correct that for the record. But regardless now, he hasn't been in her presence for 2 hours. If he ate that sandwich, he ate it around 9:30, give or take, at the latest. So in that period of time, he's been running errands, doing business calls, texting Kouri, very benign, normal day-to-day texts, nothing about I'm about to die, nothing like that. He takes a nap for 2 hours. Then he gets up. They text romantic texts, wish you were here, like to cuddle, That's at 1:43 when he just woke up. The same period of time well, I'm sorry, that's not before. I withdraw that. Continues to make work calls from 1:50 to 2:30. Goes to a soccer game with his kids from 3:52 to 6:11. Takes the boys to get some food. Leaves food for Kouri in his truck as they go back to the game because Kouri is running late. And that's the day. That's the day that they are now saying that you can infer she tried to murder her husband. There's no evidence he ever took a pill from her. There's no evidence that she ever, if she put fentanyl in his egg sandwich at 9:30 and he ate it, he would not be okay for 2 more hours. He would not be. And there's zero evidence. There's not one piece of evidence from Eric himself that he ever took anything from Kouri that day, that he felt bad up until 11:33 is the first time he feels bad. Now, I think you asked a fascinating question when you asked the prosecutor, do I need to consider the death as support for probable cause of February 14th looking backwards? And I think that's a really important inquiry, because obviously, if you look backwards, everything you're looking backwards at shades how you look at something that happened before. But if you look at that count in isolation, there is no evidence that supports an opportunity for her. There's no evidence to support that he took anything. There's no evidence to support that he had fentanyl, OxyContin. And as a matter of fact, he told, wait, I have to think if this is in.
Can I ask you some specific
Yes.
questions about
Yes.
that? So let's take it one piece at a time
Yes.
here in terms of events after February 14th.
Yes.
In your view, can the court consider Ms. Richins' text messages to Mr. Grossman on February 15th? Can I consider them at all?
Can you consider them? I mean, I think you can consider anything you want to consider in terms of.
Well, see, that's the question. The Utah Rules of Evidence say, no, there's all kinds of stuff you can't consider under these set of circumstances, and it's often a difficult slalom course to ski. We did some of this yesterday morning.
Yes.
Trying to get a sense from the defense of whether or not the court can consider things like the text message, quote, if he would just go away, end quote.
So, you know.
Or as evidence of an inference that she wanted him not around anymore.
But that could be divorce. That doesn't have to be
I
death.
understand, and we're not at trial, and I'm not
Yeah.
a jury, and so I have to contend with
But how
black letter law. Let me just get this
Yes.
out. I
Yes.
really am genuinely interested in your response. I acknowledge there are multiple credible inferences that can be drawn from this evidence. Several of them innocent. But I'm not allowed to pick and choose. I am not allowed to weigh the relative reasonableness or credibility of the inferences. I'm required to draw all reasonable inferences in the state's favor, to view the evidence as a whole in the state's favor, and identify is there a reading of the evidence that supports a reasonable belief. And so when you say things like, look, this evidence, she went home, I imagine Mr. Bloodworth is fighting the urge to jump up and say, and that just shows she went home to give her the sandwich. That just shows he went home to give her the sandwich. She went home to give her the sandwich. And so the reason I ask about the stuff afterwards,
Right.
the text messages, her statement regarding ordering them lunch, being home together.
So the text message certainly could be considered for the death, right? Because he's still alive,
Well,
and
I
it's
got that.
February 15th,
But that's not my question.
right? So how does the how does the statement on the 15th relate to something that didn't happen? And she's talking about it future, right? Like,
I guess the question is, if on February 15, she has a text message showing a desire to have him not around anymore, why can't I consider that for her mental state on the 14th?
she doesn't say he should be dead.
I know, but we're talking in terms of reasonable inferences here.
It's, you know, criminal defense lawyers look at these phones, and it's pretty terrifying to think that someone's going to go back and look at text that you wrote about your spouse, you know, years later, and put it all into a cone of literal death threats when you say, I wish he'd leave, he's getting on my nerves, I want him to leave the house, I'm going to leave him, I want to divorce him. Eric, they put in Eric's divorce meeting with his divorce lawyer. I mean, this was not a perfect couple. They didn't have a perfect relationship. But to take a context, one single text, and to say that that gives you a reasonable belief that she tried to kill him the day before, I don't see the connection at all.
Okay.
I don't. I don't think that is a connection.
So I hear you saying you can consider a judge, but it doesn't have any weight.
I don't think it does.
Okay. Same response regarding her June 18, 2022 text to her friend?
That's what we just said, where she has not seen yet the time, like she hadn't had an opportunity to review the timing. So if she mixed up lunch and breakfast, but everything else in there is consistent with what happened that day.
What about her text message on or about February 26 to Carmen Lawler saying I need something stronger?
Again, that's after the 14th.
It's a backward-looking statement, though, or at least it's comparative.
Well, apparently she had recently apparently according to Ms. Lauber, she had just recently got something from her. So,
right.
I mean, that could be not connected to the 14th at all.
Okay.
So,
or more specifically, not necessarily referring to what she got on the 11th,
right,
but could be from the 25th.
But I mean, you have a claim that Mr. Richins was poisoned on the 14th. There is no medical evidence. There is no connection. There is no causation. There is nothing but pure speculation that because they believe she tried to kill him and successfully killed him in March, that must mean she tried it before. That is not enough to reach a reasonable belief that someone, and that's the question you asked at the very beginning.
Right.
Just because, I mean, it's like a backwards acting in conformity argument.
Yes.
It's a backwards 404B evidence.
This is my question.
Right.
Does that exist?
Which, by the way, 404B's whole purpose of existing in every state in America and in the federal system is exactly to avoid this kind of prejudicial leap of because somebody did something once, they must have done it again. That's the whole reason we have 404B, is to prevent that.
I acknowledge that. I imagine you would acknowledge as well the numerous exceptions and the lengthy or the deep body of case law regarding exceptions to the general bar to propensity evidence. And so here, when Mr. Bloodworth makes references to modus operandi, he's arguing to some of those exceptions.
Right. Well,
In your view, does 404B work backwards or does it only work prospectively?
It only works prospectively, in my opinion. But the analogy as to why this is such damaging and risky analysis can be found in that rule, baked into that rule that our legislatures and our Supreme Court recognize that that's very, very dangerous to base a prosecution on somebody, well, somebody used drugs once before in their life, they're probably guilty this time. That's the whole thing we're trying to avoid in our system. And that's the whole basis for their argument on the attempt. That's the entire basis, because they know they don't have proof. They don't have medical proof. We heard testimony about allergies. We heard about all of that. So, I mean, there's innocent explanations for everything that happened on the 14th, every single thing. So that doesn't lead to a reasonable belief. They are 100% relying on an action in conformity argument.
I don't think we heard the admissible testimony of allergies, but I take your point.
Okay. I'm sorry. I'm trying really hard
That's
to
okay.
separate it in my brain.
I understand.
I actually think it's included in the, I believe it's included in some of the exhibits,
Okay.
but we'll just leave it alone just in case I'm wrong about that. I can check that while he's back up. But having said all of that, you know, the distribution charge that is connected to the attempt charge, if the attempt charge doesn't have probable cause, the distribution charge doesn't have probable
I
cause.
agree.
They both have to go.
May I ask you about the consciousness of guilt argument that the state makes?
Yes.
Which I understand to be my words, not the state's. Why is she lying in her text message to her best friend in June about what happened on the 14th?
I think the only thing she got wrong was breakfast or lunch.
Well, I think her location about her being home all day is one of the things they lean on. We were working from home that day. And
I mean, that's easily provable. So it's not like when she's talking to her friend, she's trying to remember the day back, you know, a few months later. And she got part of it right. I mean, and part of it wrong. And I just don't know if it's just, I mean, how do we know that, what purpose would that be? How would that serve as a lie?
well, the argument is that she's hiding the fact that she was with another person besides her husband on that day.
Okay, that's a good reason to lie. Because you're with your boyfriend. And you don't want to admit you're with your boyfriend.
Right.
I mean, that's not conscious of guilt of killing your husband. That's not wanting to tell people you were hanging out with your boyfriend.
Okay. That's one credible inference, right?
Yes.
All right. Would you say that it's not a credible inference that the reason she's lying to her friend is because she had the scheme to be not present?
But she admitted she was present with him, and she was. She brought him breakfast.
Okay.
So that's true. That inculpates her more than exculpates her. That's the opposite of covering herself. She's putting herself in the house with him on the day that they're claiming he was attempted to be poisoned. That's a statement against interest,
Okay.
in my opinion. Okay. So I don't really need to argue the distribution. You get that. All right. So the only other things that we have on the fraud type arguments, I do think that the state never established jurisdiction or venue for any of those counts. I don't believe we've heard any proof about why this court has jurisdiction over these acts. They did not establish where they occurred.
Why isn't there a reasonable inference that Kouri Richins was making these applications and forming these schemes from Summit County?
And they have to show that. You can't just out of whole cloth make that up. There's no evidence that occurred.
Well, the standard of proof is the same for every element
Right.
of the crime, right?
But
So
there's no evidence that was submitted.
She lives here. Her business was based here. I think there's a basis for reasonable belief that she was initiating these contacts, forming these schemes from Summit County.
Well, I just want to make the record
Okay.
that I don't believe they've established jurisdiction or venue on any of those counts. Furthermore, on the, I don't see why the two insurance fraud counts don't merge here.
Correct me if I'm wrong. I'm seeing several merger issues in
Yes.
this information, but merger is a fact issue that's handled after conviction. Am I right about that? Not at a preliminary hearing.
Not after conviction, before. You said after conviction? You meant after
Is it before
charge.
submitting it to the jury or after?
Merger?
Yeah.
I always do it as a pretrial motion, but
Okay.
I may be wrong. I may be doing it wrong.
I don't think it gets considered though at a preliminary hearing as a matter of law.
Well, I think if you determine at a preliminary hearing that two counts are actually one act, that you cannot push forward one of them, absolutely, I think you could do that.
Do you
But
have a citation for that? I thought it was the opposite at a preliminary hearing.
well, I think you would just argue that they can't make two separate counts, so there's not sufficient reason to believe that a second crime was committed because it's all one. So that's your finding, that it's a reason You can't reasonably believe the second crime was committed because it's just one crime. Because the scheme swallows the allegation of the filling out of the application. I mean, it swallows it. So
I'll take a look at this.
yeah. And then I think on the rest we would just submit on the other counts, Your Honor.
All right, so let's just be clear. To the extent that merger needs to be considered as part of the probable cause determination, that's going to mean that 1 and 3 merge, right?
Yes.
2 and 4 merge.
No, not 1 and 3. Attempted murder is on a separate day. It wouldn't
1 and
merge.
3, 2 and 4.
I'm sorry, let me look at what 1 and 3 is. I'm getting my numbers mixed up.
So the distribution counts merge into the ag murder and ag attempt, right?
No, those would be 2 separate crimes.
Tell me why. You can't
Because
commit them without doing the distribution, right?
Right. I think they don't merge though. They're separate crimes. Like distribution is a separate offense than the attempted murder.
Okay.
So they wouldn't
then
merge.
Why isn't, on the one hand, forging a signature and then on the other hand, making a false statement when trying to collect on the claim? Why aren't those 2 separate crimes? What is the
Because
merger you're
they're
arguing for?
the 2 insurance fraud charges, because that is the same offense. Insurance fraud is not 2 separate offenses. And what they did is they said she created a scheme to wrongfully get insurance fraud. And part of that scheme was she signed the application and they just charged insurance fraud twice. I'm not talking about the forgery, I'm talking about the 2 insurance fraud charges. I think
Okay.
they merge.
All right.
And
And just to be clear, you think they merge because it is the same fruit of the criminal conduct. That is, there was only one policy.
right. That's correct.
Okay, I understand.
That's correct.
Thank you.
Thank you. Can I just have 1 minute before I sit?
Of course.
Just one more thing, Your Honor. And I guess maybe the last thing I would say too is there's so many reasons that Mr. Richins could have not felt well that day and taken a nap. And to get over the hump of saying you're going to stand trial for attempted aggravated murder, which is about the next to most serious charge you can ever be charged with, because he went to take a nap, is pushing it, Your Honor. We're just asking that the court exercise your gatekeeping function. Let's remove that from the confusion it will cause the jury, the prejudice it will cause the jury, the complete lack of foundation. We're asking that the court take the rarest of steps and say, this one will not go forward. And we submit on that.
Okay, thanks. Thank you. Mr. Blow.
Your Honor, real quick on just the merger issue, it's 2 different policies. Count 7 relates to the, I think, $250,000 true stage policy, and count 8, I think, relates to the $100,000 policy.
That is not the way it is charged. I think that is, you're going to need to amend the information if you want to do that.
I don't want to amend
Frankly, I don't think there's
information.
any allegation of fraud, or there's any, tell me why there's any reasonable belief regarding fraud related to $250,000 policy.
Fraud in the claim, saying that I don't know why Eric Richins.
That's not what she said with respect to the $250,000 claim. That was only with respect to the $100,000 claim. It's 2 separate diaries. This is why I'm asking.
Your Honor, I think
They were paid out at different times.
Sure, in the one diary, though, they discussed both policies.
I don't think that's true. You can show me, but I looked at them carefully yesterday. They
Well,
have
let me ask you
separate
this.
diaries regarding separate policies.
Let me ask you this, sir. Is this an issue you're considering? And if so, I can show it to you, but I don't know that it's a...
I
It's a real
understood
issue here.
you to be saying count 7 is based upon statements made during the process of collecting the proceeds in June. Count 8 is the scheme to get the policy with intent to kill Eric Richins to collect. the statement, Mr. Burmester, of no known drugs, occasional cannabis use?
No, that,
That came out of the medical records.
Your Honor, it's Exhibit 18, page 1. It's the last note.
I see what you're referring to. So this is 1803. Hold on a second. Let's get to the bottom of this. My apologies, I had it backwards. Okay, so, count 7, thank you for this clarification, is with respect to the $250,000 policy. Got it. Thank you for that clarification.
Your Honor, regarding the 404B discussion, the purpose of admitting the evidence is further to many of the exceptions, propensity, intent, preparation, lack of accident, nearly all of them. 404B just relates to whether or not the defendant acts in conformity with her character, whether that's prospectively or retrospectively is irrelevant. The most of the defense's argument against bind over the attempted homicide count, as the court kind of noted, a lot of that goes to the jury. A lot of that was arguing countervailing evidence. As the court is well aware, the standard today is notwithstanding countervailing evidence, whether that's countervailing evidence of how quickly Eric Richins eats his eggs, or whether he goes shopping beforehand or afterhand. It's countervailing evidence. It does not apply to the court's analysis today. Part of that countervailing evidence, I find it ironic that counsel argued we hadn't heard one piece of evidence from Eric Richins. What questions does the court have?
I understand the state's position. I understand you to be saying conduct in March is evidence of other acts admissible to prove an MO. I understand the state's position.
And the lessons learned, I think, is very important.
Sure.
We've had some discussion with defense counsel also as it relates to the standards at issue for the probable cause determination. And I think the court has sufficient evidence when viewed in the light most favorable to the state, when giving the state all the reasonable inferences, notwithstanding the countervailing evidence, to find probable cause here even without the 404B part. The 404B part helps, certainly, but I don't even think it's necessary for the court to get to a probable cause determination. And, Schmidt, in discussing probable cause, references that, probable cause in a preliminary hearing is the same as probable cause for an arrest warrant. And if the state were to set forth all the evidence it has put, referenced in its brief, argued here today, and charge an attempted murder, and ask for an arrest warrant on the information
Or a search warrant.
or a search warrant.
Right.
And if the state submitted it to 100 judges in Utah, 100 of them would issue that warrant.
Check to speculation.
It's an argument. Overruled. I understand the state's point. Okay. It is 11:29. We're going to come back at 11:50. Oh, Ms. Nestor, my apologies.
Very quickly, I checked the ME report. It did reference the fact he was positive for COVID, but
Okay.
it did not talk about allergies in the ME report. That's where I thought it might be. But I'll keep looking and see if I can find it. But I do know that he did test positive for COVID.
Understood. Thank you. 11:50. Court's in recess. Thank you. Are bound over. What's that, Ms. Nestor?
I think you just said 6 and 7 and 7 and 8, and you skipped 5.
My apologies. 5 and 6 are Iron Bridge and Boomerang, respectively. 7 and 8 are the $250,000 two-stage policy, and the scheme related to the $100,000 true stage policy, respectively. 9, 10, and 11 are forgery counts related to the altered America First Credit Union account statement submitted in respect to the Iron Bridge and Boomerang finance loans, and with number 11, the forged signature on the $100,000 true stage life insurance application. Mr. Bloodworth, any clarification?
No, sir, thank you.
Ms. Nestor?
No, sir.
Okay. Let's pause there for a second. Ms. Nestor, Ms. Lewis, I imagine Ms. Richins would like to enter pleas of not guilty to all charges.
Correct, Your Honor.
Does she waive reading of the third amended information?
We waive reading.
All right. The court, Ms. Richins, is entering pleas of not guilty to counts 1 through 11 in the third amended information. Where would you like to go from here?
We'd like to set a trial date, Your Honor.
Have you had a reasonably detailed conversation with the state about numbers of witnesses, length of time? Because I'm going to have some questions.
We have discussed it, and what we have agreed to, I don't know if it works with the court calendar, is we would like to set aside 4 weeks, basically the month of May, to try the case. So we think that would include jury selection. So we figure the jury selection is going to be at least a week and 3 weeks for trial.
Have you given any thought to pre-trial motion practice?
We have. We
Discussions
discussed
regarding jury selection. There's going to be some questions regarding preserving the integrity selection process?
Correct. We've discussed it. We haven't set particular dates for motions, although I believe we thought it would be two rounds of pretrial briefing and motions, and that we need to do scheduling on, or we need to do a scheduling order on those motions and briefs.
Can we start having those conversations regarding pretrial deadlines, maybe a pretrial conference in mid-September?
Yes. We're in trial until September 20th, though, so actually if we could just do
Late
it
September.
after that.
Does that make sense, Mr. Glover?
Yes, sir.
Okay, give me just a moment. Yeah, that's my next question. Counsel, I have a couple of questions here. If you're not prepared to answer these, we can continue this discussion. But first, rather than the entire month of May, can we just say the last week of April, the first 3 weeks of May?
We were a little bit worried because I think Easter's really late this year, and
Memorial Day is included in the day. It's something you're
right.
frying pan into the fire. More to the point, my signing week is the last week of May on Memorial Day. It could be tough for me to trade out of that.
I think we checked this. We were trying to avoid spring
Oh,
break.
excuse me. Hold on a second. I'm in the wrong. Let's try this again. My apologies.
It's okay.
Oh, it is there again. Did I get Memorial Day twice? Is that possible? Hold on a second. I did. We'll review who I pissed off to get that. With two questions. One, that will be hard to trade out of. Two, I need my Fridays.
Right.
We understood that.
I think
Okay.
we took that into consideration when we decided we thought it would take 3 weeks.
Okay.
Before counting jury selection. The only concern we had was about Easter week, that people traveled, and we were trying to avoid losing jurors who might travel over Easter. So that's why we started. I'd almost rather push it to the first week of June and take that day. Is it a week that you do that, whatever it is? Oh, I don't know what that is.
So Easter in 2025 is April 20th. I think we're going to be okay.
Okay, then we could do the last week of April.
So what I'm asking, is
That would work.
April 28th through May 22,
Right.
not including Fridays.
Right.
The idea being that jury selection would be April 28th through May 1. Say it again. Yeah. So then let's talk, I'm gonna have lots of questions about how we're gonna do this. We're gonna have to, we'll have a discussion about whether we're doing half days each of those days for jury selection, whether we're gonna ask jurors to be available the whole day each of those days, whether we'll need to have a discussion about whether we're doing 4 veneries, 1 for each day.
Right. I do anticipate, Your Honor, there will be a lot of individual voir dire based on the.
I imagine. And so we'll want to be thoughtful about how many we ask to come each day.
Right.
I'll need to reserve sufficient resources in terms of people power and jury selection slots. Third district policy is we do this during using the virtual jury selection system. You're going to have to file a motion inside extraordinary circumstances. It's not my decision. Brittany, what do we have going on in the afternoon of September 27th? How many? Yes. 3 p.m. Yeah.
We set 1, 3 p.m. Sure, why.
You know, just do this. Counsel, are you available on the morning of the 26th? Or the 26th before, say, 2 p.m.?
I may be in a trial. Would it be all right if I can't make it, if Miss? Are you trying to?
We might both be in trial.
There's a chance we could be in trial that day. A chance. It's set for a 3-day trial. I'm sorry. It's set for 3 days, and I think it's only going to take 2. It's a trial down in Salt Lake, so we could just tentatively set it if
Okay.
we need us to.
Well,
In the afternoon, better, in case we have to wait on a jury or something.
all right, let's avoid that day. 27th is bad. What's the afternoon about? Christmas.
If we could do it remotely, we could definitely, on the 26th,
In the morning or the afternoon?
in the afternoon would be better. I'm sure the judge would give us, if we need to step out and do take a break.
I've already moved the hearing once, I'm sorry. I can't do it in the afternoon.
Okay.
Bear with me. I'm sure this is like nails on a chalkboard to all of you, I apologize. So, you said something at 3 on the 26th?
We did. It's a theft. It's
What do we have at 1:30? Alright, that's a mess. That's not too bad. What do we have on the 11th? Or the... Yeah. Okay. What about the 25th? Oh, goodness. Okay. Yeah, that's... All right, counsel, the morning of October 22? Nah, can't do that, I'm sorry. My goodness, this is the problem. I'm gonna have to push something out of the way. Ms. Richins, I apologize. I'm thinking about this the wrong way. Ms. Lewis, Ms. Nestor, I think we need to hold an initial pretrial conference to start talking through pretrial deadlines and start talking about jury selection. Tell me when you'd like to do it. I will make room.
30th of September, Monday.
I would unfortunately be out of state that whole week. That I can't fix.
What about October? It's not this whole week.
about the afternoon of the 23rd
Like later,
Of
September. September 23rd, later afternoon, like 3.
We'll make it work. Would you like that to be in person or by WebEx?
Whatever you prefer, we'll probably come up.
I prefer in person.
Yeah,
Is
that's
3 p.m. workable?
Yes, sir.
Okay. Mr. Bloodworth?
Yes, sir.
All right. We'll set a pretrial conference for September 23 at 3 p.m. in person.
Thank you, Your Honor.
Counsel, I need you to start talking to each other about issues you anticipate, pretrial deadlines. I won't be able to see around every corner. I would appreciate your input, given your experience on how you'd like to conduct this. We need to start talking about jury selection. To the extent I'm going to have to ask for special treatment, favors, or to the extent you want to file motions to try and secure an exception from the standard practice in the 3rd District, we need to get rolling. I would prefer that you have notice of how you're going to be taking the jury in this case as early as possible. Okay. Mr. Bloodworth, anything to that?
No, Your Honor, thank you.
Ms. Lewis?
No, Your Honor.
Ms. Nestor?
No, sir, thank you.
Mr. Ramos?
Nothing, Judge. Thank you.
Ms. Richins, I'll see you again on September 23 at 3 p.m. I wish you the best of luck. Court's in recess. Thank you.